ಅಲ್ಲಿ ಮುಂದೆ ಬರ್ತದೆ.
ಬಾ ಇದು ಪೂರ ಡಬ್ಬಿ ವರ್ಷ ಪೂರ ವರ್ಷ ಅದರ ಮೇಲೆ ನೋಡಿ 5 ವರ್ಷ ನಾನು ನೋಡಿದ್ರೆ ಹೇಳ್ಬಿಡ್ತೀನಿ. क्या डाले इसमें? हाइट में फाइल इसमें 31 है क्या? इसमें उधर ऐसा डाल दो, उधर डालो, ऊपर लिख कर दो, तो डालो ऐसा, हो डालने से हाँ 19
साइन करा है और रात को टाइप कराया साइन हुआ मेरा
सीरियल नंबर 19 नहीं हो क्या करा है उसमें
क्या
तो मॉडिफिकेशन कर लें ऑर्डर शीट
करेक्ट है क्या ये क्यों कर रहे हैं अभी इसका टीचिंग के कर रहे थे
नको कुछ नहीं
नहीं बहुत सारे
15 मिनट बात करते हैं अगले साल हम लोग नको कर बोलना है अगले साल भी नको कर बोलना इसमें मुश्किल में हमें जीत पाना वो है हमारे हमारे कसम में ಬರ್ರಿ ಸರ್ ತಪ್ಪ ಬರೀತಾವ ಏನೇನ್ರಿ 30 ಪೋಸ್ಟಿಗೆ ಕೊಡಬಾರ್ದು.
The council is not to do the posting ಅಂದ್ರೆ 1-2 ಮೆನ್ಷನ್ ಮಾಡಿ
ಕೊಡಬಾರ್ದು ಅಂತ ಆಮೇಲೆ ಕೊಡ್ರಿ ನಂಗೆ ಹೌದಿಲ್ರಿ ಬರ್ತಾರೆ ಮೊನ್ನೆ ಏನಾದ್ರು
ಸರ್ ಅರ್ಜೆನ್ಸಿ ಎಲ್ಲ ಬರ್ದಿತ್ತಿದೆ, ಅವ್ರು ಬಂದ್ಮೇಲೆ ಕೊಡೋದಾ ಈಗಲ್ಲ?
हाँ सर, सिस्टम में पैसिव में गए तुम्हें, पैसिव में है तुम्हें, पैसिव में नहीं आना, पैसिव में एक्टिव में आ जाओ. डिस्कनेक्ट करा दो मैं तुमने. हर बार कैसा कर दूं तुम्हें लॉगिन ऐसा? अब एकदम लॉगिन हो जाओ. अब डिस्कनेक्ट करो ना तुम, अब एक बार लॉगिन. अब एक बार लॉगिन हो जाओ, नहीं हुए तुम्हें अभी. नहीं आ रहा. कंप्यूटर सेक्शन कर छोड़ो नहीं, कंप्यूटर सेक्शन को मुदस्सिर नंबर सेंड करो, मुदस्सिर का. हाँ ಅವ್ರಲ್ಲ ನಮ್ಗೆ ಗೊತ್ತಿರೋರು ಅದಕ್ಕೆ ಹಾಕಿದ್ದೆ ನಾನು ಗ್ರೂಪಲ್ಲಿ. ಗೊತ್ತಿಲ್ಲ ನಿಮ್ಮವ್ರು ಯಾರಂತ? ಲಾಕ್ಲ ಸಾಕು ಮಾಡಿಲ್ಲ.
ಸರ ಫೈಲ್ ಮಾಡೀನಿ 23 ಫೈಲ್ ಮಾಡೀನಿ. ಒಂದಕ್ಕೆ ಸ್ಕೂಟ್ನಿ ಆಗೈತಿ, ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಬಂದೈತಿ, ಬರಕ್ ಹೋಲ್ದಲ್ರಿ ಪೋಸ್ಟ್ ಮಾಡಕ್ ಹೋಲ್ರಿ. 23ಕ್ಕೆ ಫೈಲ್ ಆಗೈತಿ ಜನವರಿಗೆ. ಸ್ಕೂಟ್ನಿ ಮಾಡಿಸೀನಿ, ಎಲ್ಲ ಆಗೈತಿ, ಪೋಸ್ಟ್ ಆಗಲ್ದು. ಈಗ ಡೇಟ್ ಐತಿ ನಮ್ಗೆ, ಏನ್ ಮಾಡ್ಬೇಕು?
ಅಲ್ಲ ಇದು ಇರ್ಬೇಕಲ್ಲ, ಏನು
ಎಲ್ಲ ಕಂಪ್ಲೈ ಮಾಡ್ಯಾರ. ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಆಗೈತಿ, ಕ್ಲರ್ಕ್ ಹೇಳಿದೆ ಪೋಸ್ಟ್ ಮಾಡಕ್ ಮೆಮೊ ಬೇಕ್ರಿ ಅಂತಾರ. ಪೋಸ್ಟ್ ಮಾಡೋಣ
ಮೆಮೊ ಬೇಕಾಗಿಲ್ಲ.
ಈಗ ನೋಡ್ರಿ, ಈಗ ಐತಿ
ಫ್ರೆಶ್ ಮಾಡಿದ್ರೆ ಮೆಮೊ ಬೇಕಾಗಿಲ್ಲ.
ಈಗ ಐತಿ ನೋಡ್ರಿ, ಈಗ ಅವ್ರ ಮೆಮೊ ಅಂತ ಲಿಸ್ಟ್ ಮಾಡಿಲ್ಲ ನಿನ್ನೆ. ಬೇಕಾದ್ರೆ ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ನಾಗ ನೋಡ್ರಿ, ಬೇಕಾದ್ರೆ
ಹೇಳ್ತೇನೆ, ಬೇಕಾದ್ರೆ ನಂಬರ್ ಕೊಡಿ ಅವ್ರಿಗೆ.
ಹೇಳ್ರಿ, ಈ ನಂಬರ್ ಇದೆ ತಗೊಳ್ರಿ.
ಬೇಡ ಚೀಟ್ಯಾಗ ಬರೋದು ಕೊಡಿ,
ನಂಬರ್ ಚೀಟಿ ಕೊಡ್ರಿ. ಮುಗಿದೋತು, ಎಲ್ಲಿದೆ ಮೆಮೊ ಇವು ಎಲ್ಲ ಬೇಡ ಬೇಡತ್ರ ನೋಡ್ರಿ. ಸ್ಕೂಟಿ ಮಾಡಿದ ಎಲ್ಲ ಐತಿ, ಬೋರ್ಡ್ ಬ್ರಾಂಚಿಗೆ ತಂದ ನಾವು ನೀನು ಕ್ಲರ್ಕ್.
ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ನಾಗ ಇರುದಿಲ್ಲ ನಿಮ್ ಕ್ಲರ್ಕ್, ಏನ್ರ ಹೇಳ ನೋಡ್ರಿ.
ಇಲ್ಲ, ಹಂಗೆ ಹೇಳಿದ್ರೆ ನಾನು ಕೈ ತಗೊಂತಾರೆ ಬಿಡಿ.
ಮೇಡಮ್ ನಮ್ ಕೋರ್ಟ್ ಲೇಟ್ ಅಂದು ಎಲ್ಲರೂ ಬರೋದು ಲೇಟ್ ಬರಕ್ಕೆ.
ಸರಿ ಸರ್.
ಮ್ಯಾಮ್ ಅಲ್ಲಿ ಹೊಸದ ಅದು
ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಿ ಸರ್. ನಂದು ಎವಿಡೆನ್ಸಿ ಪೋಸ್ಟ್ ಆಗೈತೆ ಅದು.
ಆಯ್ತು,
ಇದನ್ನ ಮಾಡಿ ಸರ್.
ವೆರಿಫೈಡ್ ಅಂತ ಹೇಳ್ತೀನಿ.
ವೆರಿಫೈ ಮಾಡಿ.
ವೆರಿಫೈಡ್ ಅಂಡ್ ಪುಟ್ ಅಪ್. ನಗತಿರಲ್ರಿ, ನೋಡು ಏನ್ ಮಾಡ್ತಾರ, ಸಂಭಾಳಿಸ್ಬೋದು. ಮೇಡಮ್ ಏನು ಅರ್ಜೆನ್ಸಿ? ವೋಟಿಂಗ್ ಸ್ಟೇ ಹೇಳಿ, ಅರ್ಜೆನ್ಸಿ ಹೇಳಿ ಮೇಡಮ್. ಆಮೇಲೆ ನಿಮ್ಗೆ ಇದ್ರಲ್ಲಿ ನೋಟ್ ಬರೀಬೇಕು, ಅರ್ಜೆನ್ಸಿ ಏನು.
ಸಾಹೇಬ್ರ, ಒಂದು ಡಿವಿಷನ್ ಬೆಂಚಿಂದ ರಿಮ್ಯಾಂಡ್ ಆಗಿ ಬಂದೈತಿ. ರಿಮ್ಯಾಂಡ್ ಆಗೈತಿ, ಇನ್ನೂ ಲಿಸ್ಟ್ ಆಗ್ಬಲ್ದು ಅದು. 17-12 ರಿಮ್ಯಾಂಡ್. ಅಲ್ಲ, ಇದು ಬೇರೆ. 17-12 ರಿಮ್ಯಾಂಡ್ ಆಗೈತಿ. ಇದು ಸ್ಯಾನ್ ಟೆಂಡರ್ ಅಂದ್ರೆ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಆರ್ಡರ್ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿ ರೀಕನ್ಸಿಡರೇಷನ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳಿ ಫ್ರೆಶ್ ಡಿಸ್ಪೋಸಲ್ ಮಾಡ್ರಿ. ಬಟ್ ಸ್ಟೇಟ್ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಪಾರ್ಟಿ ನಮ್ದು ಟೆಂಡರ್ ಸ್ಟೇ ಮಾಡಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಸ್ಯಾನ್ ಟೆಂಡರ್ ಸ್ಟೇ ಮಾಡಿಸಿ ಅವ್ರ ಪಿಟಿಷನ್ ಅಲೋ ಆಯ್ತು. ಅಲೋ ಆಗಿ ರಿಟ್ ಅಪೀಲ್ ಹಾಕಿದ್ರು. ಯಾರಂದ್ರೆ ನಾನ್ ಪಾರ್ಟೀಸ್ ಅಂದ್ರೆ ಸಕ್ಸಸ್ಫುಲ್ ಬಿಡ್ಡರ್ಸ್. ಅವರು 16 ಸಾವಿರ ಪೇರ್ ಆದ್ರು. ಅದ್ರಾಗ ಅದು ರಿಟ್ ಡಿವಿಷನ್ ಬೆಂಚಾಗ ರಿಟ್ ಅಪೀಲಲ್ಲಿ ರಿಮೈಂಡ್ ಆಯ್ತು ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿ ಟು ಹಿಯರ್ ದ ಅದರ್ ಪಾರ್ಟೀಸ್ ಆಲ್ಸೋ ಅಂತ ಅಂದ್ರೆ ಸಕ್ಸಸ್ಫುಲ್ ಬಿಡ್ಡರ್ಸ್ಗೆ ಅವ್ರನ್ನ ಹಿಯರ್ ಮಾಡಿ ಆರ್ಡರ್ ಮಾಡ್ರ ಅಂತ.
24
24 ಇಲ್ಲ ಮೇಡಮ್ ಅಂದ್ರಲ್ಲ, 23, 24 ಇಲ್ಲ.
24
ಇದಾರ ಆಯ್ತಾ? 24, 23 ಇಲ್ಲ.
ಟ್ಯೂಸ್ಡೇ ಹೇಳಿ ಆಕ್ಷನ್ ಇನ್ನಿದು
ಟ್ಯೂಸ್ಡೇ ಹಾಕ್ಯಾರ
74 ನಿನ್ನಿದು
ಟ್ಯೂಸ್ಡೇ ಕೊಟ್ರ
74 ಸರ್ ಪಾಸ್ವರ್ ಆಗಿತ್ತು ಅದು ಆಫೀಸರ್ ಅಬ್ಜೆಕ್ಷನ್
ರೌಡಿ ಶೀಟ್. ಆಯ್ತು
ಹೇಳಿದ್ರು ಅವ್ರಿಗೆ ಕೇಳಿದ್ರ ಅಂತ ಹೇಳಿದೆ ಲೇಜಿಯ ಬಂದಿದ್ರು ಸರ್ ಅಂತ. ಡಿಸ್ಪೋಸಲ್ಗೋಸ್ಕರ ಕೊಡುದು.
ಈಗ ಕೊಡ್ಬೇಕು
ಇಲ್ಲ ಇಲ್ಲ
ಇದು ಸ್ಯಾಟರ್ಡೇ ಡೇಟ್ ಐತಿ, ಅದಕ್ಕೆ ಸ್ವಲ್ಪ ನನಗೆ ನಾಳೆ ಕೊಟ್ಟರೆ ಚಲೋ. ನಾಳೆ ಕೊಟ್ಟು ನಾನು ಸ್ಯಾಟರ್ಡೇ ಐತಿ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಕೊಂಡು ಕೊಡ್ತಾರೆ CPC ಮ್ಯಾಟ್ರ್.
ಬರ್ರಿ ಮತ್ತೆ ಫೈಲ್ ಕೊಟ್ಟಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಾರೆ
ಸ್ಯಾಟರ್ಡೇ
ಬರ್ರಿ
ಫಾರ್ ಡಿಸ್ಮಿಸಲ್. ಇದು ಇನ್ನೊಂದು ಇದು ಏನೈತಿ ಫಾರ್ ಡಿಸ್ಪೊಸಿಷನ್ ಐತಿ, 2 ಬರ್ದೀನಿ.
ಬರ್ರಿ ಅಲ್ಲಿ ಹೆಂಗೆ ನೋಡೋದಲ್ಲ ನಾಳೆ ನಾಡೋದು ಇರಲ್ಲ ಮೇಡಮ್.
ನಾಳೆ ಇರಲ್ಲ ಹಂಗಾರೆ ಮಂಡೇ ಬರ್ತಾಗಿತ್ತು ಅದಲ್ಲ, ಮಂಡೇನೂ ಇರಲ್ಲ. ಅಂದ್ರೆ ಏನಾಗಂದ್ರೆ ಇರಲ್ಲ ಅಂತಿಕೊಂಡು ಹಂಗೇನೈತೆ ಮಂಡೇ ಇರ್ತಾರಲ್ಲ ಮಂಡೇ ಡೌಟ. ಏನಂದ್ರೆ ಫ್ರೆಶ್ ಇಲ್ಲ ಹೇಳ್ಬೇಕಷ್ಟೇ. ಈಗ ಹೋದ ಹೋಟೆಲ್ ನಂಬರ್ 7 ಹೋಗ್ತೀವಲ್ಲ
ನಾಳೆ ಇರ್ತಾರ. ಅರ್ಜೆನ್ಸಿ ಮೆಮೊ ಇದ್ರೆ ಏನ್ ಮಾಡೋದು? ಸಿಟ್ಟಿಂಗ್ ಇದೆ, ಟುಮಾರೋ ಸಿಟ್ಟಿಂಗ್ ಇದೆ. 21, 22, 23, 24. ಟ್ಯೂಸ್ಡೇ ಭಾಳ ಕೊಟ್ಬಿಟ್ಟಿದೆ ಇಲ್ಲ ಅಂತ 3 days. ಐತ್ರಿ 22 ಕೊಡ್ರಲ್ಲ ಸರ್. 25 ಒಂದು ಇರುತ್ತೆ. ಯಾಕ್ರಿ 25 ಫೈಲ್ ಅಂದ್ರೆ ಇರುತ್ತೆ. ಅವ್ರು ಯಾವಾಗ 23 ಬಂದಾರಲ್ಲ
Please, my lord, here in this case, for consideration of the interim prayer, there was an order of interim prayer, my lord.
There was a,
There was an order of interim stay for further proceedings in the suit, and it was not continued on the last.
no, that's what I'm saying. Wherever the reasons are mentioned, they are listed today. So please give it to the court officer.
Specific date is not given, that I will not.
Huh?
If the specific date is not given, the office is.
No, if you write the reason, it will come. That's what I'm saying. Yes.
Milords, one matter for today at 2:30, Milord. Milords, urgency is tomorrow is petitioner's marriage, Milords. So kindly, Milords, 2:30, it may be taken at 2:30, Milords.
What is urgency?
Milords, Milords, tomorrow,
Petition's marriage is tomorrow. What is
yeah,
happening?
because externment order is there, Milords. Yeah,
When was the externment order is passed?
Milords, in the end of January, I had filed it in the February first week, Milords, but actually this matter had to be listed. It got late, Milords. I had complied it early also, so it got late, Milords.
But one thing I'm telling.
Yes, yes.
For the reason of marriage, I will not stay the externment order if there is no point in that. 2:30, take it.
Please, please. Great.
My lord, one writ petition at 2:30, my lord. The petitioner preferred writ petition. Prior, there was a writ petition. The mandamus was issued, and there was a status quo for the writ petition. After, even though there is a status quo, the work board has issued formed the ad hoc committee and issued the endorsement to the petitioner to hand over the possession, my lord. It may be taken at 2.
When was it ordered?
Yesterday, my lord.
We will do, we'll see. You file it, it will come tomorrow, we'll see. No, 2:30. Yes.
My lord, tomorrow,
Tomorrow it will come. If it is a fresh matter, it will come tomorrow.
the possession has, it has been
We'll see,
taken.
nothing will happen. Tomorrow.
Lordship, one submission, your lordship.
Sir.
State is preferring the appeal, your lordship, writ petition, your lordship, challenging the labor court order, wherein labor court has directed to pay the 4 lakh rupees gratuity amount to the respondent, your lordship. But we have paid 2 lakhs rupees, your lordship. At the time of passing the order, they have stated if amount is not paid,
Same thing will apply to the state also. All
Please.
the memos should be given to the court officer mentioning the urgency.
Put
Be
memo.
considered and listed.
Memos put it. Posting memo.
Give to the court officer, don't mention. Write the urgency, whatever it is, give it to the court officer. Yesterday's matter, I told you specifically to call the AAG. Why was he not called till the court was rising?
He held up in portal number 7.
Huh?
He was held up in portal number 7. Immediately he has come.
When did he come? I told you at around 3 o'clock, till 4:45 he didn't come. 3 to 4:45, is he arguing before court number 7?
He was held up, and in
Well,
fact,
call him now, call him right now.
Milords, I beg your
What happened to that matter? No, let it come tomorrow. Take the number and post it tomorrow.
My lord.
Milords, may I? Milords, beg your lordship's pardon. Milords, I beg your lordship's pardon. Matter pertains to tender matter,
What are
Milords.
you mentioning that you tell?
Milords, since matter was listed on Monday, Milords, that day honorable court sitting was not there, Milords, and they have it tomorrow, Milords. Since interim order, we are,
You can write it on that and give it to
Yes,
the
please,
court
Milords.
officers. We'll consider it.
please.
Kudi, kudi. Yes.
Put it. Posting memo. Page wise adjournments. List number 1, page number 1, serial number 1 to 3. Page number 2, serial number 4 to 11. Page number
Lordships, serial number 5, my lords.
5.
Happy for the petitioner. The advocate and recorder has some inconvenience. May I request it on the
This
next
matter in the month of March.
Shekhar,
March.
Next.
please.
Page number 3, serial number 12 to 17. Page number 4, 18 to 23. Page number 5, serial number 24 to 30. From admission. Page number 17, 59. Page number 18,
My lord,
60 to
My lords, serial number 59, my lords. I am for respondent number 2, my lords. I pray for short accommodation, my lords. I informed petitioner advocate, my lords.
Who has moved the memo? And what
Sir has
memo
moved the
is
memo.
moved? Why did the memo?
I have informed the
Take over
petitioner
this
advocate,
file.
my lord.
Why memo is given for this case? We'll see later. When 59 comes, we'll show this, why the memo is given for a 24 matter. Yes, next.
Please.
Page number 18, serial number 60 to 65. Page number 19, 66 to 69. Page number 20, 70 to 76.
Yes. Have you informed the other side? This is matter in the month of March. This next. This interim order is extended. Next.
Page number 21, 77 to 81.
78, my lord. On record council, mother expired last week, my lord.
This is the month of March. The records of land council petitioner. If any interim order is there, extend. Yes. Yes.
Page number 22, 80 to 83. Page number 23, 88.
Serial number 31, matter become infructuous.
30.
31, madam.
You appear for?
I am for the petitioner.
M.H. Patil. Vivek Mehta.
31. Then council appearing for the petition, subject to the matter has become infructuous. Dismissed as infructuous. Yes.
My lord, serial number 86.
Huh?
Serial number 86.
Huh.
Appearing for petitioner, my lord. So, third matter, my lord, due to some medical emergency taken on Monday, my lord.
86.
86.
Release from part third. This is the month of March.
Please.
Yes, Mr. AAG. When I called
my
him, when I
lord.
said that AAG come at 3 o'clock, 4:45.
I was there in the court till 3:15, my lord, in this court. After that, I went to argue the batch matter, my lord. I came this before
Yesterday,
4:40.
when an order is passed,
Yes, my lord,
why
granted.
is that so?
Yes, my lord. I'm after the my lord's order, my lord, I communicated to chief secretary and everybody, my lord, including discuss with the secretaries, my lord. The officers are not forwarding any compliance report and finding very difficult, my lord, with the order passed with the honorable court.
Shall I issue warrant issue a warrant so that that person shall be brought before the court? When there is an order, what is this in a constitutional court?
Yes,
this is a
madam.
kind of
No,
law.
I'm not in a position.
You.
Madam, I'm not in a position to justify their action, madam. Even I'm.
Please, Advocate General, ask Advocate General to appear online.
Please.
We'll find out from the Advocate General what is happening in the state. This is a respect. This is a respect.
No,
is
no,
given to the court.
No.
What kind of administration is happening in the state? The court can understand.
No. It should not be, madam. At any cost, at least before this honorable. Yes,
Very
madam.
strange.
It should not be happen, madam. It's all our mistake, madam. It should not be happen, madam.
Ask the Advocate General to ask him to appear online.
Please.
And tell the court what is happening and what he expects the court to do. Let me find out from the Advocate General. Ask him to appear
Please.
online.
Mayor, 2:30,
And,
madam.
which is the department?
The police department, I think.
Where is we'll ask the Home Secretary, the Principal Secretary Home to come to the court? Or he also requires a warrant to come to the court? And
Yes,
what for
No,
the
it should
courts? If this is what is the assistance from the advocates, and this is the respect the officers have towards the court.
No. It should not be, madam. At any cost, it should not.
I feel, I'm telling you very frankly, court orders are taken very lightly.
Yes.
Very lightly, either from the government, from the advocates appearing before the court, and also the officers. No seriousness, absolutely no seriousness. And why are we doing all this?
No. It should not be, madam. It is our duty.
Nothing but a mockery.
Yes, it is our duty, my lord. We should assist this.
Ask,
court,
I want
Please,
the
please.
Advocate General to appear online.
Please.
Ask him to come immediately.
Please.
Yes.
My lords, my submission, my lord. Serial number 36. 36, my lord. I am appearing for respondent and I have also filed one writ petition. Both may kindly be connected and.
Along with so and so.
Please.
Yes, next.
I'm for the petitioner in that matter. Date may be.
Huh?
I'm for the petitioner in that matter.
List on 9th of March.
Please.
Call the list.
List number 1, preliminary hearing matter, serial number 1, J. Shetty. J. Kumar.
I'm appearing for the
I'll file the statement
petition.
of objections, my lord.
ಹಾಕಿದ್ದೀರಾ?
We'll file. We'll ಹಾಕಿಲ್ಲ.
Who has moved the memo?
I am,
Why?
some urgency is that, my lord, by virtue of the order passed by, now they are trying to interfere, that's why.
They're trying to?
Interfere in possession.
By virtue of which order?
The earlier order which has been impugned order.
Passed in the year 24.
Yes.
And you don't have a stay till now. And the matter has to come in the list.
They are now, my lord, trying, that's why, my lord.
What are you doing without obtaining a stay from 2024? There should be some rationale on the part of the advocates also to make mention for these kind of matters.
Some urgency is that, my lord, they are disturbing our possession, my lord, in fact, that's why.
You don't pursue the matter from 2024,
But
no
we are-
stay in that.
It was,
And
my
for a
lord,
2024 matter, now suddenly in 26, now you got the urgency. Yes, argue?
yes. My lord, the annexure A is the order, my lord, which the matter has been settled, my lord, it's stated to have been settled before, my lord, the
What is
local.
this alleged to have been passed by Lok Adalat?
My lord, in fact, it is stated that, my lord, the Lok Adalat has passed the order. On the
No,
same
I'm
day,
not able to understand what is this alleged.
my lord,
You don't believe that it is passed by Lok Adalat?
in fact, my lord, the compromise petition, my lord, is said to have been made before the court. It was referred to the Lok Adalat. There it was recorded. In
That
fact,
is an order,
this-
not an alleged order.
my lord, in fact, that is the, my lord, the procedure required to be followed in such a
Read
case.
the order.
But in fact, page number 20, my lord, is the order. ಪ್ರಕರಣವನ್ನು ಜನತಾ ನ್ಯಾಯಾಲಯದ ಎದುರು ಕರೆಯಲಾಗಿದೆ.
Where is the translation to this?
It's not.
Without filing the translation, when you understand that the court cannot, read Kannada, and without filing the translated copy, you move a memo and the matter has to be listed. This is matter in the month of March.
With kind permission.
This next.
With kind permission. The Advocate General will log in at 2:30, my lord. He's on lugs before Supreme Court, my lord. 2:30 will,
Yes.
please.
Seal number 2, Shiva Shuru.
I undertake to appear on behalf of respondent number 2. Name of the name of the Gayatri sir may kindly be deleted.
Yes.
My lord, it appears that, my lord, yesterday they
Yeah.
have made a part payment.
2 days
it
back, my
appears.
lord, some part payment has been made. My lords,
And
to verify,
taken-
my lords, and for further developments, my lords, request.
Petition about.
And, there is a try,
Who moved the memo?
I have moved the memo.
Why?
My lord, since there is a pending payment from last almost 7 months, my lord, I have completed a tripartite project. My lord. In terms of that, my lord, they are supposed to pay, release the amount.
We'll pass the order now. Please come to the prayer. What is that you're seeking?
My lord, I have 2 prayers, my lord, at page 47, 46 and 47.
Issue a writ of mandamus directing respondent number 2 to release an amount of rupees 98
98
lakhs due to petition in terms of the tripartite agreement. Who is the respondent?
Respondent number 2 here.
Respondent number 2, my lord.
Mines Department. National Mines Mineral Department.
Who has determined this amount? Where from?
But there is
where
a-
do you get this amount?
There is a tripartite agreement. My lord.
Let's see, where is that? Have you given any representation to the
51.
respondent to pay the amount to you?
My lord, actually, council is engaged, my lord. Kindly after 2:30, my lord, my council will engage in.
Let the council come.
Please.
And any matter, a memo is moved, and if you don't argue,
Please.
I will dismiss the writ petition on that ground.
Please.
Yes, next.
My request on next week, my lords, any date may fix it. Next week, any date may fix it, so that I can file a counter, my lords.
Come at 2:30, whether the counter is required or not, I'll see.
Please.
Yes, there is.
Pass.
Please, my lords.
Seal number
My lords, petitioner is a mentally disabled daughter of a KPTCL employee, my lord. The petition is filed seeking family pension for the petitioner, my lord. My lords may come to annexure A, my lord. It is the family pension certificate of the petitioner's father. Subsequent to that, representation have
Respondents to sanction and release family pension in favor of the petitioner through her lawful guardian.
petitioner is mentally disabled.
Act upon the representation dated 39/2024. Who are you?
Daughter of KPTCL employee, my lord. My father was employee of second respondent KPTCL. I am the disabled daughter, mentally disabled daughter. I am seeking family pension, my lord. Since I was dependent,
Other family members.
2 sisters are alive, my lord. My elder sisters are alive.
As per the register, whose names are reflected in the register?
I will just narrate the facts. The father of the petitioner was an ex-employee of HESCOM. After attaining age of superannuation, he retired from service. The pension was fixed in his name. Afterwards, he died. After that, the wife was given the family pension. It appears she also passed away. The petitioner, he claims to be the mentally disabled daughter. She makes an application for grant of family pension. I made an inquiry with the officials. The representation as produced along with the writ petition is not available with the corporation. So let him give another representation. If it is available in terms of law, if it is available, we'll grant it.
Yes, what you do is, anyhow, it is there, papers are served on you.
Yes,
You forward it to them. I'll say this representation to be considered.
My lords,
that can be done.
there are some rules which are applicable in this. May I produce them?
No, it's for them to consider. If they don't
Rules are
consider,
clear that I am included in the family pension. That is rule number 9, my lord.
Karnataka government servants, which employee is he?
HESCOM. That rules is, we are having our separate rules. KCSR rules are not applicable to us.
The present writ petition is filed, seeking the following prayer. It is a case of the petitioner that the petitioner is a mentally disabled daughter of Sri Basappa Lingappa Padnur, who served as a lineman under the third respondent, HESCOM, at Bailwongal. After retirement, the father of the petitioner was receiving the family pension from the second respondent. After his demise on 30/10/2013, he left behind. He was behind his wife and 3 daughters. The family pension was then sanctioned in favor of the wife, that is the mother of the petitioner. She died on 8/5/2021. It is a case of the petitioner that the physically challenged daughter and the entitlement to the family pension devolved upon the petitioner as a mentally disabled dependent daughter. As she suffers from permanent mental or intellectual disability and has no independent means of livelihood, she is entirely dependent on her lawful guardian for sustenance and care. She made repeated representations requesting sanction of the pension, and the latest representation is dated 39/2024. It is submitted that the petitioner is not in a position to maintain herself, and the court ought to have considered the case of the petitioner for sanction, and he has relied on the Karnataka government servants within brackets family pension rules 1964, and as per that, the petitioner is entitled. Then counsel appearing for respondents number.
Respondent number 3 minutes.
Then counsel appearing for the Hubli electricity supply. Then counsel appearing for the third respondent submits that the representation as stated to have been given to the respondents is not available with them. If a representation is given, whether the petitioner is entitled for the family pension, the same would be considered by the respondents in accordance with the rules. It is submitted that the rules which the petitioner is relying upon do not apply to the respondent HESCOM, and they have their own separate set of rules, and basing on that, they will take appropriate action on the representation. Next, having heard so and so, it is a contention of the petitioner that she is entitled for family pension after the demise of the mother, and in that regard, already a representation is given to the respondent. According to the land counsel for the respondent, the said representation is not given, or it is not with them. The writ petition, along with the writ petition, the copy of the representation is placed. The land counsel appearing for the third respondent shall forward the same to the respondents, and the respondents shall consider the said representation in accordance with law within a period of 4 weeks from the date of receipt of the copy of the order, accordingly disposed of.
Grateful.
Serial number 4. Suraj Parole, AGA, Deepak S. Kulkarni.
Please, as a petitioner challenging the order passed by Deputy Commissioner, that my lord sir, cancelling the gift deed executed in favor of the petitioner number 1. The dispute has adjudicated by Deputy Commissioner, my lords, is the title in question, right? This is not vested in the purview of the Deputy Commissioner, my lords.
Impugned
The
order
dispute
dated
regarding the title,
11/11/2025 passed by respondent number 2. Who is respondent number 2?
Deputy Commissioner, my lords.
What did he do by virtue of the impugned order?
He set aside the gift deed, my lords, executed in favor of the petitioner. The gift deed, registered gift deed, my lords.
Under the senior citizens.
Senior citizenship.
Let's see the order. Where is the order of the Deputy Commissioner?
68. Page number 68, my lords, annexure K is there, my lord, for the Deputy Commissioner.
My lord, respondent number 5 and 6 seek to file objections. We seek to file objections.
Let's see, it's coming up for admission.
68 page number, my lords, in
Order is
Kannada.
in Kannada, translated.
Translate, please.
The so and so, already you filed wakalat?
Yes.
So the council appearing for respondent number 5 and 6 seeks time for filing objections. This is matter, when do you want?
2 weeks.
This is matter after 2 weeks.
Interim order may extend. Interim order may
Interim order earlier granted is extended.
Please.
Serial number 5 adjourn. Serial number 6. Shadab Hassan Saab, Dharwad.
Yes.
Madam, but in this case, I'm filing the response to the objections filed by these state lords.
Last occasion, my lords, I have filed the objection, saying that he is not a owner of the vehicle. It was standing in the name of some other persons. His statement is recorded, saying that he never transferred the vehicle. My lords, kindly see, I have filed objection on, my lords, 17 February. My lords, his statement at page number 7, translated copy.
Passing the order on IA number 5 dated passed in FDP number. What is this matter?
Wrong file, wrong file.
Seal number 6, my lord.
6.
100267 is what you have given.
10044.
100.
It's my vehicle, my lords.
441.
My vehicle is seized, my lords. I have,
1
yes,
minute.
please, my lords.
Directing respondents to release award damages of rupees 1 lakh.
Please, my lords.
What are the facts of the case?
My lords, what has happened in this case? Now kindly, my lords, come to page number 12, my lords, of my writ petition. I have purchased this Celtos car from the owner through a sale deed, my lords. And today, my lord, I also produced along with my response Annexure D, that is a transfer form that is signed by the original owner, my lords. Right?
Is it not the transfer form? The ownership rights are transferred to you or not?
It's transferred by sale deed also, my lord. I produced sale deed also.
What sale deed?
Lords, because there is no procedure for transferring the inventory, but there is.
Lords, after the transfer.
Lords, why the?
It will be transferred if you sell if you buy the property, buy the car.
Lords, because why the sale deed was executed, there is a existing loan standing in the said vehicle. The owner is assured that I will clear that loan, and thereafter we can get a transfer.
Things which are legally.
That's the reason, my lords. Now, why? Yes, my lords.
But the transfer of if you say you are a owner of the property, the transfer should be in your name.
Please, my lords.
Lords, as on
Now,
today, he is not the owner of the vehicle.
Lords, what I'm submitting before this honorable court that when a property is seized from the police authorities, they have to report that same to the magistrate. Now the criteria for the consideration of whether who is entitled, this is not an ownership, my lords. The person who is entitled is a criteria for release of vehicle, my lords. Now, what has done, the police have done is, my lords, they're not even informed, my lords. My,
Person entitled to, we will consider basing on the records.
please, my
Not
lords,
the sale deed. So show one piece of paper that you are the owner of the property.
lords,
Not the sale deed. There won't be a sale deed for transfer of a vehicle.
there is, my lords, there is no procedure, but my lords, kindly see document today I have produced, my lords, along with my response
Where is that?
at page number 6, my lords.
When is it filed?
Today, my lords, now today I filed that. Let me just put it in.
And even it is not submitted to the officer also. There is no any reference by the officer, page number 6.
Yes.
And another
Now, sir, pardon. Lords, he has executed this form also, my lords. So, my lords, what is the purpose of producing this document for this onward to that? He has also delivered the possession of that vehicle also. When it comes to immovable property, my lords, registration is not required. It can be by way of delivery the possession. And he has executed sale deed plus this transfer form, lords. And the vehicle is seized from my possession, and the same was kept in the respondent's premises for more than 1 year, 1 month, 2 months. What is my prayer before the report? Let the process be filed before the magistrate. The magistrate will decide, my lords. Let the magistrate decide.
First of all, when you are not the registered owner of the property, you have no locus to come before the court. Let the owner come.
My lords, that's the reason I'm telling. Let's the magistrate decide, my lords. Now kindly see the section, the scheme of section 457.
Your locus to come before the court.
Lords,
without being a
even lords,
registered
in
owner of the property.
even many judgments also, the honorable it was held that.
Give one judgment.
Lords, I will give whatever the criteria was that even the banker, the financer were preferred over the.
File the judgment, will see.
Please, my lords, I will file the judgments.
Yes,
Lords,
Mr.
my date me
Next
kindly.
Yes.
Seal number 7. Sridhar Goro.
For the petition, my lord. My lord, the respondent have filed an ABN case and they have filed the execution petition. They filed the ABN case and as well as check bounce case in 2020, my lord. They are claiming both the check amount in a check bounce case also and even in the ABN case, my lord. At annexure H.
Where? Read it.
To quash the proceedings at annexure H, my lord. They have filed an execution petition claiming the award amount in before the ABN case, my lord. I have already paid the check bounce case, my lord. In check bounce case, they are
What are you supposed to do then?
my lord. If I go to ABN court,
To understand the
please.
procedure, how can you come to the high court like this? What you should, if the execution petition is not maintainable in
Please.
view of the money already being satisfied,
Please.
you will tell the executing court that. Why will you come to the high court?
I have filed the objection to the executing court, but they are not accepting.
Then it will hear, given opportunity to the court to hear, give time to the court. If it is not hearing, come to the court, file a petition seeking a mandamus. But you can't come to the high court and say, you quash the proceedings. Is it a 482 jurisdiction?
My lord, they have filed the ABN,
Please come. No.
the civil court has ordered for.
What kind of writ petitions are filed? The present writ petition is filed seeking the following.
Warrant has been issued, my lord. I have filed the object. Warrant has been issued against me in the civil court, my lord. Warrant has been issued against me.
Where did, so what you asked? You asked for the quashing of the proceeding.
Please.
Where is the order?
At annexure A, my lord.
Huh?
Annexure at page number 65.
Question. Where is it questioned before this court? That warrant of arrest.
At page number 65, my lord.
Come to your prayer, Mr. Counsel.
A writ of searcher.
The procedure before the court, how you seek relief, how the court grants relief. Is it the way? You say arrest warrant is issued, stay that. You never question that. You will say quash the execution proceedings. How can the execution proceedings be quashed? There should be an impugned order,
Please.
isn't it? Where is the impugned order?
My lord, at page number 65.
It is not filing the order in the order sheet. You should have, there should be a prayer.
Please, my lord.
Do it.
Please. May kindly be posted on Monday, my lord.
Huh?
My kindly be posted on Monday.
Yes, Monday.
Please. Grateful, my lord.
Seal number 8. Irangoda K. Kabur.
Please, ma'am. My lords, the petition has been filed challenging the order on I number 7, my lords. Filed one under section 151 for depositing the rents of the suit schedule property, my lords. There has been not, the inquiry should be conducted while depositing the, while allowing the IA regarding the mean profits, my lords, according to order 20, rule 12, my lords. But the inquiry has not been conducted and the IA has been allowed, and I have been directed to deposit the rents of the suit schedule property serial number 7. Page number 42, my lords.
Yes.
Only considering the reasons, my lords, in the reasons mentioned in the affidavit, that is, it is the submitted that the suit schedule property being bearing RS number 20, consisting of 6 shops, in which the plaintiff receiving the rent by the tenants, the defendant number 2 to 4 are the being the LRs of the deceased Ramchandra Sondar Plummer, are entitled for 4/8 share over the said property. Accordingly, they are entitled to receive the rent amount, but the plaintiff number 1 is misappropriating the said rent amount. And in the next page, page number 43, the plaintiffs have filed the present suit against the defendant for the relief of partition. It is the contention of the plaintiff that they are having 1/7 share over each suit schedule properties. Though the plaintiffs denied the application averments, but the tenanted premises in the suit schedule item number 7 bearing RS number so and so, measuring 5 acres 5 guntas, is also one of the suit schedule properties. The arrears of the rent, accruing rent, also constitute a part of the suit property.
When councillor agreed with orders passed 9 and the 7, the plaintiff is before this court. It is a case of the plaintiff that by virtue of the gift deed, what is the suit for?
Partition, my lords.
Then why was this property shown? When you say that you are the absolute owner of the property, why this property should come to the plaintiff? Where is the plaintiff?
Page number 25, ma'am.
No, this contention, come to paragraph number 3. The
Please.
plaintiff, by denying application averments, submitted that by virtue of the gift deed, the defendant number 1 gifted the said RS number so and so.
Please.
Since then plaintiff is in position of the same. You are the plaintiff. I can understand it is the case of the defendant.
Please.
You are the plaintiff. You have shown a particular property as a joint family property and you are seeking the partition of the same and seeking 1/7 share. In that case, when you yourself say that it is a joint family property and you are receiving the rents, what is wrong in this order?
My lords, it has been gifted to us, my lords.
If it is gifted to you, you are an absolute owner of the property. Why did you file a suit showing it as a joint family property and sought partition of that? Come prepared Tuesday.
Please.
Yes, Tuesday.
Please. Notice, ma'am.
20.
Notice.
Huh?
Issue notice.
Well, that is sufficient. Notice the respondents.
Seal number 9, Shurajas Parole, CGP.
I undertake to appear on behalf of respondent number 2. After issuance of notice, first time, my lords, the matter is listed. My lords may seek 1 week accommodation to file statement of objection.
No. There are stages. When court has ordered notice at this stage, it is only to get instructions. Objections you can file later. Yes. What is the matter about?
I'm impugning, my lords. Stay is operating against me.
There is a stay.
Yes. There's an intermode.
Why, who moved the memo?
No, not moved. There is a date given matter. After issuance of notice, date is fixed.
100730, court moved. Look at the memo. Who has moved it?
No.
I'm really unhappy the manner in which this.
Because in notice itself, this.
I have not moved it because I have the interim protection, so there's no need for me to move the matter.
Notice itself shows, my lords, matters should be listed on 19th.
It's a date given matter. It's the cause list, my lords.
Only looking at the cause list. Why are they uploading it?
Date given matter.
Everybody, at every stage, no application of mind. That's the whole problem. Yes, intermod earlier granted is extended. This is matter after 2 weeks.
Obliged to.
So and so. Submitter has instructions to file wakalat.
Seal number 10, Santosh Kumar B.
Appear for petitioner. Petitioners challenging the compromise decree before the Lok Adalat.
But the petitioners are the parties to the compromise decree, my lord. The suit, the respondent number herein, sole respondent, my lord, there was a loan transaction. My lord, he entered into an agreement for sale, unregistered and stamped agreement for sale with the petitioners. Thereafter, my lord, he instituted a suit for specific performance. It is at page number, plaint is at page number 11, 10, annexure A. In that suit, my lord, a compromise decree is entered into the present, which is under challenge. In that compromise, my lord, instead of paying the amount to the petitioners are, my lord, illiterate ladies. There are minors also, uneducated ladies. Now, in the agreement, in the compromise decree, what he recites is that at the what he was assured to the petitioners was that at the time of registration of the sale deed, entire remaining consideration would be paid. But in the compromise, what is mentioned is, my lord, the entire property rights in the property is relinquished in favor of the plaintiffs. The translated copy of the compromise, ma'am.
You are represented by an advocate or not?
Yes, I was represented by the advocate.
Then-
I was represented by the advocate.
Then
My lord, petitioners.
You are aware of the, not necessary that every party should be educated.
Yes.
And when a compromise is entered, you are represented by an advocate.
Yes.
And
Yes.
understanding what is a compromise.
Yes.
And when they must have appeared before the court must have asked them what are the contents, have you understood?
Yes.
You understood, and then
Yes.
on these grounds, we
Yes.
cannot, we can't set aside the
No,
compromise.
one contention is, my lord, since the agreement, neither the agreement is registered or stamped, neither the compromise decree is also not registered or stamped.
Party to the compromise.
Yes, I am party to the.
When you are coming up with these, there should be a strong ground than saying, I am illiterate, I am not aware, this happened. Those are not the grounds.
Yes,
What
may
is
I-
the response?
Please.
This next.
Seal number 11.
Please.
Yes.
Filing
What happened?
Filing objections.
Huh?
I am filing objections.
Take that objections.
Objection.
Seeking parole by the petitioner, my lords, came to be rejected on the ground that, my lords, he is agree.
Exercise requires the endorsement of rejection of parole of the petitioner.
Yes.
Who has rejected the parole?
My lords, parole rejected by, my lords, by the respondent number 2, my lords, superintendent of jail.
Respondent number 2.
Yes.
The chief superintendent,
Yes.
central prison.
Respondent number 2 has, my lords, rejected on the grounds of,
Competent authority.
please, my lords. My lords,
Why the act is saying otherwise?
my lords.
The rules are saying otherwise.
Yes, my lords. My lords, the rules are saying otherwise, my lords. In fact, he's a gangster, Bananja Raja. He's having, my lords, history of, my lords, gangster. And there are cases against him, my lords. Kindly see my objection, page number 2. There are number of cases, totally 22 cases, my lords, out of which, my
No
lords,
representation on behalf of the petitioner. The objections were filed on behalf of the state. This is matter for discussion on Friday. Next Friday. Yes, next.
27. Seal number 12. Tal Bormal.
I seek 2 weeks accommodation in the last occasion. My lords had instructed me to get at least undertaking for the Surface Act. I had kept everything ready, my lords. Mother of the petitioner is serious.
This is a matter on Thursday. By the time if the undertaking affidavit is not filed before this court, the petition will be dismissed on the ground.
Please.
Yes, 13.
Seal number 30.
seal number 13. Yesterday, my lords, please to adjourn, my lords, batch matters, 230 matters. It is of similar in nature.
What is this?
Lords, it may kindly be taken on Saturday, my lords. We have,
Give that number, connected number list along with that.
Yesterday, 230 matters. Yesterday, 230 matters.
lords, Saturday it may be posted, my lords.
Saturday not possible. Whenever the other matters are coming, then it will come. Yes,
Let's kindly pass over, my lords. Please,
pass over.
please.
Seal number 14.
This case, respond number 2 to 12 have filed a claim petition before the deputy level commissioner, and they led
Yes. Oh.
they led evidence in all 14 witnesses were examined, my lords. I cross-examined 2 witnesses, and it was closed. Thereafter, I filed an application for permission to seek cross-examination of the other witnesses. That was rejected by the authority below, my lords, on the ground that already I have examined cross-examined two of the witnesses. Same will be the cross-examination for other witnesses also. That is the reason it cannot be permitted the same.
Against an order passed by the Labour Commissioner in an IA, against that writ petition lies.
Yes, my lords. Application is filed for recalling the witnesses under CPC, my lords. 17 rule.
On that order, your lordship, they can file a writ petition, your lordship. Only on the IA, your lordship, just like a CPC, your lordship. GMCPC, this is a LPG, your lordship, labor court order, your lordship, wherein they have filed application.
What is the order of the court? Please come.
Page number 55, my lords. They say that the application is filed for recalling the witnesses, but already two.
If you want to file a translated copy, I'll hear it. If not, I'll post it in the month of March.
I will file translated copy. Will be taken up next week, my lords.
Yes, please.
Still number 50. Madam Patil.
Yes.
Your Lordship, it's a writ of mandamus to direct the respondent to consider the representation dated 31st/12/2025.
You have given representation to whom?
A respondent, no. To
Gram Panchayat officer.
Yes.
Represented by secretary. Which Gram Panchayat is also not mentioned. Who is your senior? Sharath.
Algoda Patil.
And how these repetitions are numbered? How the repetitions are numbered? They don't have any checklist? How can the repetition be straight away filed against Gram Panchayat? Without there is no state as a party. And which Gram Panchayat? Gram Panchayat of so and so? Nothing. What is this repetition? Huh?
I'll make some corrections.
Not amending. These are all the basic things
Yeah, no,
while
so
filing
this
the petition. Huh?
Yes. Yes, yes. So this is only regarding minutes. The RTA was filed minutes.
Whatever it
Yes,
is,
yes, yes.
array of parties have to be at least.
Yes, yes. That I will make.
No, without filing, without making the state as a party, you can't maintain a writ petition.
Yes, yes.
So Panchayat department, you are arguing principal secretary, Panchayat Raj department. So and so, Gram Panchayat, so and so, Gram Panchayat.
Yeah, I'll make
represented by so and so. Gram Panchayat office, order something.
What has happened, my lords? The RTA's minutes, they have
Whatever
given
has happened,
Yes, yes.
this will not change.
Yes, yes, that will not change.
What is the representation given?
Milords, representation is concerned, Milords, the RTA was given, Milords, to sort for some documents, Milords. Though, Milords, they have told us, Milords, they will provide the document. And they have told the fees, Milords. The fees also has been paid, Milords. Now that after 30 days also, Milords, they are not providing the information, Milords.
You have sought that information under the,
RTI, Milords.
when you first have sorted information
Yes, yes.
and the Right to Information Act, what are you supposed to do?
That, Milords, now what has happened, Milords, they have admitted that, Milords, they will provide it.
You have given a representation on the Right to Information Act.
Yes, yes.
Under the Right to Information Act, there is a timeline prescribed.
Yes.
If they don't give it, what you are supposed to do?
Appeal, Milords.
Then why did you come to this?
No, Milords, what has happened, Milords, they have admitted that, Milords, they will provide the documents within the prescribed time, Milords. Yes, that is appealable, is there.
Please come. The writ petition is filed, seeking the following prayer. It is a case of the petitioner that he has given and he has approached the respondent under the Right to Information Act and sought for certain information. It is a grievance of the petitioner that the said information is not furnished and the said representation is not considered. Hence, he has come before this court, so filing a writ petition, seeking a writ of mandamus, directing the respondents to consider the representation. Having heard the counsel for the petitioner, There is a material on record. When an application is filed in the Right to Information Act, if the information is not granted within the time-bound manner, there is a remedy available to the petitioner. He cannot come before this court seeking a writ of mandamus. Accordingly, the petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy.
Obliged.
Bill number 16, BC Dhanaya Swami, Sachidanand.
I'll file an undertaking memo regarding the payment of my lord loan.
Please. What is that undertaking?
This is a surface matter with regards to,
Have you seen the undertaking? What did he say?
my lord, they are stating that they will pay within 4 months, my lords. But if some clarity, my lords, because if they undertake to pay 50% by March 31st, my lord, financial year ends on March 31st so that we can upgrade the account. The balance 50% we can give leniency by another month, my lords, by April 30.
May come up with an affidavit, some amount by March,
By March.
remaining amount
Within-
another 3 months.
Please,
List the matter on Wednesday?
Please.
Wednesday.
Please.
List it on Wednesday. Then counsel for an undertaking, the affidavit is filed.
memo,
The amount-
this is a memo. This is a memo, my lord.
If an affidavit is filed on the party,
That's what-
I'll,
Affidavit is not filed.
this is only an undertaking which is filed.
undertaking memo, my lord.
There should be an affidavit. Undertaking is an undertaking affidavit. What is it? Undertaking memo?
Yes.
The petitioner submits that he'll pay the amount within 4 months. 4 months. Learned counsel appearing for the respondent submits that. A memo is filed. An undertaking affidavit shall be filed. He has to file an affidavit stating and an amount, a part of the amount shall be paid by the financial year, that is by March, and the remaining amount also, it has to be mentioned by what date and month he'll be paying the money. Land counsel, the petitioner submits that he'll file an affidavit of undertaking, list the matter on Wednesday.
And the process of, my lord, the process of,
Until such time, no coercive step shall be taken by the
Please.
respondent.
please.
Bill number 17, Prashant F. Gowda, CBLD.
This case, petitioner is an ethanol manufacturer. And in a similar identical matter, this honorable court has already granted an interim order. Same was challenged before the division bench. And the division bench has already confirmed it. Page 156. Then 156 is the interim order.
150?
That's one submission.
1 minute, let me see what is that he is referring to.
156. It's the order dated 15/12/2025, my lord. And the bottom of the page, my lord, after traversing through the clauses in the agreement, long-term offset agreement, lastly, in the light of the matter would require consideration, therefore there shall be an interim order as present, particularly in the teeth of clause 6.8 quoted supra. And and this order was challenged, and I had filed along with the memo, my lord, separate. Excuse me. Court of-
Take the order,
No, already we have filed, ma'am.
page number.
No, in that separate memo I have got. On 16th, separate memo. 17th.
Oh.
16th. 16th.
This here.
This interim order was challenged by the oil manufacturing company. The division bench. These are the dedicated ethanol plants established as per the policy of the central government.
Yes.
No, sir, against this order, my lord, already the OMCs are on the verge of preferring SLPs before the Honorable Supreme Court of India. Matter may kindly be adjourned after 2 weeks, my lord. It is matter of couple of days.
No, we'll grant the interim order and adjourn the matter because when similarly situated people are having the same relief. Why not the petitioner? Who filing the SLP? Getting
Already-
By filing an SLP, you will not get an interim order. We don't know whether you get or not. If
yes,
you
ma'am.
get, you can question this one.
Already preparative works are over and then on the verge of filing, my lord. That's one submission. Even otherwise, my lord, the factual aspects in the instant case, they vary. He is alleging that the allocation made is lesser. this allocation made, which is made lesser in quantities because, my lord, this particular supplies.
It is not about the facts. It is about the law.
Correct, my lord, but
What did the learned single judge say? We'll see his order.
156, my lord.
What did he say? What
Interim-
was the reason, on what basis he has granted an interim order?
would
That
read.
we will see.
Start from-
Facts is like, the quantity and all won't be same in every matter. Page number?
156. Here also the notice was issued and then after conveying the prayer, my lord, the rights of the parties are governed by the long-term offtake agreement with the dedicated ethanol plant. The relevant clauses of the
Clause
agreement.
6.8 unequivocally mandates that if beyond what is offered in clause number 6.2, the overall annual offtake quantity of a plant is offered by the bidder under the EOI. The additional offtake quantity will be through the preferential allocation in the ethanol procurement process followed by procedure. The same 6.2 also.
Yes, my lord. But here is the case, my lord. This particular, every vendor, he has to specify the quantity of ethanol which he will be supplying quarter wise. My lord, ethanol supply year that commences from November of every year and concludes October the next year. So there are 4 quarters. In the instant case, the petitioner never offered any quantities for the 4th quarter. That is why there is lesser in allocation of the quantity, because allocation is done on.
Understand what is the impugned order?
No, my lord. What has happened is.
He's only seeking for revised allocation.
Revised
That's all.
allocation.
He's only seeking for revised allocation. That's
As
all.
per the agreement, my lord, here clause 6.8 also.
What is impugned in this? First,
No, here I am seeking for a mandamus direction to them in the very same relief what in the earlier petition also which has been sought.
See, what is the relief you're seeking?
But I am seeking a direction to them. That
Representation, then why are we granting an interim order? Why are we granting an interim order?
Because it was granted in the other, it was granted in the earlier case, my lord.
No, not only that, because here what has happened, my lord, I'll tell you. The central government has invited all the investors.
Before you submit on the merits of it, you are seeking a simple prayer of consider the representation.
Please.
Why are we entertaining and passing interim orders?
My lord, what has happened is because what?
We'll allow your writ petition,
There
we'll
are-
ask them to consider.
There are 2 things, my lord. One is as per 6.8, they have to take as per the agreed quantity. Second issue comes is if I am producing excess, then preferential allocations will be given.
Beyond the scope of the writ petition.
No. I'm not.
Thought for a prayer to consider your representation. Why the court is enlarging the scope of the writ petition? You didn't ask anything. You only asked for consideration of representation.
Yes, ma'am, consideration.
In that case, why should the court pass interim order? Why should the court grant you something?
Here, after considering all this court, this honorable court, my lord, what I'm making some, I would fully agree that if my lord allows my petition and direct them to consider within a.
We will ask them to do it.
In the line of the.
We will ask them to do it, not even one word above or below.
Yes, ma'am.
Beyond your prayer. We will
As
allow
per
your
the,
writ petition.
as per the long-term agreement and only one submission in the light of the judgment passed by this honorable court in the writ appeal number. Division bench has gone extensively in all these clauses, my lord.
But why it has, no,
Yes.
I can't do something which is before me, what is there, I can only
Yes,
decide.
ma'am.
And if it is a division bench's order which will bind me, but
Yes, ma'am.
not, there is nothing to bind here.
No,
Because
the very same clauses,
the court has considered some order, interim order passed by a judge in a division bench. Now, what is a writ petition before me?
very
In a
same.
sim- But if it is granted, I can't help it. That is something which is not correct. And I can't comment on that.
No, I
The
am
present
not.
writ petition is filed seeking the following prayer. It is a case of the writ petitioner that petitioner is an integrated sugar factory engaged in the manufacturing of sugar, cogen powder, and has also established a distillery. The petitioner herein has established a dedicated ethanol plant for the manufacturing and supply of the denatured anhydrous ethanol for the purpose of supply to the oil marketing companies. That is the respondent number 2 to 4. It is a grievance of the petitioner that
My lord, even just one submission, my lord, the representation is dated 9/12/2025, my lord. But it is dispatched through postal mode, my lord, on 23rd January, my lord. If my lords, even that way also, my lord, the way he has brought up this writ petition, the representation annexure, annexure E, my lord.
1 minute. The grievance of the petitioner is that the allotment made to the petitioner for years 520, 25, 20, 26 is substantially lower than the quantity of ethanol that will be produced solely from the raw materials, in relation to which agreements have been executed without even taking into account its total annual design capacity, which is considerably higher. Hence, the petitioner has given a representation dated 9/12/2025 to respondent number 2 to 4, seeking inter alia an enhancement in the allocation of quantity of supply of ethanol for years 5, 2025, 2026, pursuant to the tender bearing number 222376 dated 23/9/2025. It is a grievance of the petitioner that no positive action has been taken by the representation by the respondent number 2 to 4, even till today. Hence, the petitioner is constrained to approach this court by filing the writ petition. Learned counsel appearing for which respondent?
2 to 4.
Learned counsel appearing for the respondent 2 to 4 submits that they have received the representation on.
My lord, it was that exact date I do not have, my lord, but it is dated 9/12/2025, dispatched on 23/1/2026.
23?
1/2026 they dispatched the representation dated 9/12/2026.
Oh, it is stated that the representation is dated so and so, but the same was dispatched on
23/1/2026. 23/1/2026.
23/1/2026. And immediately the writ petition is filed. The petitioner has given a representation to the respondents seeking to consider the case of the petitioner. The respondent number 2 to 4 ought to have considered the same in accordance with law, and they cannot keep quiet by just receiving the representation. In that view of the matter, the writ petition is disposed of, directing the respondents to consider the representation dated so and so in accordance with law within a period of 2 weeks.
4 weeks, my lord. Meantime, something.
What will happen for
Yes,
that?
yes, my lord. Yes, my lord.
Within a period of 2 weeks from the date of receipt of the copy of the order.
Number
Only
18.
one word in terms of the long-term agreement with the entered, my lord. In accordance with,
Whatever
accordance
you
with
said,
law, my
that
lord,
they
yes.
will do it. It is not for the court to tell what to do. Yes.
15 my lord. Seek for password my lord is.
Which one?
Serial number 8. Shivasiru.
Yes.
No, the impugn order is at annexure C, my lord.
Annexure?
Annexure C award, my lord, wherein the petitioner has obtained a
In the impugned order bearing number 12/1/2022. Why are you questioning an order of
Lord,
12/1/2022 in 2026?
Your lordship has heard this matter last time. It was the case, my lord, wherein the amount has been recovered under the Negotiable Instrument Act. To this effect, my lord, the criminal court has already decreed in my favor, saying that there is no due is pending. Despite of this, my lord, on the basis of this, they initiated execution proceedings. Your lordship has directed to take a hand summons
Additional
upon.
government advocate shall get specific instructions in this regard.
My lord, the last date, my lord, this matter was heard. In fact, it's the respondent number 1 who has to answer this question because, my lord, he bank, my lord, society. He is the one who has received an amount. In fact, my lord, your lordship has directed to take a hand summons. I have taken, but they did not appear. I have filed a memo to this effect.
No, against the first respondent,
Please.
how can you maintain a writ petition
My lord,
without
rightly, my lord, when there is a fraud,
the action of the government?
please, my lord, there is an alternate no, my lord,
You are aggrieved by the first respondent's.
please.
He is not a state.
He is a cooperative society, my lord, Savarda society, my lord. There is an appeal under section 46
He
before.
cannot only, he can't. That's what I'm saying. If the respondent action, it is in connection with the state, then you will come here.
Please, ma'am.
isn't it?
My difficulty is, my lord, the petitioner is very poor person to the
Difficulty
extent
will
of
not
1 lakh rupees
get
only.
in a writ petition.
Lord, this court can, under
Oh, this
220.
court cannot. That is a
But under
misconception,
wherever-
misnorm that every matter High Court will interfere. High Court has its own restrictions.
Please.
High Court is not a superpower or a superman that he will do anything. High Court
Rightly,
will not
madam,
do
when
it.
there is a-
High Court will only can do as per the powers conferred under the Constitution under 226, 227, not beyond that. Notice to the first respondent.
I have taken already notice, hand summons is served.
Huh? You have
I have-
taken?
Hand summons I have already been served upon him, respond number.
Where is that?
I have filed, on 18 February, I have filed acknowledgement.
Fine.
Please.
As to the order of this court, it is submitted that they have taken the hand summons on the first respondent, which was received on what date?
My lord, 17th, my lord.
On 17 to 2026. Let's just matter next week.
Please.
Number 19. Pachapure, Sangram.
Ashok, may kindly pass over, my lord. Senior is held up.
My lord, I am for the respondent, my lord, and I was directed to produce the records. I am filing a memo along with the records, my lord.
Password. Take it, take that.
My
Serve
lord,
him
may
also.
I request it for tomorrow, my lord? May I request it for tomorrow, my lord? Memo is fine.
He's here. He's here.
My lord, okay.
It's memo they have served, my lords.
Have you seen?
Yes, my lords. There is one order. It's not a transfer order. It's a deputation order. She was there, my lords, as per their own record. As per my instructions, my lords, she was there for 3 months. But as per their annexure, my lords, from 15th November, she was there till September 22 for 11 months. That's the only. Rest of the thing, my lords, they are all appointments in different in the campus only.
No, exactly what did they say? Was appointed as assistant professor and so. She has served in information.
The first document is, my lords, appointment order.
My lord, may I make
Same
some-
appointment. Second is, my lords, regarding promotion. Second document.
Why is somebody from 31/20/12 to 15/11/2021 continuously no transfer for one lady?
No, both of them have worked in the same university, my lord. And it was earlier a constituent college of the same university. And
No. Because there should be a distinction. That is what the court asked. It is
Yes, ma'am.
college, the university campus, and that what is that college?
Constituent college, my lords.
Constituent college.
Sangoli Rayana.
Sangoli Rayana, my lord.
So that when you're saying that she has served as a university main campus, that is what you're referring to. 3/1/2012 to 15/11/2021 continuously without any transfer.
Well, subsequently, my lord, she was transferred on 15/11/2021 till 5/9/2022. Again, she was transferred on 7/11/2022 to 22/2/2023.
So it's it is our deputation is only once.
My lord, apart
This
from that,
lady
my lord, she is also assigned special duties, which are she is heading a coordinator of international relations cell. She is the assistant registrar of internal quality assurance cell. She is the in-charge director of Prasar Ranga of the university, my lord. She is also director of journalism and mass media communication. She is the coordinator of RCU studies chair. All these activities are in the campus. And the petitioner who has been transferred is junior to the other assistant professor, associate professor, my lord. So all those records have been produced. My lord, she is
No, but
also.
prima facie, it appears that there is some kind of discrimination.
No, my lord, as far as
Doesn't matter.
my lord, as
Both are
far as
associate-
Both are same.
my lord, as
both
far
are
as
associate professor.
no, my lord, she is senior to the petitioner.
How much senior she is? When was she appointed?
My lord, I have produced the record also regarding her.
And when are you
Same,
appointed?
same, my lords. It's the same, my lords. Your lordship may take annexure.
2012.
Same resolution, same appointment, same day both have been appointed. My lords, annexure A, your lordship may take, my lords. Your lordship may take reference number 4, my lords. Syndicate resolution dated 25/1/2012. Your The lordship may take notes annexure R1, just suppose notes with the annexure A notes. Syndicate resolution number 26 or appointment order, that is resolution 25 on 2012. Same notes, same day they have been appointed under same resolution by same syndicate resolution number.
My lord,
Lordship
subsequently,
got it,
as far as
page
the
12, my lords.
promotion is concerned, my lord, the promotion is also, I have produced the records to show and with which, with the date on which he has been promoted. And I have also produced the record to show that what all other responsibilities the other associate professor has been given, my lord.
Earlier granted is extended till the next date of hearing. This is matter on next Friday.
Please.
Seal number 20.
Appear for the petitioner board. Appear for the petitioner board. The petitioners are members of the fourth response society registered on this Karnataka society
Let's
registration.
come to your prayer. What is that
Wait.
you're seeking?
Annexure M is the inquiry report. The inquiry was conducted.
Inquiry report dated passed by the
Third is my inquiry officer.
Inquiry officer.
Yes.
After this step.
After this, my lord, they have to, the second respondent has to independently pass an order, my lord.
Under 68.
No, my lord, under section 20, under rule 5 subclass, under rule 8 subclass 5, my lord, of the Karnataka Society Registration Act. This issue has been, my lord, considered this issue. Here, my lord, section rule 20. But here, the page number 5, my lord, page para 5, well, 7.7 is applicable. Once the inquiry is made, it would be for the registrar to apply his independent mind to the inquiry report, either to accept or reject the said report. If the report is rejected, re-inquiry could be also be ordered by the registrar. But this is my lord, the authority required to consider the inquiry report. Now, we have filed an objection to the inquiry report. My lord, the authority has not taken any decision. Therefore, let the second respondent pass an order. But operative portion, my lord, para 7, my lord, order passed by this honorable court, Roman 2, the respondent number 1 shall consider the report of the respondent number 2 in the light of the order passed by this honorable, pass appropriate orders after providing opportunity to all the parties. Here, the inquiry report is there, my lord. The authority has to, second respondent has to take a decision either to accept or reject. We have filed an objection not to accept. Let them consider in accordance with rule 8 subclass 5. Not, I'm
apprehending that he will not consider as per rule showing. Why isn't it a premature petition?
Not, they have not considered.
What was the inquiry report?
Not inquiry report is annexure M, my lord. 18,925, my lord. There is a miss 18,925.
From 18,925 till now, nothing has happened.
No, my lord. Not we have filed in objections requesting not, there is a misappropriation of funds.
The relief you are seeking is to set aside the inquiry.
No, your lordship may dispose of the writ petition, directing the authority to take a decision in accordance with law based on
That is the case. Why should you seek this prayer? If you want that relief, why
Yes.
are you seeking the prayer to set aside the inquiry report?
No, the inquiry report can't be, the second respondent has to take a decision either to accept or reject.
I'm asking about your prayer.
Not prayer we have,
You can't generally ask something and tell the court that do something else. What you want, you should ask.
not, in
The
connect,
relief you are asking, you should have.
my lord, connected writ petition also they sought for quashing of inquiry report. Court said, my lord, inquiry report can't be quashed. Only either to accept or reject, it is a power up to the second respondent, deputy registrar of cooperation.
Has not exercised so far, and there is no cause of action for you to come.
But I request second prayer for mandamus, consider our objection and take decision in accordance with law. But the rule,
There is no mandamus. Look at it.
prayer 2, my lord.
Your mandamus says to reject the inquiry report. Why will this court tell him to reject the inquiry report?
Consider representation and take a decision in accordance with law. All contingencies may be kept open, my lord. But for a moment, my lord, rule relate, I will permit it to read.
Understand the rules. Where did that occasion has come to you to come to this court? He has not done anything affecting your rights. Inquiry report is pending before the registrar. He
Registrar.
will consider it. Why should you come to this court?
But there, he is not taking any steps, my lord. He is keeping,
And if really that is your intention, you would have said, basing on the inquiry report dated so and so, there may be a direction to the respondent, the registrar to consider it and pass appropriate orders. That is not at all the relief you ask before this court. Please, the present date petition is filed, seeking the following relief. It is the case of the petitioner that the fourth respondent is a society registered in the province of the Karnataka. Provisions of the Karnataka Society Registration Act. Main object of the society is to provide better quality of education to the children. It is stated that after coming to know about the illegal acts of the respondent number 5, claiming to be the chairman of the society, and illegal act of the sixth respondent, claiming to be the secretary of the society, by illegally deleting the names of the petitioner from the membership and illegally got enrolled the persons as members, including the sixth respondent, even though she is not even member of the society, and no documents regarding membership enrollment of the new members. The petitioners have made a representation to the second respondent for holding an inquiry under section 25 of the Act. Based on the representation, the second respondent had taken cognizance and appointed retired officer, Department of Cooperation, as an inquiry officer. And the inquiry officer, after following the due procedure, conducted the inquiry and submitted his report on 10/6/2025 by assigning the cogent and valid reasons. Now,
the said report was not set aside by this honorable court wide annexurial page 55, earlier inquiry officer. Then the matter was remanded to the inquiry officer for fresh inquiry.
he submitted that earlier, this court has set aside the inquiry report. On what ground?
Not the opportunity not given to the other candidate.
The earlier inquiry report was set aside and the matter was remanded. Thereafter, the fresh inquiry report, after conducting an inquiry, they have submitted the inquiry report on 8/9/2025. The present petition is filed seeking to set aside to quash the inquiry report. You are the ones who want an action to be initiated against.
But the inquiry is not considered our case. Notice was not served. The inquiry officer says the postal shera shows that incomplete address, therefore notice was not.
Who are you?
But we are the members of the society.
Inquiry is conducted against whom?
Against all of the constitution, financial affairs of against the respondent.
Then why should the inquiry report be set aside?
But
It is not
inquiry report is not, inquiry report says notice was served.
I should dismiss this petition with exemplary cause for seeking such a relief. You at your behest.
No, inquiry report not considered our grievances. This is our contention. Whatever the inquiry report, for a moment, inquiry report, what it says, notice has to be served on the parties in the annual general body meeting. The inquiry officer says incomplete address, return to sender. If the return to sender, the society sender notice, the acknowledgement says return to sender, the notice was sent to society. Therefore, no notice, any proceeding initiated by the respondent is nullity. This is our specific contention. Without notice, constitution of the committee and conducting affairs of.
How many times this inquiry will be conducted? How many times it will be set aside?
No. Earlier, without notice to other group, not the inquiry was conducted. Other group have filed a writ petition for a ground of violation of principles of natural justice. I considered the notice was not served on them. Let them fresh inquiry to be served. When the matter was remanded, then the other group made an allegation that the inquiry officer is not proper colluding with the petitioner herein. Therefore, another inquiry officer has to be appointed. We have said no objection, let them conduct any other inquiry officer. The fresh inquiry officer, without considering our grievances or objections, our specific case is annual general body notice has to be served on the parties. He says notice sent, but the acknowledgement incomplete address returned to sender. The notice sent to the petitioners has returned to the society. Therefore, without any notice, they have constituted a committee which is illegal. And some other persons have been enrolled as a member. Only the amount is there. No resolution, no application. The membership is not approved by the board. This is a finding recorded by the authority. In spite of that, my lord, there is illegality of this inquiry report. Therefore, we will put forth our case to the before the second respondent, not to accept, but take a decision in accordance with law. This is our case.
Thereafter, another report is submitted on 18/9/2025. The present petition is filed to quash the improved inquiry report and also a direction to reject the inquiry report. This court is not able to understand and appreciate the reliefs that are sought before this court. If a report is given to the registrar on 18/9/20, the inquiry officer has submitted a report on 18/9/2025. The registrar will consider the same in accordance with the rules and the provisions of the Cooperative Societies Act.
But Society Registration Act.
As per the
Karnataka Society Registration Act.
But the petitioner has come before this court, seeking this prayer, which is not permissible. In fact, this is a writ petition, which is a premature writ petition. However, considering the fact that the same is pending before the registrar, the writ petition is disposed of as with the following order. Which is the respondent.
Respondent number 2.
Respondent number 2, ma'am.
Respondent number 2 is directed to consider the inquiry report 18/9/2025 in accordance with law.
After hearing the parties, respondent and petitioner.
Accordance with law, that is hearing the parties.
Respondent number 1 and 2, I'll take notice.
Respondent number 1 and 2, HCDP takes notice. For the other respondents, known that this court is not issuing notice, as no adverse orders are passed to this court.
Please.
Number 21.
This case, my lords, I had borrowed a loan from the respondent cooperative bank. From the respondent cooperative bank, I had borrowed the loan. I am a defaulter. I did not pay the amount. Arbitration case took place and arbitration award was also passed. And thereafter, auction took place. The auction successful bidder has bid the property. But my only request is I am ready to pay whatever the amount that is to be whatever the amount that is due by me. If some time is given by the bank, my lords, because that is the only house property I own and I am residing therein, my lords. That is the reason. If the respondent counsel some time is given, I will pay
What
the
time
amount.
it mean? Sometime means what?
Amount is I'll negotiate with the bank if they
Both
can.
of you want whatever you want to do, you will do.
Let's, the first contention, it is not a house property, it is an open space and one complex in it.
So I will
That
not grant
the
any interim order.
petition.
I will not grant any interim order. Whatever he wants to negotiate.
I'll say, if sale confirmation takes place, then my
Not
rights.
even at this stage also, you cannot, the question of, it's a bank.
Oh, the bank, cooperative bank, my lords. Only
No
sale.
reduction is not at all permissible now.
Yes, I agree, my lords, but only if sale confirmation takes place, then I will be having
When
no
you are
right.
in the same position now.
Yes, my lords,
as
I do agree.
The position it would be on the next date or like when the sale is confirmed. The moment sale notice is issued, your right of redemption is gone.
Yes, my lords, but only.
So, no interim order is required.
I want
because
to-
You won't be in a better position than what you are now, even if an interim order is granted.
Only I want to retain property. If some time is given, I will pay the amount, my lords. That is.
Can't be sometime, if really there are any bona fides on your part, by this time you would have come up with an affidavit before this court.
Yeah.
Without an affidavit, I will not consider.
40,
any of the
40,
cases.
40 lakhs is the due amount, my lords. I shall pay 10 lakhs within 4 weeks, my lords. Thereafter, another some time is given, I will pay the amount, my lords.
Nobody is there to give you time. It is for you to tell when are you going to pay.
Within 4 weeks, I will pay the 10
10
part.
lakhs, 40 lakhs is outstanding.
40 lakhs,
Oh,
98,000.
outstanding.
Why should we interfere?
Another, thereafter,
file an undertaking affidavit before this court, not this oral submission. File an undertaking affidavit, not
Please,
memo.
please.
And comes for the petition submits that he is ready to
Tuesday.
clear the entire outstanding dues. In that regard, he'll come up with an undertaking affidavit. List this matter on
24.
next Thursday.
24, Tuesday, my lords. May I request?
Not possible, 25th. List this matter on 25th. He shall serve the copy of the undertaking affidavit in advance on the counsel appearing for the bank so that he'll get instructions in that regard.
Please.
You can get show it to the bank, whatever they say.
Already, my lord, the fourth respondent has become the successful bidder, my lord, that he has paid the amount.
You have not confirmed it.
Not at all.
You have not confirmed the auction.
Not yet.
That's why his rights will come provided you have it is submitted that so and so has become the successful bidder. The same he shall be made a party to this writ petition. By the next date of hearing, the petition shall make the successful bidder as also a party to this writ petition.
Please.
Number 22. Petition Karvi.
My lord, challenge the impugned order, my lord. That is, my lord, I have put the translation copy, my lord.
I'm submitting the synopsis.
Translation copy. My lord, case is, my lords, the petitioner is the impugned order.
Yes.
Petitioner is JD number 2 before the trial court, my lords. Suit for recovery, my lords. Against the JD number 1. JD number 1 has taken the loan of 9 lakh on 2018. Subsequently, my lords, the suit was decreased on 2012, my lords, for amount of 12 lakhs. 12 lakhs, my lords, against the JD number 1.
When was the decree?
Please.
When was the decree?
Decree of 2012, my lords. That is of 12 lakhs, my lords. Subsequently, execution petition.
JDR number?
JD number 1 and 2, 1 and 2. 2 and 3 are surety. I am the 2, JD number 2. I have not taken loan. Loan taken by JD number 1. I am the surety.
You are JDR number 2.
Yes, I am JD number 2. My lord, these petitioners are, my lords, legal heirs of JD number 2. She was died on 21/7/23, my lords. 21/7/23. My lord, subsequently, my lord, they filed the execution petition on 2016, my lord, for claiming 27 lakh, my lords, 19,958. Subsequently, my lords, without making many attachment of the property, they have sought for, my lords, that auction sale on 17/9/22 for amount 15 lakh. Now the worth of that property is, my lord, as per that 60 lakh and SR value is 1 crore 22 lakh, my lords. So subsequently, my lord, that was not complied. Subsequently, they again called one more without complying the order of the CPC. They are again auction on 16/1/23. Subsequently, my lord, kindly press, my lords. Thereafter, the bailiff has given a report that there was no path, no road, then it's not executable. So that's why subsequently, my lord, the trial court has closed the, my lords, 8/1/24, closed the execution petitions. No, God, that is a appeal is pending before the High Court. My lords, that is order 1/3. Please, appeal pending is before the High Court, and this time being the execution is closed. Liberty to file fresh execution petition. That was again, my lord, without filing the execution petition, the decree holder again file application for restore.
You don't require mic. You don't require mic.
Sorry, madam.
Yes.
Without, my lords, filing the fresh execution petition, he again restored the application after the validity period, that is 16 days, after 60 days. So then, my lord, he has paid the amount after 6 months. Now. As per the provisions 21 rule 84 and 85, he has to deposit the amount within that day of the auction day or 25%. Thereafter 15 days, he has to pay entire amount. So he has paid 17/9/22, my lord, that was the auction sale. And he has deposited before the court 11/4/23. Subsequently, my lord, that is our amount of, my lord, two amounts. 1 lakh is 15 lakh and one auction bid is 12,50,000. So without complying the order.
So how much deposited as of now?
Please, my
What is the amount deposited?
Deposited amount 15 lakh, my lords. 15 lakh deposited on 11/4/23. And my lord, 11/3/23 and 10/3/23. 10/3/23. So total. So auction is dated, my lord, 12/9/22. 12/9/22. Another auction date is, my lord, that is 16/1/23. And my property is, my lords, one more is my property is a self-purchase property. It's not a mortgage property.
It's not a?
Mortgage property. So while taking the loan from the JD number 1, he has not mortgage property. My property is a self-purchase property. So decree holder, without taking the steps against JD number 1, he was still alive. He is still alive.
What is this argument? What is, it is a coextensive liability.
Please, madam,
That
please.
is for him. Why anybody wants a guarantor? Tell the court.
Please, madam, please. But
Oh,
madam,
that plea is not at all available to you.
Please,
It
madam.
is for the JDR, as it is a coextensive liability, either
Please,
to go against him or against you.
Please,
You can't question
please,
it.
please.
So that is.
But a question of irregularity, my lords.
Huh?
One number, irregularity committed by the trial court is number 1. First, my lord, without attaching the property, they have to attach under 21 rule 64 of the CPC. Second point is, my lords, they have to deposit the amount within the day of 20% as per 21 rule 84 of the CPC. Thereafter, they have to deposit 75% of on 15 days. So that was not complied. Subsequently, my lords, the execution itself is closed on 8/1/24. That is kindly please them on the page number
These are
134
all-
of the judgment.
These are all ultimately come to the point. Don't go into this technique.
Please.
You owe certain amount.
I am ready to entire pay. No, my lord.
You are a judgment debtor.
I
You
am
have to
ready
pay the
to
money.
pay the entire amount. Because the worth of the bill is without valuation of the property, my lord. Decree holder called it with a bailiff.
Who has purchased the property?
Purchase the property,
This is
Girish,
something.
Girish Ramakrishna Hegde.
He's
So
not a
the sale
party.
is not, no, he is not, sale is not confirmed till today. That was not a made a party. Under order 21 rule 92. Sale is not absolute, sale is not confirmed. That was not a made a party.
No,
Under
we
order
will set
81.
aside the sale without the auction purchaser being a party to these proceedings.
So my lord, he is not being party under order 21 rule 92, my lords. If the sale is confirmed, then I made a party.
Even at this point, I am also.
I am ready to make a party.
Valuable
I am
rights have
I am ready to
accrued to
make a
him.
party, but I am ready to deposit
Necessary
entire amount. Entire amount I am deposit.
Why should we consider all this?
Lord, case
Please,
is
my
something
lord.
different. Lord, may I submit? Kindly come to my lord, synopsis. Case is something different, my lord. Now, he has challenged the order passed under order 21 rule 90. What happens is, my lord, kindly come to the
First of all, let us see the order in full. Page number.
Page number. I have produced the my lord, imprint order. Imprint order, I have given translation copy.
Yes. Yes,
Page number 2 is the fact of the case.
page number.
2. The judgment debtor in his affidavit stated that the applicant are the husband and legal is second judgment debtor and the decree.
Where are you reading? I'm looking at an order.
Finding is, my lord, pair number 7.
IA number 5.
Yeah, yes, my lord.
IA number 5, brief details of the application.
No, he has produced a
Are you reading from the
Translation.
reasoning part?
translation.
That's what reasoning part you're reading. Please read.
My lord, that is point number 1. The claim applicant judgment debtor in his affidavit assert that for purchasing the application property, a loan of rupees 20 lakh was taken from Bayrumbe Service Cooperative Society and purchased for 20 lakh rupees. And the said property was mortgaged. The decree holder cancelled these facts and gave old document to the court and illegally sold the suit property to the Girish Ramakrishna Hegde through auction at a lower price. Claim application related to interim application number 6 and 7 have been dismissed. It is found that the heirs of the second judgment debtor had complete information about the auction of the process. At that time, the heirs of the second judgment debtor did not file an application in court or appeared to file objection, stating that decree holder was conducting the auction process using old document or regarding the value of the property. The auction process of the property is completely finished and money has been paid to the decree holder, after which 4 claim applicants separately filed claim application regarding the property. Even though the heirs of the second judgment and lending institution had informed that the case was pending in 16, asserting now that the auction process is illegal without taking any action until the completion of the process in 2025 is not legally sustainable.
Give CPC. Let's see what order 21 rule 96. Please read.
Application to set a sale on ground of irregularity or fraud. Please, ma'am.
Where is your application?
Well, application is translation copy. I have.
Let's see what is it. Yes.
Application for the reason stating the company will kindly set the option sale in respect of the immovable property. Survey number 126 is at 2K, measuring 12 guntas. My lords, my fact says, my lords, then pair number 2, my lords.
Read.
2. The judgment debtor purchased the land in Sirsi Taluku, Sirsi Obli, Sirsi Taluku, survey number 126, HK, measuring 12 guntas on 3/8/2017 for a sum of rupees 25 lakh. While purchasing the said property, a loan of rupees 20 lakh was obtained by mortgaging the said property with Bayrumbe Service Cooperative Society. All urgent documents were deposited with the Bayrumbe Service Cooperative Society, and a registered mortgage was created on 3/8/2017 for the loan of rupees 20 lakh. On the aforementioned property, a further loan of rupees 20 lakh was obtained from the Totgara Cooperative Sales Society Limited in the year 2019 and 20. Mutation number so and so was recorded in the RTC of the said property in the year 2019. Decree holder finance has misled the honorable court by submitting the RTC dated 15/9/17, and he has placed the said property for auction. In this case, an auction was conducted on 12/9/22. At the time, the said auction was not finalized. 12/9/22, Girish Ramkrishnan did not deposit any money in the honorable court. It is observed that Girish R. Hegde bid for rupees 15 lakh in the said auction. The said auction became void. Subsequently, at the request of the decree holder, the honorable court again conducted an auction on 16/1/23. Girish R. Hegde bid a lower amount than the previous bid of rupees 12,50,000. Even on the day of the bid, Girish R. Hegde did not deposit any money in court. The decree holder, finance, has never recorded its encumbrance on the auction property. The honorable court has not attached the said property. At the time of auctioning the property, a fresh RTC was not obtained. At the time of placing it for auction, the encumbrance certificate of the property was not produced. Before auctioning the property, the prior encumbrances were not consulted. No rules were followed prior to the auction. The decree holder has acted in his manner with an intent to defraud. The current market value of the auction property is more than 60 lakh. There are also loan existing on the said property. Under such circumstances, it appears that decree holder finance through Girish R. Hegde, it is attempting to sell the property is at lower bid price. This is against the rule and constitution.
Yes, I have seen.
Please.
Where all these contentions are answered by the court.
My lord, kindly see, that is not the, kindly see, my lord, what the synopsis what I have produced, my lord. The petitioners are not the JDs, they are the legal heirs of the JDs. My lord, kindly see, when the loan was taken on, kindly see at page number 1. Loan was taken on 21/7/2018. 2008. 8. And at serial number 2, kindly we see 3/6/2016, execution petition was filed. And my lord, kindly see this, 4th one, 10/7/2022, proclamation was issued. At that time, JDR was very much alive. She died on, my lord, 21/7/2023. This application.
Sale was conducted on 12/9.
Yes, that's what they are not saying. Sale auction, Annexure G, kindly be seen.
Even before they came on record.
Yes, sale auction was conducted. Annexure G, what the document what he has produced. Now, in the year 2025, they make an application to set aside that sale. Order 21 Rule 90 subclause 3 says, application.
Let's read it.
Please.
Let's read it.
Yes, I will only read the relevant. Subclause 3 says, no application to set aside the sale under this rule shall be entertained upon any ground which the applicant could have taken on or before the date on which the proclamation was drawn up. So JD was very much alive. After 1 year, she dies. Now in the year 2025, the legal heirs of the JD comes and says, fraud has happened. Now, on the same point, my lord, Supreme Court very recently has answered, my lord, in the synopsis that I given, my lord. Kindly come to our High Court also has followed at page number 3 onwards, my lord.
We'll see the Supreme Court judgment.
Yes, directly if my lord wants, page number 16 onwards.
Paragraph?
Paragraph number 15 onwards it starts, my lord. Page number 22, relevant, page number 22 in the middle, my lord, paragraph number 15 may kindly be seen. There it clearly says, to get over the difficulty, Shri so-and-so has fallen back on order 21 rule 90 subclause 3 of the code, which provides no application to set aside a sale under this rule shall be entertained upon any ground which the applicant could have taken on or before the date of which the proclamation of sale was drawn up. Undoubtedly, this special rule got so-and-so. Now it answers in paragraph number, my lord, 17.
Yes.
17. Given the insertion of so-and-so, subclause 93, the statute book with effect from 1977, it would be incumbent upon a judgment debtor or any other interested person. It says, my lord, interested person who applies for setting aside an execution sale held thereafter to satisfy the executing court that the ground upon which the application was made could not have been made in time. Lord, the JD was very much alive. After 1 year, she dies. Now that is number one. Number two is Annexure G. He has already, the auction purchaser has already deposited the money. That is very much with the court. He is not made as a party. And my lord, the same position of law is followed in my lord, page number 3 onwards.
All that not required.
And on limitation also, my lord, page number 25. Supreme Court has on this ground itself. Page number 25 onwards, my lord, paragraph number 8 to 12.
Paragraph?
8 to 12. Paragraph number 8, my lord, reads exactly on this point only, my lord. It says within 60 days he has to make application, proclamation application. Now the JD dies after 1 year. Paragraph number 8 on.
Let's read 12.
Paragraph number 8 is a extraction, my lord. 9.
12 you said.
I'm sorry. Pardon?
You said paragraph number 12.
8 to 12.
Page number.
Page number 32 of my synopsis, my lord.
The limitation for filing.
The limitation for filing an application to set aside the sale of execution decree is 60 days in terms of Article 127 of the third part so-and-so Limitation Act. Then, my lord, a bare reading of the provision, this is important, a bare reading of the provision clearly shows that Section 5 of the Limitation Act, which deals with the extension of the time or condonation of delay, is not applicable to the proceeding under Order 21 Rule 90 of the CPC. Therefore, the delay, if any, cannot be condoned in terms of Section 5 of the Limitation Act. My lord, after this, the discussion happens, my lord, at paragraph number 11 and 12 also. They say after 60 days, this application itself.
Yes. Sorry, please. Relying the judgment for this honorable court. That for my lord,
Going
as
into
per
the
the CPC.
judgments, before going into the judgments on a factual aspect, you please clarify. Now, the synopsis, what he has given.
Please, madam.
So, proclamation was on 10/7/2022.
Please.
Auction sale was conducted on 12/9/2022. Judgment debtor died on 21/7/2023. That is almost, I mean, near to 10 months from the date of auction sale. So, what was not available to the original judgment debtor, because the delay has already, the time has already gone, that is not available to an LR now.
My lords, one point, my lords. Before taking proclamation, they have to attach the property under order 81.
Even
21.
that also has to
No.
be questioned within the,
It is
within the 60 days time.
That is order 21 rule 89, not 90. If it is irregular or fraud, they can file applications. Kindly order 89.
All.
21 rule 89, they have set a sale deed on deposit. It is filed within
have
60
already
days.
a decree-
And they have to pay, my lord, 5%.
Proceedings which
No,
are,
that is how-
which are initiated in the year 2006. You have
My lord,
successfully tracked down.
Because, my lord, she was suffering from cancer from 2021. No notice are issued by the bailiff through her and no panchanama taken in presence of her. Only they came to know when they received the LR's application or notice on the LR application. When she was died, they have taken the
The present application is filed under which provision?
2190.
21 rule 91. Can you see that? Yes, we have provision. Kindly have a check the judgment. This honorable court has passed the order and it is held by the Supreme Court members. Kindly pay. Please, I have 3 judgments, my lord.
We'll see for your,
No, I have
your satisfaction. Yes,
Please, my lords. The one judgment is second judgment, page number 22.
yes.
Similar set of facts, my lord. Page number 22, similar set of facts by this honorable court. In fact, in this similar is, my lord, the petitioner who is judgment debtor in execution number EP number 109 on the file of 23. Mandya is aggrieved by the executing court order 13/12/30. The executing court by the impugned order has rejected the petitioner application under order 21 rule 89 and 90 of Civil Procedure Code. The petitioner application for set aside the sale of land measuring 5 acres, 14 guntas, including 9 guntas of Kharab land in survey number 160 of Swansea. Second paragraph, the executing court on 412 has issued sale certificate in favor of the second respondent, who assert that he is put in possession of the subject property. The petitioner who disputed the assertion that the second respondent in possession of the subject property has filed application to amend this petition, challenge the executive order so and so. This court has observed that this application could be taken up along with the writ petition final. Further on 10-2, this court grants stay for disposition from the subject matter on the condition the petitioner shall deposit 1,50,000. Another
For
sum of
what
2 lakh.
proposition you want?
So, my lord, this court has given a finding that in pair number, my lord,
For what purpose you are relying on this?
this proposes, my lords, when the auction is called, my lord, on the day itself, they have to deposit under order 81 rule, 21 rule
When will
84.
we consider all
20
that?
Please.
When will we consider, at what stage we will consider all that?
But that is a material illegality, my lord.
Before proclamation.
That's a bitter proclamation, but Sangi, the property was not
Yes,
attached.
I'll
My lord,
record it.
one-
You are
one
relying
minute.
on this judgment.
My lord,
Paragraph
please.
number
My lord, that pair number 24.
20?
Four.
Yes, I'll
Page
record
number
that. Yes,
46, my lord.
yes. Next,
46.
next.
When there is a default by the purchaser, at least. The 24 page.
Yes,
Pair number 24, page number 46.
yes.
When there is a default by the purchaser to pay the purchase price within the period mentioned in the order 21 rule 85 CPC, the discretion lies with the concerned court to forfeit the price paid to the government after deploying the expense of the sale, and the default purchaser forfeit all claim to the property and to any part of the sum for which property may be absolutely sold. In this regard, this court must refer to the provision of 21 rule 86 of CPC, which adds procedure in default of payment. In default of payment within the period mentioned in the last preceding rule, the deposit may, if the court thinks fit, after defraying the expense of the sale, be forfeited to the government, and the property shall be resold, and the default purchaser shall forfeit all claim to the property or to any part of the sum for which it may be subsequently. So the second respondent deposit total amount of is 5,600,000 with the executing court, and the petitioner deposit sum of 4 lakh with this court. In the particular of the case that the second respondent has the advantage of revenue entries for the subject matter, and that in this case, my lord, they have not deposit on the proper time as per the provision of law, then this honorable court allow the petition. And second is the Supreme Court judgment, my lord, that is in gas and petroleum in page number 53, para, my lord, 7.6, the concluding paragraph. Similar setup, they have not deposited the amount within the 15 days, my lord.
Yes.
Lord, all these judgments.
Paragraph.
7.6.
Paragraph.
Para 7.6, my lord, page number 65.
Yes.
In the present case, admittedly the purchaser respondent number 1 deposit, my lord, 25% of the amount on 3/11/2011 and did not deposit 20% of the amount as required under order 21 rule 84.
No, basing on what material you are saying that it is not
My lords,
deposited?
that is irregular materiality as per 21 rule 90 is, my lords.
You understand my question
Please,
first?
please.
I said, you are saying that on so and so date, so and so amount is not deposited.
Please.
What is the material for that? I am asking you.
Please, my lord, order sheet kindly. Kindly see the order, page number 124.
120?
124. Order sheet, my lord. 123 is the mother spot sale, my lord. 8/8/22, this trial court has passed the order for spot sale, that is for sale 9/22. Page number 123.
Actually, is it correct?
123.
Lord, that's what.
123, I am saying, 123 page number. Page
Yes.
number 123, the spot 8/8/22 passed the order for spot sale. Thereafter, my lord, 28/9/22, 124 page number. matter is called out. The scheduled property was set put in auction sale for rupees 20 lakh. At the time, this was the amount at the time of filing the execution petition. However, the bailiff of this court submit that 24/8/22 mentioning that the scheduled property or the property of the JDR covered with the other agricultural property from its all direction, no road or no pathway facility is available to reach the proposed property. Only 3 bidders were participate in the spot sale and 2 for sale amount less than 50 lakh.
Now, what happens
That's
here?
last, I ಹೇಳ್ತೀನಪ್ಪ. Please.
Yes.
I am saying the DHR has.
Let him tell.
Please.
Yes.
Now, my lord, I'm not able to understand what point he wants to make.
What he wants to say is, the amount is not paid as per the, as it is supposed to be paid as per the auction.
Exactly, my lord, first sale, even CPC says, even if he has failed to deposit the first instant, second time the auction was called, then he has deposited. First time he might have failed. He is not a party. Now he is making allegation against someone who is not a party. That's what. Once the auction happens, my lord, I do not suffer. It is the purchaser who suffers. That's what, my lord. Even I have produced on that point also, my lord. I have produced the judgment.
Kindly, 2 points, my lord. 127, my lord. 127.
I'll
Same
consider all
auction
the
is without
judgments.
following any procedure, my
I'll
lord.
consider all the
Again
judgments.
called and second, my lord.
Yes,
Second,
I will
last
consider.
option is, my lord.
I'll consider and pass. Yes,
No,
I will.
my lord, pass through. One thing, my lord, page number 142 kindly be seen. Because till today the execution petition, no, my lord, right to file execution petition. This order is against me. Trial court has disposed the execution petition. How the mother trial court again restore the order without filing the fresh petition, my lord? That is on one.
That year is not open for you to question for the reason you are not a party to the proceedings at all. Your mother has never questioned it, or your whoever it is.
No, my lord, on that time she was died, my lord. She is no more.
Died after
She was
proclamation.
died, my lord. She was died on 21 and this order passed on 12/11/23.
She died
They have
after-
not took the steps for legal aids.
Yes.
So taken steps for
She
legal
died
aids.
after
That is the
issuing
reason, my lord.
proclamation, my lord.
This is the reason.
Yes.
And one more is, my lord, as per the judgment of the Supreme Court, my lord.
Give all the judgments. Give all the judgments to the
Judgment
court.
saying that, my lord, without valuation, my lord.
Paragraph number,
Yes, I
whatever
saw
it
the
is,
paragraph.
you please write the paragraph numbers and give it to the court officer.
Please,
I will consider, I will record all your submissions, your
Please,
judgments and pass an order. Give it to the court officer. Take it.
There is
keep it
no
in the file.
valuation, my lord, that is I am saying.
Yes, paragraph number you
Paragraph
please write.
Please,
Which paragraph you are relying on?
Please, I'll give the paragraph.
Yes,
Please,
next.
Cell number 23. Bedpur Mat.
Yes, next.
Even, my lord, I am ready to deposit the entire.
Huh?
Maybe record. Even though, my lord, I am ready to deposit the entire.
Petition is ready to deposit the entire amount.
Entire,
Record.
please, ma'am,
Keep it, yes.
No, my lord, that submission is subjected to verification of the auction purchaser. My lord, he is not the party and without making him party.
I'm not understanding. Let him say whatever he wants to say. You can't stop him, isn't it?
Yes.
He want whatever he wants, whatever to be recorded, I'll record it. What is your problem? Yes, next.
Seeking writ of mandamus to consider my representations. Seeking writ of mandamus to consider my,
What is the, to whom you have given?
given to the, my lords, respond number.
Respondent number 3 to
Three.
consider the
Please.
representation. Who is respondent number 3?
3 is known as executive engineer, public.
Executive engineer, public works, ports and inland. What is the representation?
That's what happened, my lords, I have allotted within certain land, certain work to develop the graveyard, my lords. Apart from that, my lords, after completion of my award, part, my lords, they have paid a portion of the award amount. Remaining 1,19,000 rupees has to be paid by them, my lords. To pay that, my lords, have submitted a representation. To pay that said amount, my lords, balance amount, I will
Where
submit.
did you say so in your petition? Which para? By the respondents, they satisfy respondents were under an obligation to clear the pending bills.
It's para number,
Yes.
para number 4, my lords.
Huh?
Pass. We will consider their representation.
The present petition is filed in the following prayer.
Take notice for
The
all.
facts of the case are petitioner is a class 1 contractor and who takes the civil works in Navalgund Taluk and other parts of the Dharwad district. Respondent number 3 called for the tender to develop graveyard in Kalwad village, Navalgund Taluk, and estimated cost of the project was 3,96,946. The petitioner pursuant to the tender has submitted his quotation and the respondent three, after completion of all the formalities and after scrutinizing all the documents, has issued work order on 10/5/2017. After that, the petitioner and the third respondent have entered into an agreement, work agreement. The petitioner has completed the work. After completion of the work, the petitioner submitted a completion report before respondent number three. Expenditure amounting to 3,96,486 out of the total of an amount of rupees 34,67, which it just said and directed to pay an amount of rupees 3,61,809. An amount of rupees 2 lakh was paid and remaining rupees 1,96,486 was due to be paid. It is a grievance of the petitioner that in spite of the repeated representations on 13/1/2026, 21/1/2026, 31/2026, 7/2/2026, and 13/2/2026, the respondents are failed to consider the same and release amount, which made the petitioner to come before this court. Let HCGP appearing on behalf of
other
respondents 1 to 4 submits that they'll consider the representation in accordance with law. Having heard so and so and so, the accordingly this court is passing the following order. The respondent, which respondent is the concern?
Respondent number three.
Respondent number 3 shall consider the representation dated so and so of the petitioner within a period of 4 weeks from the date of receipt of the copy of the order.
Grateful.
Yes.
May I make some corrections I have to make, ma'am? Am I permitted to make corrections?
Huh?
I have to make some corrections in the prayer paragraph.
No, you will, whatever prayer you sought, that will be given.
That
You
is
will not be permitted.
No, that is the office objection raised by the.
Give it to him.
14.
Yes, next.
Seal number 24. Yavatiyam.
I appear for petitioner. Petitioner is questioned annexure A regarding taking over the possession, my lord. The due loan amount is 1,50,00,000 on 3/5/2022 availed the loan, my lord.
Why should we interfere with the possession notice? What is wrong with it?
Now the 13/2 notice was issued, my lord. I replied that, my lord, give me 6 months time. I will repay it, my lord.
13/2 notice is not seeking time. 13/2 notice
Now 14 order is also passed, my lord. My humble request is only within 6 weeks, my lord, I will pay 50% of the amount, and within 6 months, my lord, I will complete the due. Andre, I have availed a loan, my lord. Therefore, my lord, within 6 weeks, I will file an affidavit.
Mentioning the reasonable time we will consider.
Please, one humble submission is, my lord, bailiff has come to take a possession, my lord. Therefore, my lord, I will file an affidavit tomorrow itself, my lord. Tomorrow itself, my lord, I will file an affidavit.
The petitioner submits that the petition is ready to clear off the entire dues, outstanding, clear of the entire loan amount within a reasonable time, and in this regard, they'll file an undertaking affidavit. Should be an affidavit.
Please.
Undertaking affidavit before this court. This is matter tomorrow, till such time not to take any coercive steps. Till tomorrow.
Please.
Yes. Seal number 25. Shukumar Badwadagi.
There are certain objections minutes I have to comply. There are certain objections raised by the office.
Let's see what is the NU you have come.
Plus the
Let's see what is the petition about.
Plus petitioner is seeking before the sum court a writ of mandamus. Plus as per plus annexure J and K and L are given a complaint.
To register the case against the respondent.
Yes, ma'am.
Provide police protection for transportation of mining material.
Yes, ma'am.
What is this?
Plus annexure K and L.
Under which provision they are obligated to do it?
Plus the petition, plus as per annexure J, page 42, it is in Kannada, minutes.
You have given
they are
a-
obstructing
you have
us,
given
minutes.
You have given a complaint against 3 to 6. Who are 3 to 6?
Plus 3 to 6 minutes. I'm requesting this honorable court directly respond 3 to 6. Take action against respond number 7 to 9.
Who is 7 to 9?
7 to 9 are minutes private transport operators who are not allowing us to minutes
And Mines
transport.
Lorry Owners Association. No, first of all, there can't be a direction to the police to register the complaint.
Yes.
That you are not entitled. Next, then provide police protection for transportation of mining
The
materials.
reason for this
Under
is,
which provision you are entitled
the
for
reason
this?
for this is, minutes, the reason for this is, let's me kindly see annexure.
Whatever is the reason, under which provision you are entitled for this, you show the provision, we will direct them to do it. That is what is the mandamus.
Let's may see, let's me kindly have it on 27th, minutes. 27th, I will.
So and so,
3 to 6 minutes.
the AGA takes notice to
1 to 6.
1 to
6.
1 to 6.
6.
1 to 6.
Yes.
Yes, issue notice to the other respondent. Petition shall comply with the office of objections. Yes.
May I request on 17th, 27th, minutes?
27th, yes, based on 27th.
Please.
Yes, 26.
26.
This I have filed. Writ of mandamus directing the honorable court to dispose of the IA number 2 of 25 minutes.
I number 2 of,
2 of 25 minutes.
when did you file it?
I have filed on page number 23/7/2025.
23/7/25.
25.
What is IA?
I have to stay the proceedings.
To stay there?
To stay the proceedings. Already the OS was filed, my lords. In OS, I was the ex parte, my lords. Subsequently, I filed miscellaneous application. Miscellaneous is pending. Subsequently, the plaintiff have filed execution petition.
No, when you file a miscellaneous,
Yes,
then you will seek the application there or here.
because there is a delay, my lords. In the miscellaneous, there is a delay application. So there are inquiries going on the delay. My lords.
First of all, such an order court cannot grant. For that, a mandamus again.
Mandamus to consider and pass the appropriate order within a time frame, my lords. Direct.
The represented petition is filed, seeing the following prayer. Submitted that he has filed I number 2 of 2025 on 23/7/2025, and the court has not disposed of the same. Hence, the petition is before this court. Accordingly, the petition is filed, passing the following order. This court has not issued notice to the other respondents as as this court is not passing any order, adverse order against the respondents. The same shall be considered and order shall be passed in accordance with law. Yes, expeditiously. Yes.
Number 27.
So 27 also, it is the same direction, my lords. I have filed a compromise petition in 15/4/2024. Since 2 years, the magistrate have not passed the order also.
You filed a compromise petition.
Yes, sir, we have
That is
filed.
not considered.
It has been not.
Please come. It is the grievance of the petitioner that he has filed a compromise petition under on 15/5/2024 in OS number 21 of 2022, and so far the court has not considered. The ARJ is directed to call for a report from the concern. Why this application, why this compromise petition is pending from 15/5/2024? List this matter on Wednesday.
Please.
Number 28.
This is with respect to forest development. Forest development tax is 28.
Lord's impugned order at page number 36. 12% of the this. Grateful.
Dispose. Number 29. Arunachal P. Hegde.
Challenging the dismissal of an impleading application, my lord, in a partition suit. My lord, we are plaintiffs before trial court. And we filed a suit against defendant seeking half share in the suit property. Our father and father of defendant are brother and sister. My lord, he took a contention that his sisters are necessary parties to this suit. Now the application is moved to bring them on record, impleading application, my lord. Now that is being dismissed.
How can it be? All of them are parties.
Yes.
The members of the family.
Yes.
Sisters.
My lord,
What is that order?
Annexure F is the order, and that's in Kannada. I have given a translated copy. The only reasons portion I have given a translated copy, page number 35. And Lordship may turn to page 36, para number 10. That is the only reason given.
Why the whole order can't be filed? How many pages is the order?
Since there was urgency, my lord, only reasons portion I have typed. Para 10, my lord, page 36.
Foot is of which year?
21.
When was this IA filed?
IA in there 2025.
Why they have not realized till now that they are necessary parties? It is not realized till now that they are the necessary parties.
It was my only negative point is a bit delay was there in filing the application. But not in any way, it's a partition suit, my lord. Para 10, it's stated, plaintiff has not stated in the application that legal heirs of deceased Venkatesh Shetty are necessary parties. Since it is not stated how they are related to plaintiff and defendant, point number 1 answered in negative. In para number 2 and 3 of the supporting affidavit of that IA number 6, my lord, I very clearly stated what is the relationship.
Then consider the petitions of its one of the defendant sisters, sir.
Yes.
Defendant sisters were not made parties to the suit. Hence an IA is filed to implicate them. The same is dismissed without considering the facts of the case, and also giving the finding that the relationship is not stated when the petitioner in the affidavit has stated the same, considering the same. There shall be stay of all further proceedings and so on. So petition is permitted to take out hand summons from the council and file a memo to that effect. If the memo is not filed by 16th of March, the stay granted by this court stands vacated.
May I seek for hand delivery? Hand delivery.
Order, yes.
Please.
Yes, 30.
Number 30.
For the cavator.
Yes.
Yesterday's matter, I have been instructed that as regarding monetary consideration, we are still ready. As regarding monetary consideration, we are still ready on that, not in respect of the land in question.
That is not acceptable to you.
Yes, not. I still request, my lord, it may be determined because as per section 3 of the Partition Act, I am entitled. Because that will put an end to the entire litigation.
You cannot say that
My
I
lord,
enjoy.
it might be from the, but the provisions gives a right, and that too, after determination of the final decree during the execution petition only, I can invoke that particular provision of law. That is the, it is only after final decree I am requesting this honorable court. That is the, before the trial court had filed necessary application.
It is not, property is not divisible.
Yes.
It is not divisible.
I was awaiting this question from this honorable court, my lords. To clarify things, my lords may kindly have a look at the situation of the property. They are all, my lord, commercial shops.
Yeah.
And in between two
let me have a look.
shops, my lord.
You have
Yes.
give him a photograph.
My learned senior must be aware, my lord, how it looks, my lord.
Even otherwise, the
Yes,
one which is
in-
forwarded to
I'll
the court,
give,
I like
I'll
to know on that also.
I'll give. I also given a copy of this hand sketch map to my learned senior, my lords. This may kindly be taken a look at, my lords.
You have the copy of this?
I'll give that to my learned friend. I'll show that the same. It's not indivisible at all. That middle portion which is marked in yellow, my lords, EF,
Having the
IJ.
copies which was
Those
before
are-
the trial courts, but
Let me
if you
just
can
make-
still rely on this, but I am not aware of that.
No, let me, my lord, place on record what is the factuals.
There is, a ground floor and the
First floor.
Yes.
It is allotted to you.
Oh, that's why this map, sir, one nimsha, sir.
Right.
That map, hand sketch map may kindly be seen. The middle portion marked with yellow, EF, IJ.
Anyhow, that is there here.
No, that entire, including first floor and ground floor, it is allotted to me. So there are shops, my lord. In the property, it's a commercial building. Only at the hind portion, there is a house.
And there are like, it is like shops, different.
Yes,
Composite shops.
You can't say that, from the middle, whatever it comes, the court should have properly looked at it. And
No, there are two independent shops, my lord, which are allotted. Two, they have, my lord, separate entrance at the main road. There is a road. That's why, my lord, I am referring to this map.
You will get how many shops in the first floor and how many shops?
Two shops in the ground floor and two shops in the first floor. It's a wide property, my lord. Here, my lords, may kindly see in this map that EFIJ portion, which faces the road, my lord, on the side, it opens on the road. I'll have direct access from the road. It's not that Murad, it is so indivisible that Murad, he will.
How do you go up? The steps are from which side?
There are stairs on the Murad, other side of the property. Beside,
Has
that's a
to
common
enter into
stair.
my
Murad.
property
This is
in
one.
order to have access to that.
And Murad, and dehorse this Murads. In fact, I also took instructions and Murad gave Murad few more proposals if they really Murad, as my little senior friend was submitting that bona fide interest is there to give any property to me. Yes.
I may put forth because these were the exhibits and the
So the other portion marked in yellow in the map Murads at the front, that's a 900 square feet vacant space. I am ready to take that also.
For example, if the upper portion and the lower portion, all those shops are of the same dimension.
Yes.
So can there be, why can't it be like only in the ground floor you can have 2 shops?
Let them give 2 more shops in the ground floor, Murads. 4 shops, let them give in the ground floor.
Then again, it will be
Any
practically-
adjustment, I am ready. This is precisely what.
It will not be practically feasible for further developments. At that moment of time, the roof portion may be required for construction also. So it will be in a very difficult situation at that moment of time.
One-sided. It is that's why if it is.
My lord, may I request?
Wouldn't have gone to the court.
My lord, may I request the photographs which are marked before the trial court? I have placed a photocopies. It is a black and white. I understand. I understand it is a black and white.
Yes.
It is a total composite building.
Last one.
Now, this is the portion which he wants to execute. The one which is written as Sharda Clinic. The one which has been written as Sharda Clinic, and on the upper portion. And the approach for this is again he has to come into my property from the other side, where he has no access. So this is the difficulty. That is why this is one.
2 in the ground floor, give him the other 2.
Entire 7/8 share is with them.
Entire first floor you have and any extension you want to do it.
No. Then it will be practically impossible because what happens, I cannot make any further constructions because he'll be in the ground floor. Then how can I make any constructions on the first floor also? Your Honor can see the one which is written as Sharda Clinic. It is exactly in between that composite complex. The one which is trying to be put forth before this honorable court.
He has a right. He has a right. There is a way. Your convenience, inconvenience doesn't matter.
No, but section
You
3.
cannot say that this property is not divisible is without any basis.
May I just, Murad, for clarity, please?
You are only speaking about convenience.
This is, Murad, this was decided in the
Yeah,
FDP,
this
disposed
is
of in the
also-
year 2012, Murad. Even if it is for a moment admitted, what my learned senior friend says that subsequently there was a compromise because of that, all these things. But even after filing of execution by me,
How many are the sharers?
for eight sharers, Murad, he says now.
I am 7/8 sharer.
Along with my original plaintiffs, and now he is claiming entire 7/8 share. Murad. No dispute about that. Let him take it, Murad. They have taken money from him. Let him take it. My 1/8 share, Murad.
What they want is now your share is also given, then they will take the entire benefit.
Yes, yes, Murad. For that, Murad, let them, Murad, give, if they give a.
Because if in terms of monetary terms. what
In
is
the year
your-
2012, Murad, when the valuation was made, 4 crore 99 lakhs was the valuation.
No.
Entire property.
No.
Entire property.
Your share.
No, divided by 8 Murads.
How much it is?
It comes to around Murads.
4 crores ಅಂತ ಹೇಳಿ 25 ಲಕ್ಷ.
ಇಲ್ಲ 25 ಅಲ್ಲ sir, 8 lakhs.
Say 50 lakhs.
In 2012 Murads. And as on today, the value per square feet is Murad 30,000 rupees.
How many square feet? So square feet.
It is 1250 square feet.
55.
So 3.6 crores will be the valuation, Murad. And he says Murad is ready to give 55 lakhs, which was a Murad proposal given way back Murad 7-8 years ago.
That is total. That
But
valuation is totally.
let there be bona
incorrect.
fides, Murad. I
Your
have
Honor,
convinced, in fact, my client that if there are good, genuine proposals,
My lord.
Hubli, on the main road, Murads.
My lord, I have already led an evidence in respect of the valuation that has been put forth. To counter that, also I have made a valuator I have examined as a valuator, and he has given a valuation, and his certificate is also placed on record. And that is also not taken into consideration by the.
Prayer of yours cannot be considered.
My
for the
lord, may I
reason
request?
You are only on a one-sided, your convenience you are seeking, you are seeing.
Not my.
You are not.
It
you are
is.
not
I am relying
Since
solely.
last
I am
30 years,
relying
Murad.
solely. I am relying solely on section. I am relying solely on section 3 because I am 7/8 shareholder, and I am supported by a ratio which has been also held by this honorable court in the earlier part of the portion. May I request?
Yes.
This is specifically in respect of section 3 of.
Yes, yes, let's see.
ಕೊಡ್ತೀನಿ ಒಂದೇ ನಿಮಿಷ. I think ಎಲ್ಲೋ misplaced ಮಾಡಿಸಿದ್ದೀನಿ ನಾನು.
Are you, is it your case that under section 3, even if the, one of the sharer doesn't even want to sell his property, but under 7, the court can compel him to sell the property?
Can't be. Because it will give an end to the entire list in question. In my case, what is there?
No, no. What is your answer to that? Is the section 3 says that even if one of the sharer doesn't want to sell his property, the court will, on a request of other sharer,
Yes.
can compel him to sell the property.
This is what it is stated in this particular ratio. My lord can
If
see
no such shareholder is willing
para
to
number
buy
5,
such
para number 5 shall,
kind,
para
the
number
applicant
5.
or applicant shall be liable to pay all costs of or incidental to the application or applications.
Para number 5.
Para?
5.
Yes.
Learned counsel for the petitioners having reiterated the grounds urged in the petition submits that the petitioners are the major shareholders in the suit property. They are residing in the said house. Therefore, the trial court was not justified in rejecting their prayer under section IA number 3 to permit them to buy the share of the petitioners in FDP number so and so. He submits that the petitioners in FDP number so and so have also now filed an application before the trial court under section 3 of the act. If the petitioners herein are not permitted to purchase the share of the other properties, they will be put to hardship. This is the prayer that was made in the application. Then your honor can see the finding starts from page number, para number 8. Section 2 of the act provides for court to order sale instead of physical division of the property in partition suit. In the event, if it is found that the property cannot be reasonably or conveniently be partitioned, the court can therefore direct sale of such properties and distribute the proceeds.
That's the crux of the issue.
Yes.
And section 2 also is, is precisely what I was asking, para number 8.
Para number 8 and para number 10 mail.
8, if you see, is,
yes.
Read it, section 8.
Section 2 of clause 8. Section 2 of the act provides for the court to order sale instead of physical division of the property in the partition suit. In the event it is found that the property cannot be reasonably or conveniently be partitioned, the court can therefore direct sale of such property and distribute the proceeds.
Now in this case, the court do not find any of that. It can
no observations has been made by the trial court in the order. That is paramount where I am before this honorable court.
And then you have come before the court, will consider it.
But section clause 10,
party, we can't
para number 10 of
yes,
that particular
yes,
ready judgment.
Yes.
A reading of subsection 2 of section 3 of the act would make it clear that if there are 2 or more shareholders who severally apply to leave to buy as provided under subsection 1 of section 3 of the act, the court shall order sale of share or shares of the shareholders who offers to pay the highest price above the valuation made by the court. So valuation has to be made by the court. As per my application,
all these things will come into play provided the property cannot be divided and cannot
yes,
be given share.
My lord is absolutely right. That is why may I request the the sketch which is produced along with the decree which has been passed. Now, because now
we are looking at the photograph. That is more clear than anything else.
That is misleading. That is what I am trying to say, because it is not going to divide exactly the way the decree, or I can say the FDP court commissioner has submitted.
If it is not, how it can be done? You can come up with a proposal, but you cannot say, I will retain entire thing, you go out. That is not for you to say. It can be divided. That's what I'm saying. If it can't be in the middle, give him in the corner. And you use the remaining property.
But since she is only 1/8 sharer, that is why I am trying to put forth before this.
That's why I gave that
and put into
proposal.
The provisions of section 3 of the Partition Act.
You can have an amicable settlement. Section 3 does not give you such a power in the facts and circumstances of this case.
But may I request still the map, which is, that is the commissioner's map based on which the present execution petition has been filed. It will not put forth the actual status of the land which is to be divided and the actual status of the walls which are existing, which will put in possession of the.
At best, what I can do is that let there be an advocate commissioner be appointed. Again, you should come out saying that which part of it will be feasible for partition. Apart from that, this selling, buying, this proposition rule 3 will not come to your risk. That's what there's a only order that can be passed in this. If you want, I can direct the court to do it. But provided you should come out.
No, in fact, for this purpose only, I have given the hand sketch map. What is allotted to me is a property measuring 1250 square feet. There is a vacant site, which is not occupied by anybody. My lords may kindly see that hand sketch map. On the other side, that is lesser in extent. It is about 900 square feet. I am ready to take even that. If that is that will not cause any problem either to him or me. But it appears that they are not ready for that also. And my lords may kindly see this judgment is not applicable to the facts because.
Forget about it. I haven't asked you whether it will apply or not.
Yes, yes.
You have to argue on that.
Yes, and therefore, in the absence of challenge to the final decree, now all these things cannot be permitted to be argued in section 47 application. That has been my request, since yesterday.
We have to put an end to this.
Yes, yes.
That's the reason why the.
No, that's why multiple proposals have been given. It appears, but none of them are either the present value not ready.
Please instruct your client. The only option that is available to them is either to give him that open site or any part of this building, which is convenient to them. But they can't say you completely go out of the building, we'll use it how we want. If you want to use that building the way you want to, give him the open site. You can't have both because you can't dictate the terms.
In those circumstances, my lord, may I request, if it is put forth before the mediation, I think we can work out. If
I'm not agreeable for any more. This has been 2018 this execution petition. Please, I may permitted to make only one. Yes.
We'll only it will not go on forever. We'll only say, I'll give a fix a date. On the date you appear.
Please.
It is not happening. I'll give a date this side of the roster, and that date itself will pass orders.
No, today only, both parties are present. Let them go and come, Matter may be passed over.
My parties
Matter may be passed over.
I'll take it up tomorrow. How can again by afternoon? Why should you rush to the court? Let's this matter tomorrow. Both the parties shall appear before the mediation center.
Yes.
Let the other side not still precipitate in respect of
Mediation center, Dharwad. No coercive steps till tomorrow.
Please.
This is a matter tomorrow.
Yesterday also, I made the same submit. It will continue, once it is granted.
There is no.
But I'm only trying to submit. Conduct may kindly be seen. 21, the order for delivery was.
That only tomorrow.
Yes.
Yes, and tomorrow no more arguments. Either it is happening this way or it is the court's way. Yes.
Please.
My learned senior friends consent, a particular advocate may be because
anyhow there are mediations.
No, there are It's my request, that senior Balika, sorry,
No,
anybody.
let them go there. They will appoint.
They'll have their own this one.
Yes.
I'll leave to the court if he's still.
Or somebody who is because it should not go on postponing. That's why.
No,
because what happens is sometimes.
No, they have a trained mediators, isn't
yes,
it?
Yes.
Not any advocate in the court.
Of course, only trained mediator.
Next.
2:30 will appear in the mediation.
Go, you go right. The parties are there. Let them go right now.
The file has to go. That's why,
It will go.
Please, that may be.
Orders matter, seal number 30, 31 urgent, seal number 32. Ravraj Sipati.
For the petition, Your Lordship. Now, this is the third time, the second time both the parties are before this honorable court.
Come to the prayer. First of all, you point out the prayer. What are you seeking?
Please, Your Lordship. Your Lordship may kindly find the prayer.
To quash the registration granted to the respondent number 1. Who is
Yes.
respondent number 1?
The respondent society, Your Lordship, registered under the Karnataka Registration of Societies Act.
Who are you?
I am the petitioner trust, Your Lordship.
Were you concerned with their registration?
Please, Your Lordship. Now, the facts, before even opening the file, Your Lordship, the facts are that I was a trust running this Jain Basti since many years, somewhere around 1999, Your Lordship. Now, subsequently, I approached, as this was a practice, Your Lordship, I approached the district court under section 3 and 7, seeking approval of my management.
That was challenged by the respondent number 1 before this honorable court. This honorable court answered the question that you cannot go to the PDJ, you cannot go to the district court under 3 and 7, and therefore that order was set aside with a specific finding that the principal district court does not have the authority to approve any management. Now, respondent number 1 registered a society under the Karnataka Registration of Societies Act on the same basti. Basti is a temple, Your Lordship, Jain temple. On the same Jain temple, showing the trust's properties as their properties. And now they try to claim management on not only on the management of the basti, but also the properties of the trust. Now, on the first date, Your Lordship, if I may take a look.
Under the Cooperative Societies Act, once a registration is granted, what is the next procedure?
Not Cooperative Societies
Registration
Act.
Act.
That's what I'm saying, Societies Registration Act. What is the next procedure?
They can approach the registrar under section 20.
Let's see, give the act. Where is which provision deals with registration?
Well, section 27, if they were aggrieved by my registration, 27 empowers the registrar.
Section 27.
Yes.
Please read 27.
Please, Your Lordship. If it appears to the registrar that any society registered or deemed to be registered under this act is carrying on any unlawful activity or allows unlawful activity carried on within its any premises under the control of the society, the registrar may hold an inquiry or authorize any officer to hold an inquiry in the activities of such society, and in respect of any such inquiry, every such inquiry, the registrar or the authorized officer shall have the same powers as are specified in subsection 2.
The registration.
Please, Your Lordship.
Registration deals with which provision?
Section 8.
Section?
8.
Now, if a society is registered.
Yes.
I mean, the registration is refused.
Yes.
An appeal lie to the Karnataka appellate.
Only in case of refusal.
Refusal.
Yes.
Now, it is granted.
If
It
it
is
is-
granted and a person is aggrieved by it.
Yes.
Even in that case also, an appeal shall lie.
No, but under section 8, appeal is not maintainable.
Then
They can invoke section 27. There are two.
27 is.
In case of unlawful activity, my lord, we can also allege that registration itself is illegal.
Some other provision.
The only remedy would be to challenge the registration by way of seeking a declaration before the competent civil court. There is no enabling provision, but I have examined the entire act.
Even before going on those facts, Your Lordships, the facts which are adjudicated by this honorable court in the previous round, if I may kindly.
Not necessary for this. Now the issue is.
There was a direction issued to the.
Or the registrar is not necessary. Not necessary. The registrar has not looked into all this. Somebody went to the registrar and got their society registered under the act. Now you are aggrieved by such an action. All those things High Court will not look into whether this property belong to your trust or this belong to that, and what is the inter se dispute between the parties is not the concern of the High Court at all. There should be a mechanism other than there should be an alternative remedy to you. What is that? You have to tell the court.
But sir, except, if I can, except section 8 and 27, none of the provisions under the act would deal with
No, if you look at 27.
Yes.
No, because these are all the issues that which requires a inquiry, which the court can't do it.
Yes, that's the reason why I consciously made the submission that since this becomes a disputed question of fact, which requires evidence to be recorded.
Your Lordship, inquiry is done, Your Lordship. Even the Dandavati report is a part of records before this honorable court.
Let's just forget about the earlier this thing. But to the earlier petition, he is a party.
Please, Your Lordship, he is a party.
Oh.
It was his petition. Now, my major two grounds were my president in the trust.
Registrar was a party to the earlier petition.
Please, Your Lordship.
But anyhow, even this order will not go to the registrar under the how the things are going on here. I don't think this order will be communicated to him.
If I may make one submission on this ground, if I may take your lordship's kind attention to the order passed by this honorable court in this petition, by the order dated 18/7/24. Now consciously, this honorable court, having regard to the order passed in the earlier petition, has recorded the reasons why this interim order was granted. The first order dated 18/7/2024.
Cancellation of registration and dissolution of certain societies.
That is the only mode, millets, under which inquiry in terms of section 25 will be held. If the registrar feels that the very registration, though the words, millets, the legislative intent was to inquire into with regard to the legality or otherwise of the society also.
What do you say?
Here, it is a disputed fact that, my lords, as
No, when the registrar is a party to the earlier round of litigation, when there is a dispute between two persons, and when he is aware of all this, when an application is filed seeking registration, what are the formalities?
No,
that has to be
what my
followed?
learned friend is saying is post the registration. Those proceedings are post registration.
Post registration.
Yes, ma'am. Not before that. The registration had taken place in 2020.
So what happened post registration? What this court has said?
No, they had sought approval of the committee by making an application before the district court. That approval was given. I questioned that before this honorable court. Their approval was set aside, holding that the district court has no jurisdiction. Now the facts are these, Millard.
No, by the time you went to the civil court, your right is already registered.
Yes, ma'am. Now they contend that the trust had come into force in the year 1999. Millard, the facts are these, Millard. This trust was registered in the year 1950 or so, 56. By suppressing that, the mode of succession there says that one of the trustees therein and the community people of Jain caste will, let's form a committee, and thereafter they will look after this basti. Now, by suppressing that registration of earlier basti, they got it re-registered in 1999. That is suppressed in the entire petition here also. Lord, since the mode of succession, they provided that two of the persons who are mentioned therein, their family members, with the help of the localites of Jain community, can form, let's say, a committee. Based on that decision that was taken by the family, the present committee was, let's, constituted only for the purpose of administration. But the trust in the year 1956 will remain intact. Property belongs to the trust. Now, suppressing all those things, they had done this. Since the family members came forward for formation of a committee, it was registered under provisions of Karnataka Society Registration Act. Now, nowhere in the entire petition they do whisper about the registration of 1956. They contend as if this temple has come.
Filed your objection.
Yes, ma'am, I have filed.
What about you?
State has not. State has not.
Why?
My other ground, which is on the facts, I could not.
And moreover, petition has to be dismissed on the ground of delay in laches. 2020 is a registration. They keep quiet for 4 years. They challenge it in the year 2024, 25. I'm sorry, 24.
Please come. This petition is filed.
Your Lordship, may I make one submission?
1 minute. This petition is filed in the year 2024. They're questioning a registry, seeking cancellation of the registration of the first respondent society by the district registrar of, by the district registrar under the Society Registration Act. The first respondent has filed his objection. The second respondent, for the reasons known to the best reasons known to them, in a writ petition of 2024, even till today, the objections are not filed. The objections shall be on record by Wednesday, or else the court will pass appropriate.
Lordship, there is an interim order in operation.
That I have sought for vacating. That's the reason why twice he had taken time. May I request?
Wednesday.
Very well.
Wednesday, by the time, extend interim order till then. Yes,
Obliged.
please.
Obliged.
Number 33.
Please.
I appear for respondent.
Hearing part petition. In fact,
Where is the translated copy?
my lord, I have produced it, my lord, in fact. I requested, my lord, the office to, yesterday it was produced. I requested the office to, my lord, send it to the office. So, my lord, whether it is received, my lord, or
Translation.
translation, my lord, in fact.
Where is it?
But I have produced it, my lord, yesterday.
Not here.
But,
I have the copy. my lord.
This is matter. In the month of February, in the month of March.
My lord, I am seeking for last occasion, your lordship is pleased to hear this matter quite some time. Once, my lord, they took time for translation of the sale deed. The other time, they took time for translation of the impugned order.
When did you file that?
Yesterday, I have the,
Yesterday I have filed it. My lord, I will.
I have
my
the
lord,
copy.
let
They have
me- my lord,
served.
I am not asked.
Next,
Kindly be passed over, my lord,
Please,
it may kindly be
please.
secured, my lord.
34.
Not that, my lord, he is making allegation.
Till number 34. H. Bagi.
Notice to R2 returned as refused, amounts to deemed service of notice. Yes.
I filed application for seeking direction, my lords.
Hmm?
I filed application for seeking direction, my lords, stating that, my lords, after granting interim order from this honorable court, the third respondent is doing a business, illegal business, my lords, bank transaction, because this honorable court has granted by appointing the president of the board. But now he has issued a check in the name of the president and doing a transaction there, because already
Is the case file a contempt? What
This is
further orders you
pending.
will expect from the court?
and he has not allowed, and
Against
he
an
is,
interlocutory order, no contempt lies.
that's my lords, the interim order, that's why I did not. Interlocutory application, my lords, the contempt may not be. That's why I sought for direction, my lords.
When there is an order to do it, it's an interlocutory final order, is a violation of the order.
Yes.
So
And
this is what do you want now?
and even though he has not allowing,
What do you want now?
no, even though he's not allowing now I am the petitioner, is the president of as per the earlier order, my lords. And he has not allowing to do the work, my lords, because the secretary and the given false and fraud application to the,
What direction is given to whom?
my lords, the state, my lords. Now I am seeking direction against R3.
Earlier to whom it is given?
Plus the impugn order is stayed. Impugn order is stayed. Impugn order is
Pass that
stayed.
impugn
Appointing that is appointed as respondent number 3 was appointed as a president. That has been stayed, my lords. But now he is doing that, conducting the business.
Who appears for the state board of?
Board, my lords, Muhammad Ramshali.
Where is he?
He's appearing. His name is shown, Ramad Shah.
That's true, I'm asking where is he physically?
Morning he met me, on the served coffee.
Password.
Otherwise, I have taken up Monday, my lords.
This is the matter on Monday.
Please.
Yes, 35.
Till number 35.
Petitioner,
Sadiq and Goodwala. Dinesh M. Kulkarni.
see, 2 days time, I am not well, Monday or Tuesday.
I have filed affidavit yesterday for affidavit.
Whom you appear to whom on
They
behalf
are-
of?
Both are each, same.
Who will argue? Whoever wants to argue, please stand. Others who don't are not arguing, please sit. Who will argue in both of you?
I am for respondent.
Yes.
Respondent in this case, my lord. I have filed the affidavit. This court has direction to me file a affidavit. Therefore, I have filed the
When
affidavit.
was the order? When was the order?
Oral direction has been given this court, my lord.
On 4/2/2026, I think there was an order to file the statement of assets and liabilities.
Yes,
Right from that day, what are you doing? It was on, it was on 4th.
yes, yes. 2 days time I am requesting.
This is matter on Wednesday. By the time if the assets and liabilities are not placed on record, the writ petition will be dismissed on that ground.
Yes.
Yes.
36, urgency number 37. Vishwanath Bhatt. J. Shetty. J. Shetty.
I will dismiss this writ petition. Having given a memo, don't even appear before the court. The memo is moved, a court is moved. Accordingly, the matter is,
Vishwanath Bhatt.
accordingly, the matter is listed. When the matter is listed before the court, there is no representation. List this matter for dismissal tomorrow. Yes, 38.
Seal number 38. Sadiq Karmi.
My lords, this impugned order was passed without jurisdiction by the additional chief executive officer of State Board of OCAF. And the learned counsel for the board was directed to submit the statement of objection or the order which they have submitted, that they will submit. That is came on record in view of the order dated 21/11, my lords.
Who is the counsel?
Mr. Jay Shetty appears, my lord.
Where is he?
He was arguing
Jay
before my
Shetty.
lords in the previous matter.
Lord
It
Khan.
appears he was called somewhere else, my lord.
Please.
Yes, 39.
Number 39, KL Patil.
39 minutes. I seek weeks accommodation to file affidavit. Notes,
Matter,
sir.
Lordship is directed to file an affidavit, my lords.
Notes, what?
With regard to what extent of land was acquired, the petitioner's land was acquired without acquisition and
Why your respondents are doing like this?
Well, it's what I-
Acquiring the land and not paying the compensation.
What has happened, my lords? Pursuant to order of this honorable court, we requested the city survey authorities to assist us, my lords, in conducting the survey, because they are the, my lords, authority holding the records. On 10th itself, my lords, we wrote the letter. Yesterday, late evening, my lords, survey has been completed, my lords. So we are yet to receive report, my lords.
Thursday,
please.
Yes, my lords.
next Thursday.
26 minutes.
This is filed on Thursday. By the time the affidavit shall be filed, no further time will be granted.
One submission, Your Lordship, one submission. Actually, R3 has to file affidavit. Same is already clarified, Your Lordship. It may be deleted, Your Lordship.
What is that?
Insofar as first concern, Your Lordship.
Item number 1, my lords, in 39.
39.
R3 has to file affidavit.
The affidavit shall be filed by.
That has been clarified, but in cause list they have printed.
Yes. By the next date of hearing, R3 shall file the affidavit. No further time will be granted.
Please.
Yes, 40.
Still number 40. Rahul Srikanth.
This is tender matter, my lords. Senior advocate is online.
May I seek a password? Senior is also online, man. It's just password.
Password.
Please.
In the afternoon, my lords, I think senior advocate is
2:30, I have
engaged.
some difficulty. Can it be on Tuesday?
Senior is also, but he's seeking password because he's elder.
Oh, they are seeking time.
Please.
Not seeking time,
If
my
it is
lords,
seeking
because we
time.
are ready because 2:30 he has got some other engagement.
This matters on Thursday, next Thursday.
Lords, 25th is the last date on which, my lords, the tenders are supposed to be opened, the technical bid. So therefore, my lords, may I request for 24th,
When do you want?
24th, my lords,
24th is what?
Tuesday, my lords.
List on 23rd.
Please.
23rd, my lords, 23rd, 24th, may I request.
24th.
20.
Yes. 41.
Still number 41.
The
Lord.
stay granted by
41.
Yes, 41.
yes, ma'am. Petitioners are, my lord, the elected candidates.
Who is respondent number 4?
4 is, my lord, the
Deputy Registrar
Registrar.
of Cooperative Societies.
government advocate was directed to take notice.
The
My senior counsel was appearing, my lord. In fact, he had argued on the last occasion, my lords. May kindly recollect this matter where, my lord, the election.
already, so and so, AGF for R1 to R6.
Yes, yes. Notice is ordered. It's only for, my lord, the purpose of interim order that we were pressing the matter, my lords. My lords are pleased to hear. And inner council, it appears, my lord, is not.
It was there for my submission,
Yes,
my
ma'am.
lord. On the last date of occasion.
What is impugned order?
Impugned order is an interim order passed by the, my lord, Deputy Registrar of Cooperative Societies, intervening in the process of election and staying, my lord, the election of the office bearers pursuant to, my lord, please, my lord.
On the ground?
On the ground that, my lord, the election petition is filed by some defeated candidates, stating that, my lord, there were few dead persons who had approached this honorable court seeking right to vote.
Election petition is filed,
Under section 70 of the, my lord, Karnataka Cooperative Societies Act. Pursuant,
the election is done.
no, after the election is done. Election is now over, my lord.
So you are saying that election process is.
Process of election, my lord, commences from the date of issuance of calendar of events and concludes upon, my lord's, election of the office bearers, that is president and vice president. Now the,
State by virtue of the election petition.
yes, now the general election is held, my lord, and we were the elected candidates. Pursuant to that, my lord, the election to the office bearers has to take place. At that time, my lord, they filed and he has intervened in the process. Now it is, my lord, He is a defeated candidate.
The defeated candidate.
You are the one who have filed the election petition.
Yes.
My lord, may I make submission? I was directed to go before registrar under 70, my lord, by this honorable court. I went before registrar. I raised my dispute and I filed an application and documents were filed to show that dead persons were made to vote. Now what happened is registrar granted an interim order. Now against which they have come before this honorable court. It is against only interim order, my lord. The very maintainability of the writ petition is in question, my lord, because this honorable court time and again held any interim order passed by the registrar has to be challenged in under 107 of Karnataka Cooperative Societies. On that basis, my lord, I am canvassing my argument on two limbs, my lord. First is maintainability with respect to writ petition itself. Second is now interim order is passed. Now he doesn't go to the registrar requesting for vacating of interim order. He doesn't file any objection there. Directly comes before this honorable court. Similar set of facts were there before this honorable court, my lord. This honorable court clearly stated, go there, go file your objection, file vacating stay application, then come before this honorable court.
This is a routine procedure.
Yes.
Why should there be an exception?
My lord?
No, this is a routine procedure here. Why should this be an exception?
Correct. That's what they have to answer it, my lord. They directly come before this.
Answer it because here alternative remedy is something which is that word itself is not there in the dictionary. It is like every order of that's what I said. Even the constable does something, it should come to the High Court. So all writ petitions are entertained like that. Why should this?
No, for this, my lord, especially for these things, my lord.
No, those kind of things are so many entertained. I've been seeing.
Yes, my lord. I have produced some documents.
There should be some parity.
No.
Even in.
Correct, my lord. I have produced some documents. I have pleaded. I have showed them something. Register has passed on the basis of that. Now, let them show a document or let them object to my documents.
Aspect with regard to the maintainability when there is a remedy available to him. Number two, whether such an order can be passed by the registrar that you have that you submit on that. That also will consider. Both will consider.
Yes, my lord. I have showed the registrar that dead persons were made to vote.
He has to say.
Your Lordship, when the respondent, the very petitioner, has filed the documents and to show that dead persons have voted, Your Lordship. Prima facie, we found that it is needed to examine, Your Lordship.
Election,
For that
he is
reason,
hearing an election petition.
please, Your Lordship.
He has to hear the parties and accordingly, if he feels that
We'll hear, Your
the
Lordship.
election will be set aside.
Please, Your Lordship.
If it is not. So why should in between this should be stopped? Ultimately, the result would be he can do it whatever at a later stage he can
But
do.
when election petition is filed, Your Lordship, prima facie found that there are dead persons.
Section
dead persons-
71(3), my lord.
Let's see what are the when election petition is filed.
Section
what are the
71(3), my lord.
71.
Section 71(3).
Read.
The registrar or any other person to whom a dispute is referred for
You are
decision.
reading 70?
71 subclause 3.
Decision. The registrar or any other person to whom a dispute is referred for decision under this section may pending the decision of the dispute, make such interlocutory
All
orders.
these election petitions are heard under section 71.
Section 70 is the provision which gives right to file an election petition.
Let's see 70.
Yes.
Any dispute arising in connection with the election of a president, vice president, or any office bearer.
Yes.
So the procedure is 71.
Yes, my lord, dispute will be raised under 70. But the interim order or any order on interlocutory application will be passed under 71(3). That is what the procedure is followed. Now against that he has remedy and he never files objections to this.
What do you say?
Yes, ma'am. First submission would be, I am instructed that senior counsel is arguing in the first court. If it may be taken at 2:30, it will be grateful.
2:30
And for
I have
this,
parted matters, my lord. Day after tomorrow, Saturday, it may be taken.
This is matter on Saturday.
No, my lords, may I request, multiple times it was listed. Later on it may be taken after 2:30. Let him finish his matter and come. Because, my lord, please,
Saturday.
please.
Not 2:30, day after tomorrow. On
Please.
Saturday. Yes, next 42. 42.
Mrityunjay Sadikeri.
Also,
Sadikeri. Pass.
yes.
43.
I appear for the respondents, my lords.
43, seal number 43.
Pass over.
Vijay Tata Bangi. Pass over. Seal number 44.
Appearing for respondent number 4, my lord.
I have filed the memo seeking withdrawal of the writ petition because it has become infructuous. 44.
We haven't received a copy, my lord.
Even that copy also you want? He wants to withdraw the writ
Yeah.
petition.
Yes.
Please.
I will give a copy.
The memo is filed. This memo is filed stating that the issue involved in the writ petition has become infructuous and shall be permitted to withdraw. Accordingly dismissed as withdrawn.
44.1, my lord, I will argue some other date, my lord.
No, this is for only 44.
44 only, my lord. 44.1 survives, my lord.
44.1.
Survives.
44.2 is
Both-
filed
no,
as.
Both will not survive because.
They will, it will not survive.
May I make a submission?
44.2
It's the
also,
same
my lord, does
tender,
not.
my lord.
I have moved the memo, my lord. Now, they have challenged that we have, the department has issued
There
a
is a
notice.
counsel for the petition in 44.2.
No, I am not.
In his absence, you can't argue.
Yes.
I have moved the memo. Urgency is that, my lord, we could not do anything in view of the interim order.
Pass over.
Please, much of.
Yes, next, 45.
45, your
44.1
ladyship, I
you
appear
must
for the
be having-
petition in this matter.
44.1.
What was the same
In
tender?
both the cases, my lord, they have
We'll
challenged.
see, we will see in the afternoon, 45.
Your ladyship,
Yes,
I
Mr.
appear for the petition in this matter. It is a matter concerning a refund of a earnest money deposit that was made in connection with a tender for the Hubli Smart City project. The balance amount after the EMD could not be paid due to
Why
COVID-related
this
exigencies.
22 matter, now the memo is moved?
Your ladyship,
What was happening from 2022?
your ladyship, every time this matter is taken up, the municipal corporation takes time on one ground or the other. If your ladyship could kindly have for a moment the order sheet.
45.
And in fact,
My lordship,
if I draw
respond
your
number
ladyship to
GK
order it-
Hiregaoda is a file. For respond number 2, GK Hiregaoda is a appear, my lordship. He has filed a wakalat, my lordship.
Could I request your ladyship to just for a moment have order dated 28/7/2025? Now, on that date, your ladyship, Justice Suraj Govindraj was presiding over the court, and there was an observation made by the bench that if money has been paid to you as earnest money deposit and the project cannot be carried out due to COVID, then you ought to refund the money. At that point, respondent number 1 said, we have given the money to the corporation. So Justice Govindraj had asked the corporation to come on record and verify where the money is sitting.
Hubli Dharwad Municipal Corporation.
That,
my
that
lordship.
order has not been
GI
complied
gets
with.
him, but already he has filed wakalat. GK Hiregaoda has filed wakalat, my lordship. He is only appear, my lordship.
Yes, then what is he doing without filing the objections? After filing wakalat, how many years the matter will be pending? Where is he? Ask him to come.
Please.
Yes, next. Password.
Oblige, your ladyship.
46. 46. Srinivas Vinayak.
Sir, request a password, my lord. Senior is on his list.
47.
46 password. Seal number 47.
My lords,
Suraj
this is the
Madhupati,
claimant's
Sri
appeal
Nayak.
for seeking enhancement of lordship. Filed the IF for amendment of the appeal, my lords. Want to increase the valuation of the appeal, your lords. I have filed the IF for amendment of the appeal, my lords.
What is the amendment you're seeking?
My lords, I want to increase the valuation of the appeal, your lordship.
From where?
Earlier,
Why-
I have
why should-
restricted to 15 lakhs, my lords.
Huh?
Earlier, I have restricted to 15 lakhs. Now I want to that restore the original claim of 2 crores, your
Special
lordship.
claim.
2 crores, your lordship.
Why did you restrict it to 15 lakhs? Because the, why you restricted it to 15? Why you want crores now?
My lord, that is continued the medical treatment, your lordship. He suffered a paraplegia and suffered 100% disability, my lords.
Insurance company is not a party.
Yeah, it's party, my lords. They have filed the wakalat also.
Where is he?
The iske kayak mat
I number 1 of 26 is filed seeking for seeking the amendment of the prayer and also the prayer. The respondent shall file objections if any. This is matter after 2 weeks. Then it will go to the bench. Is 48.
Seal number 48, Kiran K. Kapoor.
These matters.
Paramgod.
My lords, they have filed the application, respondents have filed the application for vacating of this stay, my lords.
Where is the respondent? Who filed?
Respondent number 6.
Pass over 49.
Please.
Number 49.
Further
Has filed
respondent.
a vacating application. This is the matter where, my lords, the assistant commissioner has nullified a registered gift deed, exercising the powers under the Senior Citizenship Act. Lords, my submission impugned order is in Kannada. Even the application submitted by the respondent number 2 herein is in Kannada.
This is matter in the month of May, in the month of March.
Lords, interim order may be extended.
Interim order earlier granted is extended. 50.
Date may kindly be fixed, Your Lordship. I have filed an application for vacating stay.
24th of March. Yes, fine.
Please, ma'am.
50.
Seal number 50.
I appear for appellant in this case, my lord. The third respondent has filed an application alleging that the MFA is not maintainable. As per section 83, subsection 9 of the Work Fact, amended Work Fact, a statutory appeal is provided as against the order of the Work Tribunal. Therefore, I have rightly preferred the MFA. And my learned friend, second ground, he is alleging that there were earlier 2 suits. But the honorable, there were earlier.
You want to argue it or?
No, these applications can be taken up along with the main matter because on 3/7/25 matter has been admitted.
It is not at all maintainable.
No, it's all right. See, matter has been admitted.
Are you ready to argue?
No, if my friend,
yes, I'm
because
ready.
he is moving
I'm
memos.
ready.
Allah,
Pass over.
my friend is moving memos.
51. 51. Notice to the respondent.
May I request your lordship, my lord, the serial number 50 matter has been admitted. If the applications are taken up together with the, and it was posted for final hearing.
They're asking that there is an.
That's what.
We'll hear it. Yes, 51.
51.
Notice to the respondent.
Issue notice.
52.
Seal number 52.
This also notice. 53.
53.
I'll have to file objections to the impleading application. Yesterday, they have served 1 week's time, my lord, sir.
This is the matter regarding the Deputy Commissioner has directed the Hereditary Trust not to permit his sons and family members inside the Garbhagudi. That an order is passed. That has been challenged in the first writ petition. In the second writ petition, my lord, there is a priest has been declared as the Hereditary Archak of the temple.
We'll hear it afternoon.
Awesome.
My lord, sir, impleading application is served yesterday.
Without the impleading application also, they are here in interim order is there, we'll hear. Yes.
In first
There's
case,
no
my lord,
interim order.
ಹೇಳಿದ್ದೇನೆ.
There is no interim order.
Interim order. He says there is an interim order.
No, my lord.
There is no interim order.
There is no interim order, my lord.
No interim order.
No interim.
Yes, this is matter after 2 weeks.
Great.
Yes, next 54.
Weeks. Seal number 54.
Lordship, in argue the matter, Lordship, pass over.
54. Waqar Ahmad.
Please.
Pass.
55.
55. Surabhi. Kulkarni. Girish Yadwa.
Filed application for vacating interim order.
Also,
Surabhi. Pass over.
Please.
56.
56. Lakshman T. Mandagani. Prashant S. Vasmani. 56. Pass over. 57.
Lordship, 57.
Yes.
Lord, in this case, they have made an application for vacating stay. I have also filed my objections to it. My lord, hearing the matter on vacating interim order would amount to, my lord, hearing the matter on merits itself. So if the matter can be heard on merits, a date can be fixed. I'm ready to address arguments on merits.
So generally, when we say vacate petition means we'll hear it finally.
Yes, my lord, then I'll file a short synopsis and then judgments, and then my lord, lordship may hear it once and for all.
Yes, 58.
Seal number 58.
The interim order may kindly be extended.
Prashant. Prashant.
Lordship may kindly fix a date, my lord, I have to come from Bangalore.
This is a matter on 25th of March.
20.
Yes.
Obliged.
Please, my lords. Highly obliged.
58.
Prashant Matapati.
What is
Sought
this?
sought for amendment of bylaws, Your Lordship. Yesterday matter was listed, today again. At his request,
This
Your
matter
Lordship.
on 19/2/2026.
At his request, Your Lordship.
What
He
is What he has requested? What is the
Amendment of
question?
bylaws, Your Lordship.
Questioning the bylaws.
Bylaws in the societies, Your Lordship, not against government, Your Lordship.
1, 4 and 5, you take notice.
Please, Your Lordship. 1, 4.
5, notice to 2 and 3. Yes, for objections, the respondent shall file their objections. Yes, next.
Admission matters number 59.
Admit.
My lords, there is urgency, my lords, sir. Liability fixed on the owner of the vehicle, my lords, and they have not deposited it, my lords. It's a pay and recovery, my lords. Liability was,
Here for whom?
I am for claimants, my lords.
When the memo is moved. What is the urgency stated on that? Just pass over.
Please, my lords.
Pass. Cell number 60. Manoj J. Raikar.
We will file a statement of objection. I am for respondent, my lord.
You want to file statement of objection?
Please, my lord.
When did you file wakalat?
My lord, recent, in last occasion,
When counsel for
take
the
notice.
seeks time to file objections, list this matter on next Friday.
27.
61.
Please.
Number 61. MM Patil.
It is a beneficiary appeal, my lord. In similar circumstances, this honorable court has
Order.
granted
Yes.
61 and
also same. 62 also same.
Yes.
Yes. 63.
notice may be ordered to private property.
Same
Okay.
order will follow.
Okay.
63.
63.
Pass over.
Shivraj Bhai. 64. Dinesh Kulkarni.
My lords, this is appeal challenging the rejection of DI application, my lords. Whereas I am having prima facie case and all the documents of the property are staying in my name, my lords.
We'll hear it afternoon. Yes.
Please, my lords.
65. Cell number 65.
Pass over.
Pass.
Yes. Start from 66.
Lordships, Lordship, on submission, Your Lordship. The court has referred this matter to mediation, Your Lordship, and the parties are present and they are compromised, Your Lordship. So it may be taken at 2:30, Your Lordships. Grateful, Your Lordships.
Any debate?
my lord. Lord, serial number 58, my lord. In this matter, yesterday it was listed, my lord, sir. Lord, senior counsel is engaged, my lord. My lord, 8, my lord.
What happened to that?
My lord, notice is issued, my lord. I asked my colleague to seek password, my lord. He has not.
What is
sought.
58?
Wherein he has sought for.
You question
bylaws.
the bylaws.
No, my lords. That is not the case. No, that is not the
Bylaws.
case, my lord.
No prayer on it.
Allah. That is my prayer, my lords. Here, what had happened, my lord?
Prayer is what we are concerned.
My lords, my prayer is, my lords, not to go with the further proceedings after, my lord, the term is over of the body, my lord. That is, my lord, senior is engaged, my lords, tomorrow, my lord.
Why did you question the rules?
My lord, that was, my lord's earlier order. I have 2 to 3 prayers, my lord. Tomorrow, my lord.
Take that. No. I'll look at it for that file and I'll see. Take that file.
Please, my lord.
Kind of, Learned Advocate General is on this.
Yes, Mr. Advocate General.
My lords, in fact, my lords, just to your lordship's concern, my lords, in fact, we had a meeting of all the departments with the chief secretary yesterday, my lords. What I have requested them is, my lord, all departments to have a nodal officer in Bangalore, Kalburgi and Dharwad, my lord, so that whenever the matters comes, one is filing of objections, my lord. Second thing of furnishing the information immediately so that we can assist the court also with regard to the information or the files.
In the screen here.
Am I audible, my lord?
1 minute. This is 1 minute. Yes.
I'll just repeat myself, my lord. I thought I was not.
It is such a unfortunate state of affairs. If you look at 100 petitions, I can tell you, not even in at least in 95 petitions, there won't be any objections. The no instructions will be given to them. No objections will be filed. Even if an order is passed, the officer will not appear before the court. That is the audacity of the officers. And let them not think that the court is.
Well, in fact, my lords, I understand, my lords. I'm fully with my lords, my lords. I'll try and fix the system in place, my lords. Just yesterday afternoon itself, we had a detailed meeting with the chief secretary and all the department. What we are, in so far as objections are concerned, what I have suggested and what the chief secretary also suggested, all the departments with regard to all the petitions which is received, online objection parawise reply should be given. In fact, I'll place it before your lordships, the minutes, my lords, of yesterday's. Within 1 week, the department has to give the objections. Not later than 1 week, from the AG's office, we have to file our objections. I'll place your lordship I'll place that minutes also.
Yes, that is within the knowledge of.
Passed an order saying that your right to file the objections are forfeited.
Yes,
we will not accept, and we will pass an order, and it is for the government to implement it.
Please, my lord.
The problem is in a writ jurisdiction, where the respondents of the state, by the time they are serving the papers in advance. The moment you have the papers, once it is sent, there should be some liaison officer in between, and he shall be placing the instructions so that we will not. Sometimes we don't grant interim orders, unnecessary litigation.
No, as your lordship rightly pointed out, what is happening once the petition is scanned, my lords? No, what is happening once the petition is scanned, my lords, once it comes to the High Court, it is also logged on to the AG's office, which also is logged on to the concerned department, my lords. So the time gap between the filing, what the AG's office gets, and the departments get is simultaneous, my lords. So therefore, we have no reason from either department or us to further delay the whole process, my lords. That is what we have built in a CCMS system by the government, my lords, to have real-time implementation, my lords. In fact, I'll place all this before your lordship.
I have already requested the Additional Advocate General to place before the court what are the steps that are taken by the government to see that everything is in place. That should be placed on record.
By next Wednesday, can I do that, my lords? By next Wednesday or Thursday,
Please do that. That is in the interest of the state and interest of the litigants. This is not the way we continue.
No, I'll place yesterday's proceedings as well as what your lordships are saying and how we are going to go in future, my lords. I'll definitely place probably tomorrow's Friday, Saturday, by next Wednesday or Monday also.
And also, please find out in this particular order why the concern was not present before the court, and what action the concern is, the higher officials are taking against him. That also I want to know.
I'll do that, my lord. I'll do that, my lord.
That I will mention.
Yes.
That I will mention.
Let's call this.
Please.
Lordship may have it next Wednesday to place in, not insofar as action taken, my lord, to what steps we have taken insofar as that is concerned.
Yes, yes.
Please.
Yes, continue.
Number 66.
My lord.
Sir, hearing big group matter.
Serial number 53, my lord, senior counsel wants to make a mention, my lord. Serial number 53. Senior wants to make a submission.
Because 53, my lord, said placed it today.
Yes.
For asking, we had agreed to provide translations, my lord, because some of the documents were in Kannada. We had to listed today. I understand, my lord, it was just called when everybody thought the court was breaking for lunch and it was called. I'm sorry, my lords.
And the first petition, the first petition, petitioner seeks time.
We
to
had
file
taken
objection.
time that the first petition, they filed impleading application yesterday. We sought time to file objections. It is adjourned by 2 weeks. It was called in the afternoon, before the lunch.
Yes.
No,
They want to find their objections to the IA, it seems.
In fact, I don't know how our matters got tagged to that 53.1 because they are seeking a different relief. Manoj, for us, there is some urgency.
Your matter is?
Manoj, 53.1, 53.2 and 53.3.
Or your matters? According to you, these three are unconnected with 53.
Look, they're not unconnected, Manoj, but I am representing the LDT trustee. The notice is issued to me. I am challenging it.
In 53.1 and 2, you are not there.
No.
Then why should we adjourn all these matters?
No, my matter can be dealing. If they want the matter to be heard, I have no objection. I sought time only in my matter, not in their matters.
53 dealing
53.2, my lord, they also challenged by the, my lord, the petitioner, very same order. 53.2, very same order challenged by the, my lord, the present petitioner.
We'll hear it when somebody is ready.
53 and 53, one and the same. Very same order challenged by the.
There are two separate petitioners who are aggrieved by that order.
The petitioner in 53 is Raghavendra.
There are family members of Dharmakarta challenged very same order. The 53.2 challenged by the Dharmakarta. Very same order.
Relation between 53 petitioner in.
They are legal heirs. 53.2 they the Dharmakarta. They are the 53 legal heirs.
You appear for whom?
Please.
You appear for whom?
Impleading applicant. In connected matter, my impleading application is allowed by this honorable court. 50.3.
And you have an objection for his impleading application?
No, because he has served it yesterday only. I have not verified whether in my case he is necessary party or not. That's the reason why I had taken time.
No, the main issue is something else. Why are we on this impleading petition? The main issue is something else.
Please.
Let him be heard. I have no problem with it. Let the impleading applicant be heard. I have no problem with that.
This when the passwords are called, call this matter.
Yes. Very well.
Yes.
Very well.
58 also, my lord.
Yes, call the list.
My lord, 58 also, my lord.
58?
Lord, I made a submission, my lord.
58 also along with passwords you call. No, call the list.
Please, my lord.
Preliminary hearing B group matter, serial number 66. Chetan Munwali.
Appear for the petitioner in the matter, my lords. On the last occasion, your lordship said directed me to serve a copy upon the panel counsel for respond number 2 and 3. Lords, I have served a copy on respond number 2 counsel, my lords, who is Shri Praveen Tarikar, and filed a memo. Lords, as per my lords, my instructions, he is also not aware, my lords, who appears for respond number 3. They have been served with the notice, my lords, they are unrepresented.
What is the relief in the writ petition?
Lords, seeking for a writ of mandamus, directing the respondents to issue the writ receipts, my lords, for having received the food items, the my lords, transported by the.
When did you supply the food items?
Lords, August 2011, my lords.
that was Millards, the receipts were not issued because Millards, one of their employee Millards had Millards, there was Millards allegations of misconduct against him. Millards, he was dismissed from service. Millards, amount was recovered from him. Millards, on that, the reason that he had not signed some of the receipts, the receipts were not issued to me, and Millards' bill has not been cleared for that month. Millards, I have produced Millards by way of memo dated 30th September 2024, Millards. I have produced the Millards receipts for having Millards transported the food items for the year month August 2011. Millards, I'm only Millards requesting to Millards direction to them Millards to issue the receipt so that Millards bill can be raised and Millards.
2011, 2026, how many years from the date you have executed the work?
I agree, Millards. Thereafter, after
15 long years.
Millards, initially it was kept pending, stating that the inquiry was Millards pending against that employee.
You are seeking this direction against which department?
Millards, all the
One and three, my lords. My lords, I have filed a detailed objections. My lords, my objection may be kindly seen. Para 3, particularly para 3 of my objection, my lords. May I take, my lords? It is submitted that the petitioner contention in the writ petition that directed the respondents to release the bills for the month of August 2011 for having supplied the food grains as per the terms of the tender. But till today, the petitioner has not submitted the bills with the necessary documents. Therefore, the claim of the petitioner was still pending before the respondent. Further, it is the duty of the petitioner to collect the receipt from the depot in charge immediately after the transportation of each load on daily basis after submitting the necessary documents. But the petitioner has not approached the respondent with the necessary documents and also fulfill the tender conditions.
You will have a counterfoil with you.
That's 2011, and that is with the respondent number 3, my lords. Deputy Commissioner, my lords, he is not having the, my lords, that documents. Here the prayer is, my lords, against the respondent number 1 and 3. 3 is served, my lords.
Is it is something, do you think that something can be done in this?
Your Lordships may see.
You want the bills of 2011?
Lords, immediately I approached Annexure J may be seen page number 36.
Doing from 2016.
Please, my lords, I'll explain that. Page number 36 may be perused, my lords. Immediately I've given a representation on 38/2000.
What are you doing from 2016 when the writ petition is filed?
Lords, it
Perhaps
was
5 years,
being listed for B group, my lords. Sometimes it did not. My lords, in 2024, there was a direction issued to the government to secure the ledger records, my lords. That has not been complied till date. It was heard and, my lords, that order was passed.
My lords, the ledger records will be with the, my lords, the respondent number 3. Deputy Commissioner has no role to, my lords, they maintain the documents and accounts. And prayer is, the assault is against the respondent number 1 and 3.
That order? That order,
please,
which you're referring to.
5/8/2024, your lordships.
5/8/2024.
24.
There is no such direction.
It is also, my lords, reflected in the cost title.
5/8/2024, the counsel for the petitioner would submit that with regard to supply is concerned, there is a entry in the inward book, but the official who was in charge did not sign the same. And action was taken against the said official and dismissed from service. AGA, you are only seeking time. AGA seeks time.
Yes.
To produce the inward book. Why did you take? Why was the AGA taking time when he was having the?
Yes. Last occasion, I made it clear before my lordship saying that this is a direction to the Deputy Commissioner. Now the respondent number 2 has been served. We are not appearing for the respondent number 3 and 2 and 3 minutes. Sorry.
What happened to the court notice?
Court notice have been served according
They have
to
been
the
served long back, my lords.
They will not come before the
Yes,
court.
they have not come.
Then we will allow this writ petition, whatever they want.
I have no objection to.
It will be binding on them.
I have no objection to allow with respect of respondent number 3 is concerned.
The petition is seeking a writ of mandamus directing the respondents to the bill due for the month of August 2011. It is the case that the petitioner, the respondents have invited the tenders for transportation of the food item. stated that during the period of supply of food items, one B. Narayana P. Senior assistant was in charge of the godown at Siriguppa. Due to unauthorized absence of the said officer from duty on 19/8/2011, direction was issued to verify the accounts and stock. Accordingly, on 26/8/2011, the senior assistant district manager and senior deputy general manager inspected the godown and submitted the report. Before conducting the inspection, complaint was lodged to the police on 24/8/2011. Based on the preliminary inspection dated 19/8/2011, for shortage of food items to the tune of rupees 20,09,873. It is allegation that the said Narayana Murthy has misappropriated the amount. Hence, a case was registered and he has accepted the guilt and agreed to pay the misappropriated amount. The petitioner submitted request letter dated 24/8/2011 and on 30/8/2011 to issue receipts for having received the food grains for the month of August 2011 to the tune of rupees 9,97,000 quintal of rice and 1,42,200 quintal of wheat, which will enable to submit the bill. It is a case that the petition has approached the respondent several times, and he has submitted a fresh request letter on 7/11/2015. Respondent 1 and 3 have personally received the communication 7/11/2015, and the said representation has been served on respondent number 2 by courier on 30/11/2015. In spite of the same, there is no action on the part of the respondents. When this matter came up before a coordinate bench of this court on 5/8/2024, it is observed that the learned AGA seeks time to produce the inward book. Learned counsel, learned AGA submits that the inward book will be with the third respondent, and the deputy commissioner has not, that will not be the deputy commissioner. The notice to the third respondent is served on, look at it, the notice to the third respondent was served on so and so. In spite of service of notice, the third respondent has chosen not to appear before this court. The learned AGA, the objections are filed on behalf of the deputy commissioner. Learned AGA, based on those objections, submits that
Para 3, my lords.
till today, the petitioner has
Yes.
not submitted the bills with necessary documents. Therefore, the claim of the petitioner was still pending before the respondent. To submit the bill according to the petitioner, that has to be issued by the third respondent. And for the reasons best known to the third respondent has not come before the court. In that view of the matter, this court deems it appropriate to allow the writ petition, and the court is passing the following order. The third respondent is directed to issue the receipts for having received the material for the month of, no, the third respondent shall issue the receipts for the material was received in the month of August 2011, and consider the as per the letter dated 7/11/2015 given by the petitioner. This whole exercise shall be completed within 4 weeks from the date of receipt of the copy of the order. There is nothing when it is served. Like you please tell him the date, you write the date. Within 4 weeks from the date of receipt of the copy of the order.
Lordships, there may be direction to respond number 1 to my lords clear the bill thereafter because they have the issued a work order.
No, first of all, this should happen. Because-
Please, further.
Yes. Like what they are saying is, because you have not given the bills, they are not doing it. If you give the bills, they'll do it.
Please, without the receipts, my lords, I cannot raise a bill.
That's why. Now, once
Please,
he gives the details, go to them.
please, obliged.
Yes,
Number
next.
67, AS party. ELR Khan, correspondence.
Present the respondent in this matter, my lord.
Being agreed by the order passed by the tribunal petition before this honorable court. my lords.
Yes.
It is the case of the petitioner is that, my lord, they are the mujawars of the property in question, my lord. That is the Dargah, P. Rabah Khan Dargah, my lords.
Any urgency for this? This is matter.
No, madam.
In the month of March. Yes, yes,
Please.
68.
68, RM Kulkarni.
Hearing for the
Respondent number 5 and 6.
For the petitioner, my lords, challenging.
Any urgency in this matter?
40 proceedings are challenged. 40 proceedings are challenged, my lord.
Subdivision of the land.
Subdivision, my lords, of it.
Section 4.
49.
A subdivision, my lords.
No, it is arising out of?
40, Tatkal 40 application to divide the properties, my lords.
Yes, this matter, no. This is matter. In the month of March.
Interim order may
69.
kindly be extended. my lords. Interim order may kindly be extended.
Interim order only granted is extended. 69.
69, Malikan Swami Hiremat, Ganapati M. Bhatt, Vishwanath Bhatt.
That's for the petitioner, Manoj. He's held up in Kotal
Worship,
7.
yesterday I moved memo.
You move the memo.
Yes.
What is urgency?
Urgency means kindly allow this repetition because he is questioning the order on I number 1 in pendants.
Move the memo. What is urgency, I said?
Since 5 years, RA is pending at the stage of argument, my lord. Since 2023,
Stay of the impugned judgment and decree.
my humble submission is at RA at the stage of argument. He filed IA1 for stay of FDP.
Ask him to come.
Please.
Yes. Yes, 70.
7.
Please, my lord, appearing for petitioner, my lord. Lord, wife's petition for announcement of interim order, interim maintenance order. 5,000 towards wife and 2,000 towards child was granted, my lord.
What is the income of the husband?
Income is 3 lakh, my lord. He is running the oil business.
According to you, according to the court, what was the income?
Please.
Where is the order?
At page 40, my lord.
40?
40, page 40. Please. Recording that income is 3 lakh only at page 41, my lord. They also filed the declaration, my lord. Even then, the order of 5,000 and 2,000 was ordered.
What is your income?
Madam?
Your income?
There is no, actually what they have said, my lord, I have no doing any business.
Have you appeared before the court?
Yes, my lord.
Then is it not your duty to tell the court what is your income?
Yeah, I filed the application, my lord, before the trial court. I declare the income.
As per that, what is your income? That's what I'm saying. So being a counsel, you should be knowing the details, what is the income of your client. Forget about what has been filed before the court. That is what the instructions required to be given to you. What is to be done now?
He's nothing doing.
Huh?
He's not, according to them, they are doing job, but actually he's not doing job.
You file your statement of assets and liabilities as per the
Yes.
judgment of Rajneesh
Rajneesh.
Sinha before the trial court. Where is that statement of assets? When will you be ready?
Monday.
This is matter on Tuesday.
Please.
Is 71?
71.
Petitioner.
Santosh Kumali.
This court, my lord, on 7/24, my lord, granted the interim order to the petitioner, subject to deposit of 8 lakh rupees. My lord. 4 lakh rupees I have already deposited. 4 lakhs, my lord, I could not deposit.
We'll vacate this day first.
They vacate agide. That is why, my lord, I am seeking permission to deposit remaining amount also.
It's not required. It's already 24 is the order.
Yes.
We are in 26. We will not give any permission now. I'll dismiss the petition on that ground.
Well, we are ready to pay. No, today only we are ready to.
Stopped you to pay till now.
No, my lord, since the order was vacated earlier, this court may kindly see. On 22/1/2025, my lord, this court did not extend the interim order since I could not deposit. Now I am depositing the remain.
Then who moved the memo?
I have moved the memo seeking permission, my lord. I want to deposit the amount before this court and seek extension. That is why I have moved. I am ready to deposit, my lord, subject to deposit.
Sir, we'll hear the
Yes.
matter.
Yes. Please. Yes.
What is implemented?
My lord, the petitioners are the purchasers of the property. My lord, respondents herein are petitioners are strangers to the respondent's family. Respondents inter se entered into a compromise. My vendors, the subject property, agriculture land, 10 acres was allotted to my vendor's share. Thereafter, in terms of the compromise decree, he was the owner. I purchased it from him. It appears from the compromise decree that my vendor had to pay 8 lakh rupees, the subject that I'm now depositing. My vendors, it is my vendor's responsibility. He was supposed to pay 8 lakh rupees to the sisters. He did not pay. Now, see, in terms of the compromise decree, sisters instituted execution proceedings. In the execution proceedings, even though they knew that I have purchased the property, they wouldn't make me as a party. Thereafter, they file an application for impleading. Notice is issued to me. I have not yet appeared. Even before appearance of notice, my property is attached. That attachment order I have challenged. Yes. 21/9/2024.
Page number.
Yes. Page 115. The notice on impleading application was issued on 18/1/2024, and the notice service of notice was awaiting. And on 21/9/2024, the executing court passed in order under order 21 rule 43 attaching the property that is sold to me. Now, my lord, I am ready to pay the 8 lakh rupees that my vendor was supposed to pay. 4 lakhs I have already deposited.
For what amount they have filed the execution?
Yes,
Only for 8 lakhs they have filed the execution.
they have filed only for 8 lakh rupees. I have already deposited. But my lord, subject to outcome of the writ petition, I am deposited, not because it is my vendor's liability, not my liability.
Then why are you coming?
Yes, my lord, because my property is attached now. Now property is attached now.
That now they are neither here nor there. But
Yes.
you will come and you will litigate now.
Yes, my lord, my impleading application is.
You feel you recover from your vendor, but if they have filed the EP, why should we stall these proceedings on you depositing? If it is lying in this court, what is the benefit to them?
Yes.
And happily you're enjoying from 24.
Yes.
24 you're enjoying here.
I am the purchaser, my lord, from the in terms of the compromise. That is the difficulty.
Get instructions.
Yes.
Tomorrow.
In the meanwhile, maybe I am permitted to deposit remaining 4 lakhs.
My lords, they have not.
4
paid-
lakhs.
They have not paid as per the order 7/11/2024.
I will dispose of this matter. Tomorrow he says he wants to let him deposit.
Please.
But what is the IA?
Which I present.
You have not passed, you have not filed, just move the memo.
No. I am seeking permission to deposit. That is.
Orally.
Yes. No. I mean, like, since order was vacated, my lord, without the permission.
What I'm saying.
Yes, I will. Yes, tomorrow along with memo, I'll.
These are all CPC proceedings.
Yes.
Under
Yes.
the CPC.
Yes. Tomorrow along with memo, I'll come, DD, please.
Tomorrow.
Please, oblige.
20th. Seal number 72. AC Chaklabdi, Venkatesham Kharvi.
Seeking time, my lord. Same order has been passed, my lord. Balance amount regarding that pending before the. We have filed the divorce, it is in a cross examination.
Page number 16, my lord. Impugned order, my lord.
Seeking
Only
on
one
time
reason has
regarding
been
the
given, my lord. We have filed the further proceedings stay application in the MC petition, my lord. The
Where is the order?
page number 16, my lord.
Page number
16, my lord. Page number 16, my lord. Middle portion, my lord. No application is filed for the respondent wife seeking the interim maintenance and maintenance amount was awarded to the respondent under section. Page number 16, middle portion, my lord. So only one reasons has been given, my lord. It is 125 proceedings maintenance.
Therefore, unless complaint state for there is no dispute regarding, no application is filed by the.
In respect of 125 maintenance has been awarded in civil petition, you cannot file it. That is the only reasons, my lord. My lord has passed the similar order already, my lord, in respect of.
Let me understand the facts.
Please, my lord. My lord, in 125 proceedings, my lord, this is the wife petition, my lord. The 125 proceedings has been awarded 8,000 rupees per month, my lord. So more than 2,92,000 is pending as on the date of the filing of the application. Husband has filed the divorce petition, my lord. He has proceeded in the divorce petition. He has not paid the maintenance petition before the same court, my lord.
This is pending before which court? This
Same
is also
court,
before the
same,
family.
please, same court.
No, my lords. Can
Criminal
we
order
seeking
has been
time,
passed,
we
my lord.
making arrangement. After the last week, my lord, we have paid, my lords.
No arrangement. Make your own arrangement.
So, my lords, we have,
Time the court, this is
Alla,
the-
we make.
Now
a
4,20,000 is
last-
pending, my lord.
Study up, last ಹೇಳ್ತೀನಿ. Last, my lord, 2 weeks back, we have paid deposit 20,000, only remaining 1,30,000, that is enough, my lords. Make chances, have it on first week, my lord, anything.
You're saying as if I have paid 1,20,000, what remaining is only 20,000.
No, my lords, total balance is 3,18,000. 3,18,000, out of that,
Party sum and you say that only that is pending.
no, it's only 1 lakh, okay, no, my lords. Have it on March, my lords, we will make arrangement, my lord, to deposit them.
Agreed with
My
all
lords,
the past nine.
my lords,
I number
my lord, we are making time.
in
He's
MC
working,
number.
my lord, he try to make effort to deposit the amount, I know. So kindly list it down, my lords.
02 of 2023 dated 13/11/2024. The wife is before this court. Parties are referred to as wife and husband for the sake of convenience. The husband has filed MC number 102 of 2023 seeking divorce. The wife has also filed criminal miscellaneous seeking maintenance in that.
This is the recovery
Court has
proceedings.
granted.
In criminal miscellaneous, my lord.
Miscellaneous is disposed of.
It is disposable.
The court has
Recovery
granted
proceedings is passed.
insurance to the wife. Now the present application is filed under 151 CPC to stay all further proceedings as the wife has failed, the husband has failed to pay the maintenance as awarded in the criminal miscellaneous. The court by order impugned had dismissed the IA that is filed by the wife. The court has observed that the criminal proceedings are different and she has already initiated appropriate proceedings to recover the amount. Therefore, on the basis of the pending proceedings, the present case cannot be stayed. Accordingly, the court had dismissed the IA filed by the wife. Legal counsel appearing for the wife submits that the husband who has filed the MC is proceeding with the proceedings, is appearing and is contesting the proceedings. When it comes to the recovery proceedings, he is not appearing before the court, nor he is paying the amounts. He has no respect to the orders of the court. He had relied on a order passed by this court
In WP.
passed by an order passed by this court in WP number 103725 of 2021 dated 4th November 2024, wherein this court has
Same matter, my lord, similar.
has passed an order and observed that the court has to consider the conduct of the parties and cannot permit the litigant to abuse the process of law. When there is an order against the husband and when it has attained finality and when he is not paying the maintenance and wants to proceed in the other matter, the trial court should have exercised its discretionary power I should have stayed the proceedings in MC number 218 of 2019, which is in the process of doing substantial justice, and the trial court has failed to exercise the same, and accordingly, the court had stayed the proceedings. Relying on this judgment, this order, and counsel submits the order that the court ought to have stayed the proceedings in the MC till the maintenance amount is paid by the husband. Land counsel appearing for the husband submits that recently they have paid an amount of rupees 20,000 and they'll make all efforts to pay the outstanding amount. It is further submitted that if the proceedings are stayed, already this is an MC of 2023 and that would cause a lot of hardship to the husband. Anything else?
No, my lords, because my lords, if the order of this honorable will pass the orders, if we have paid the entire amount within 4 weeks, then the proceedings may be continued.
That is what?
Because recovery proceedings is in respect of the 8,000 only, my lords. If I close this,
If you pay the outstanding amount, whatever is in the EP proceedings,
please.
court will proceed.
Yes,
That will make it
that
clear.
may be passed, my lord.
The next one, having heard the counsels on either side, there is a material on record. No doubt, the maintenance is granted in criminal proceedings, which is under 125 CRPC by the very same family court. And MC proceedings are also pending before the family court. The practical difficulty in these matters, the practical difficulties faced by the litigants in these kind of matters are the husband will file the MC divorce, wife will seek the maintenance under 125. 125 an order will be passed, and the husband, when the recovery proceedings are initiated, the husband will not cooperate with the same. But however, he will be prosecuting the petition that is filed seeking divorce. In those circumstances, this court, considering the plight of the parties, in several cases have already passed an order that under section 151 of the CPC, the court has a discretionary power for doing substantial justice to the parties to stay the proceedings. As the proceedings before the criminal miscellaneous before the very same court are between the same parties, and the court cannot permit the litigant to abuse the process of law. In that view of the matter, this court is passing the following order. The order dated so and so, passed in so and so, is set aside, and the IA that's filed under 151 CPC is allowed. Number 2, once the husband pays the outstanding amount that is granted in the criminal miscellaneous, the court shall proceed.
Please.
With the MC.
Please. Much obliged.
Seal number 73 adjourned. Seal number 74. Kolkar, Syed Ahmad, Intesham Kharvi.
Please.
I'm for petitioner.
Yes.
My lord, I have challenged the interim maintenance order
Yes.
passed by the Honorable Civil Judge JMFC Court of Mandura in criminal miscellaneous number 47/2021, my lord.
All that is not necessary.
On
You are
the-
for the wife or husband.
My lord,
You are for the wife or husband.
I'm for husband, my lord.
What is the
On
order?
the
if you-
ground that, my lord, during existence of subsistence of a first marriage, she got a second marriage, my lord. Without considering the second marriage, the trial court has passed the judgment order, interim order to pay the maintenance to the husband, my lord. My lord, may kindly be perused, my
During
lord.
the subsistence of the first marriage, if you contract the second marriage, then the court should not grant maintenance.
Yes, my lord.
Who has contracted the second marriage?
Wife has a contract the second marriage, my lord.
What is
My
the
lord,
material?
my lord,
before the court?
my lord, may kindly be perused, my lord. I have produced numbers of documents before this honorable court, my lord. The first marriage of the petitioner and the respondent took on 29/5/2021. First marriage, my lord. Second marriage, my lord. After the marriage, my lord, the petitioner and the respondent was started to residing in the rented house of the Maulali son of Khadar of Harkoni, who is second husband of the respondent, my lord. Now,
The material.
my lord, may kindly be perused. I have produced numbers of documents.
Only allegation, my lord.
It is not an allegation.
Only allegation,
It is
no
not
marriages.
allegations, my lord. My lord, may kindly be perused, sir. I have produced numbers of documents. Annexure A, marriage card. First, the marriage card of the first marriage card of the petitioner and respondent, my lord. Second, second annexer B, my lord, the second marriage court of the petitioner and the respondent, my lord.
Where did you get it? Where did you get it? Page number?
Page number, my lord, 23, annexer B, my lord. She got second marriage on 2/5/2021 at Belgaum, my lord. Annexer B. Annexer A, page number 22, my lord. She got first marriage on 29/2/2020, my lord.
What is your submission on this?
My lord, submission is, my lord, as per the 125, divorced wife is entitled for maintenance till her second marriage.
When she married?
She married, she not got a second marriage, my lord. It is an allegation. Criminal case is pending before the Belgaum court. So divorce was, my lord, granted on 28/11/24, my lords.
This alleged marriage is when?
Alleged marriage is, we are not admitting the alleged marriage, my lord. This is not marriage. Yes, only allegation by a false case, my lord, criminal case is filed.
It is on 2nd May 2021. When was criminal miscellaneous for maintenance?
That is filed on, my lords,
49/2021, my lord.
by 21, my lords.
14/9?
No.
49/2021, my lord.
That is order, my lords. Filed on 2021.
21.
Filed on
Affidavit before the court that you are not married.
Please, my lord.
File an affidavit before this court that.
Please,
you-
my definitely. I filed. Yes, Monday. It is posted on Monday, my lords.
This
Monday.
morning, it is an allegation of the petitioner that she has got.
My lord, I have produced numbers of documents because of I want to argue in lengthy.
What are those documents you have?
Because of my lord, already they are prosecuting, they are facing a trial before the second JMSP court of Belgaum, my lord.
You understand?
And
At this,
and I'm
listen to the court. At this point of time, what is the evidence on record?
Yes,
Now,
my
the
lord.
card which you are showing.
Yes, my lord.
The card can be printed by anyone.
Yes, my lord.
Apart from that, what is the evidence?
Yes. This is my humble respectfully submission before this honorable court. I am producing rulings also, my lord. I have brought.
Kindly have Monday, my lord.
Monday, yes, my
I'll
lord.
file the affidavit.
This is matter in the month of March. By the time
My lord,
the-
kindly let on Monday, my lord, because from 2021, I am not getting any income, my lord.
Question of
That is the
paying
question, my
maintenance
lord.
does
I'll
not
file the
arise, my lord.
affidavit.
The list is in a, list it on 3rd of March. The petitioner by the time.
My lord, I am suffering,
Stay
my
order
lord.
may can be
Wife is
extended,
suffering,
my
my lord.
Stay order may can be extended, my lord.
I have no patience to hear this.
Please.
My lord, stay order may can be extended.
By the time, the respondent shall file an affidavit before this court that she is not married the second time. She didn't contract the second marriage. Yes, after the divorce. Yes.
Next week, any date, my lord.
Stay order may can be extended, my lord.
This interval only granted is extended. Next.
My lord, what happened, my lord? Earlier 2025 interim order was granted.
My lord, stay order may can be extended.
From 1 year, I am suffering, my lord.
Yes. Next.
Even though there is no provision, my lords.
Yes, next. 75. Yes, 75.
Please, your lordships.
Propose respond
The
number
matter
5.
pertains to my lords, the Waqf impugned order is at page 58, your lordships. Page 52. Now, this is an order passed by the Karnataka State Board of Waqf, constituting a managing committee, my lord.
Where is the order?
52.
50?
2.
Yes.
But this order is passed by the Karnataka State Board of Waqf, constituting a managing committee of 11 members, my lords, for the management of Kanjigarpet Masjid, situated at Vijayanagar district. The impugned order, my lords, passed on 25/2/2025 without issuing a, my lords, public notice to the members, and this is a violation of principle of natural justice. Among the 11 members, my lords, there are 4 members who are, my lord, disqualified to be to become the member of the committee, as per, my lords, form number 42. Numbers,
Who appears to the Waqf court?
I am appearing, my lord. I am for
Have you
responding.
filed your objections?
I have not yet filed.
my lords, since this matter is, my lords,
Why it is not required?
No,
When
my
did you
lords.
File your wakalat.
Objections are required, my lord. I have called for the statement of Parole comments on that.
When is it reserved? 6/11/2025. The
my lords,
respondent is a Waqf board.
my lords, since, my lord, the interim order is passed in this matter on 20/11/2025, my lords, this interim order is passed.
Second respondent. They'll file the objections by the next date of hearing, or else the right to file the objection will be forfeited. The interim order earlier granted is extended till then, just to the month of March. Yes,
My lords, some
76.
early date may be given, my lords.
I have an interim order.
Still, my lords, that is not in my favor, since because,
Interim order.
yes. Lords,
After appointing of the managing committee, my lord, these people having no locus approach this honorable court, my lords. My lord may permit me to, my lords.
We'll see.
my lords,
Yes.
let's hear this matter on merits, my lords.
On 11th of March.
11th.
Yes,
Please, interim order may be extended.
yes.
Please, grateful.
Seal number 76. Send Rajendra.
Plus challenging annexure J, the impugned order, my lord, on the interlocutory application for interim maintenance, my lord. My lord, without hearing the petitioner, my lord, this order came to be passed. My lord, on 6/2/2025, now my 25,000 has been ordered to pay without any basis, my lord.
What is your salary?
I have no job, my lord, because, my lord, the wife has filed a criminal case against the,
Have you filed your statement of assets and liabilities before the court?
it was filed, my lord.
Has he filed?
My lords, internal page number 7, my lords. The order, my lords. If your lordships may permit, I kindly be permitted to read, my lords. I permitted to read, my lords, the impugned order, my lords.
Page number.
My lord, before that, my lord, there is a violation of principle of natural justice on 6/2/2025. My lord,
My lords, one wife is there. There are 3 children, my lords. One is mental retired, my lords. He is not physical and mentally able, my lords. There are 3 children, my lords. And in fact, my lords, order was, maintenance was ordered.
In this writ petition.
The interim maintenance, my lords.
So no, interim order is granted
Yes.
on condition?
On condition that, my lords, he'll deposit every month 4,000, my lords, to each of the petitioner to the.
That is 12,000.
Yes.
16,000.
16,000.
When was this order passed?
My lords, order was passed on, my lords.
Is he depositing the money?
He's in depositing the money.
Yes.
My lords, one humble submission, my lords, the amount in deposit, earlier what has happened, my lords, this court had ordered, my lords. Kindly see, my lords, order dated 18/9/2025, my lords, this court order, my lords.
18/9, yes.
18/9/2025, my lords.
Uh.
My lords, I'm not against the, he's depositing regularly, my lords. Only thing is that, my lords, the amount in deposit in the registry, my lords, may kindly be released in favor of the mother, my lords.
The respondents.
Mother and the second respondent, they are major, my lords. They have been, their amount has been released, my lords. Only thing is that respondent number 3 and 4. 4 is concerned, my lords, he is mental retired. And 3 is concerned, my lords, he is minor. On behalf of their, my lords, their amount deposit may kindly be released in favor of the mother, my lords.
The registry director to release the amount granted to the petitioners number 3 and 4. And the mother, that is respondent number 1, is permitted to withdraw the amount.
Madam,
Archana, the mother is named Archana, my lords. First respondent.
Yes, this is matter in the month of April.
Obliged.
Interim order earlier granted is extended.
Grateful.
Yes.
Seal number 78 urgent, seal number 79. Neelendra D. Gunde, AGA, GV Bharmagowda.
Serial number 77, my lords.
77.
Sorry, 77.
Yes.
Have it on Monday, my lords. He's engaged in 7.
This is matter on Tuesday.
Interim order, ma'am.
Interim order earlier granted is extended. Yes.
Obliged.
79.
Is 79
Seal number 79.
in the month of March.
Neelendra D. Gunde, March.
80.
Seal number 80.
For the petitioner, your
Already.
lordship. So it was filed by the petitioner and respondent by your lordship, and we have filed a written statement along with the counterclaims, your lordship. The respondent have not filed a rejoinder within a stipulated time, your lordship. They have filed after delay of 1,108 days. That application has been rejected, your lordship. Based on that, they are.
Come to the impugned order. Where is it?
Annexure F, your lordship. Annexure F, page number
51, my lord.
51, your lordship.
Read it.
The suit filed by the plaintiff is for partition in separate possession. On 26/7/2021, defendant number 1 filed written statement. The counterclaim sought for by the defendant number 1 is that the counterclaim properties are also joint family properties and same been purchased out of nucleus of joint family, and these properties are shown in the plaint intentionally by the plaintiff. The plaintiff and defendants are having equal share in those properties. I number 11 filed on 2/9/2024 after lapse of 3 years after counterclaim was filed. The reasons assigned that after defendant number 1 filed counterclaim and the plaintiff could not contact the counsel to give information. Written statement to counterclaim is consent as per order 6A3 CPC. The plaintiff shall be at liberty to file written statement to the counterclaim within the time fixed by the court. As per the order sheet dated 26/7/2021, the defendant number 1 filed I number 3 along with written statement seeking permission to file written statement, and said application has been allowed on cost of ₹100. Then the case has been posted for the written statement to counterclaim. Then on 6/9/2021, case has been adjourned for the reason learned counsel for the plaintiff absent. On going through the order sheet, written statement to counterclaim is not taken as not filed. On the other hand, the suit filed by the plaintiff is for partition. The plaintiff,
What is the prejudice that is caused to you by allowing this application?
the only submission is that your lordship, they have not filed within stipulated period, your lordship.
It's a suit for partition, there is a counterclaim. Then some of the properties are shown as the joint family
Please,
property.
even after giving an opportunity, your lord.
Adjudicated, no prejudice at all. Come, agreed with orders passed in I number 2 in 7 of 2021, dated 4th December 2024 by the senior civil judge and JMFC at Elbuka, the petitioner. The petitioner defendant is before this court. The IN number 11 is filed with the plaintiff seeking permission to file written statement. The respondent herein knows the plaintiff has filed the suit seeking partition. In that, the defendant has filed objections to the written statement and also has filed the counterclaim. As per the counterclaim, the counterclaim properties are also joint family properties, same being purchased out of the nucleus of the joint family. These properties are not shown in the plaint intentionally by the plaintiff, but the plaintiff and the defendants are having equal share in those properties. The plaintiff has not chosen to file the written statement to the counterclaim. Later, the written statement has been filed, denying the version of the defendant number 1, contending that those properties are the self-acquired properties. The court has felt that in these circumstances, where the rights of the parties have to be substantially decided, had permitted the plaintiff to file the objection written statement to the counterclaim that is questioned by the defendant before this court. When counsel appearing for the defendant submits to the court with the said inordinate delay ought not to have allowed the application, it is submitted that the defendant has not even chosen to state on what basis or why the delay has occurred. When the plaintiff is not very vigilant, court ought not to have come to the rescue of the plaintiff. When counsel appearing for the respondent, plaintiff submits that the court, considering the substantial interest of both the parties, being a suit for partition, has rightly allowed the application. And there are no grounds to interfere. Next, have further counsels on either side. There is some material on record. The suitors for partition, the defendants have to file a written statement and also a counterclaim stating that some of the properties are not included and partition has to be, there should be a partition in respect of those properties. No doubt there is a delay on the part of the defendants in filing the written statement, the plaintiff in filing the written statement. Later it has been stated that those properties are the self-acquired properties and the same cannot be partitioned. In the backdrop of these facts, where the rights of the parties have to be decided, Now, by allowing this application, no prejudice would be caused to the defendant. And the court has rightly allowed the application, and this court finds no reasons to interfere. Accordingly dismissed. Next.
Grateful, my lords.
Seal number 81.
May I seek
81?
pass over, my lords?
Yeah,
Kindly pass over, my lords. Senior is held up in another court, my lords.
Any urgency by you?
This impleading application is filed,
Huh?
impleading application is filed in execution proceedings. So there is no executable decree against the petitioner. And the petitioner has already filed a separate suit for declaration portion in respect of the suit property in annexure A and B.
Shall we have it tomorrow? Tomorrow?
Yeah.
Tomorrow.
Next, my lords.
Tomorrow?
Please.
Yes.
My lord, interim order next. Interim order.
Tomorrow earlier granted is extended. Tomorrow no passos.
Please, my lord.
My lord, the interim order is absolutely not necessary because he is not affected by an order.
You come tomorrow, we'll decide it.
Please.
Right.
Seal number 82.
Lord, I am appearing for respond number 2, tender accepting authority. Lord, the petitioner here in challenging, only, Lord, seeking for mandamus to consider their representation.
No, my lord.
Lord,
May I please to, may I please to allow, my lords. Wherein, my lords, I am seeking to issue the fresh tender notification. Where the
Kindly-
tender was, my lord, lapsed, my lords.
Come to your prayer.
Page 9, my lords, may I request, my lords? Writ of mandamus, any other directing the respondent number 2 to issue the fresh tender notification relating to the procurement and supply of furnitures to the various libraries of the Gram Panchayats of Belgaum district by considering the representation.
So it is twofold. First of all, they have to consider the representation. What they should do with that, they will decide.
Please, my lords, my submission may permit it.
If this order, if you require a direction to them to issue fresh tender notification, question of considering your representations will not arise.
My submission to this honorable court, my lords, wherein, my lord, tender issued in the month of July, they, my lord, after lapse of period, my lord, they're calling for the samples, my lord. That is the grievance. Being agreed by that grievance, my lord, I given them representation, my lord. Till today, that no action was initiated. Hence, I am before this honorable court.
We will ask them to consider the representation.
Please.
But there can't be any positive direction. We'll ask them to consider the representation.
Leave to your lordship, my lords.
The present petition is filed, seeking the following prayer. It's a case of the petitioner that the petition is a proprietary concern, is engaged in the business of manufacturing and sale of the steel furniture. Respondents have issued a tender notification dated 13/7/2025, inviting the tenders through e-procurement portal. Approximate bid value of the said tender was fixed at rupees
477 lakhs, my lord.
477 lakhs. And the last date for the submission of the tender applications was 4/8/2025. The petitioner, in response to the tender notification, has submitted his bid. It is stated that the tender notification was published on 30/7/2025 as per Rule 22(3) of the Karnataka Transparency in Public Procurement Rules. The bid validity is by a period of 90 days, that is 29/10/2025. And to this effect, the respondent number 2 in the tender notification also has mentioned that the bid validity period is 90 days. It is a grievance of the petitioner that the respondent number 2, who is the tender inviting and accepting authority, instead of completing the entire tender process within a period of 90 days, which was a bid validity period, without any justifiable reasons, caused a delay in completing the tender process within the said period. And after lapse of the bid validity period, issued the communication dated 29/11/2025 to the petitioner by intimating that the fresh date for production of the samples of the materials is scheduled on 3/12/2025. Hence, the petitioner, in this regard, the petitioner has given representation to the respondents dated 5/12/2025 and 8/12/2025 to call for the fresh tenders, and as the same was not considered, he has come before the court. You appear for which respondent?
Well, it's our second respondent.
What is your submission?
Well, my submission is that, Lord, because the petitioner here in seeking only the mandamus to consider the representation, that will be considered and disposed of in accordance with law.
They'll consider the representation dated 5/12/2025 and 8/12/2025. Accordingly, this court is passing the following order. The writ petition is disposed of, directing the respondent number 2
Please.
to consider the representation dated 5/12/2025 and 8/12/2025 within a period of 1 week from the date of receipt of the copy of the
Milord, at least 2 weeks, Milord.
2 weeks, because that's good for you.
Please.
Because you have to again,
Yes, ma'am.
whatever procedure you want to do.
Yes.
Please, great.
Please.
Yes, 83.
Kindly, with my lords, kindly. But serial number 81, my lord was pleased to post it tomorrow, my lords. Today itself I was ready, I was held up in the other court. It will be taken up on Monday, my lords, 81, instead of tomorrow, because tomorrow and day after.
Insisting the other side.
I'm sorry, I was held up in the other.
Not arguing today, at
No,
least
no,
you have to argue
I am ready
tomorrow.
even today, my lords. I was held up in the other court.
Why not tomorrow?
Monday.
Why not tomorrow?
Tomorrow I'm not in station. Tomorrow and day after I have some personal inconvenience.
Then where is the advocate?
I will intimate him, lords. Monday I will address.
Monday. Yes, next.
23. Seal number 83.
My lord, there is sole respondent, I will undertake to file wakalat for him. Today they have informed to take notice for him.
So insist submits that he has instructions to file wakalat on behalf of the respondent. Interim order is there?
Yes, if there is.
Interim order earlier granted is extended just in the month of March.
Please.
Yes, next. Continue. Till part third will hear, final hearing matters will give some other date. Only part third you call. Part third, further hearing and part third. Yes, 84.
84. Anjaneyam.
My lord, insurance company is also.
Appeal is there.
Appeal, my lord. Appeal Before by the the division bench, my claimant. lord.
The list this delete from the caption for the further hearing. List along with so and so. which
That is
pending
kept
before-
below, my lord. Kept below, my lord, in the list itself.
The list before the division bench, along with MFA number 102160. Yes.
Please, my.
85.
85. Nagarasi Kalluri. Sunanda P. Patil.
My lord, it's an insurance company appeal. We have challenged both liability and quantum, my lord.
Yes.
Liability ground, that is the DL point, it has
Yes,
vanished. On injury, my lord, the quantum, whatever they have awarded, it's
Come
on
to the
the,
table.
my lord,
Table.
page number 32, my lord, of the judgment, in page number 39.
What are the injuries?
My lord, as per the wound certificate, my lord, exhibit P5, my lord,
Yes.
the injuries are two, my lord. One is CLW over the occipital region and abrasion.
Fractures.
Nothing was mentioned, my lord. They are claiming that it's an head injury. They have took treatment before KLE, then subsequently has admitted with the private hospital and obtained the
Is pain and suffering as it is. Medical expenses.
my lord, that pain and suffering is on higher side. They have admitted only 13 days in the hospital, my lord.
No, pain and suffering is not about it. One fracture injury, 40,000.
My lord, there is no fracture injury at all. There is no fracture injury at all.
Head injury is a more than a fracture. Yes, next.
It is mentioned in the exhibit P5 itself. Your Lordship.
20% disability considered by.
Let's go, come to the table. We have to calculate, isn't it? Look at it. So forget about the first future loss of income. Pain and suffering, then medical expenses. Look at the table. 1,99,300. How many days he was in hospital?
13 days.
Huh?
13 days.
Then why did the court grant 20?
20. Please.
Court grant 10 and 10, conveyance and attendance charges.
Please, my lord.
It has to be
He has-
1,000 per day.
My lord, 2015 accident it is. 2015 accident, and he has medical bills of 2 lakh rupees, your lordship.
Incidental expenses, how many days you said?
My lord,
He was in hospital for 15 days.
13 days.
13 days, 1 3 days.
13,000 under the incidental expenses. Then coming to the disability, loss of income during laid up period. Which year is the accident?
2015, your lordship.
What is the income?
8,000, your lordship. It is correct one.
2,000?
8,000.
8,000.
It is correct, my lordship. Your lordship may kindly be see that it is, he has sustained diffuse external injury, that is grade 3. That is, it is a traumatic brain injury, your lordship.
Court granted 16,000. I wanted to grant 24,000. Shall I give you only 16,000?
No, no, my, I'm not saying. Regarding the disability, I am submitting, your lordship.
You have to complete this. No?
Please, please.
Go to the next one.
Please, my.
As far as loss of future income is concerned, come to the discussion in the order.
Doctor has assessed 50 to 55% to.
Where is that?
My lord, it is clearly discussed by the
On
court
page number
below in
35.
page number 26 and 27, my lord.
Page number 30, page number 25, it starts.
Paragraph.
No, paragraph number 15, but on page number 25, your lordship, 7th line from the bottom. The petitioner in order to prove.
Come to page 20 bottom. The petitioner in order to prove that.
Please, my lord, on account of accidental injuries. May I read, my lord? On account of accidental injuries, he has suffered disability, has examined Dr. Vishnath Girimalappa, who called in the consulting neurosurgeon BHS Lakeview Hospital, Belgavi as PW2. In his evidence, PW2 stated that on 9/6/2015, the petitioner was admitted and treated at BHS Lakeview Hospital, Belgavi from 10/6/2015 to 23/6/2015. He further deposed that the petitioner visited to him for assessment of permanent physical disability certificate on 27/7/2019, and accordingly he has examined the petitioner in detail by going through the medical records of BHS Lakeview Hospital, Belgavi, un certificate, discharge summary and past and present MRI scan reports, and found that the petitioner has sustained injury CLW over occipital region and abrasion or face. PW further deposed that on going through the MRI scan dated 10/6/2015, the petitioner had sustained multiple hemorrhagic contusion in left frontal lobe, right centrum, semiole, bilateral temporal lobe, posterior limb, and left internal capsule and right middle cerebral pedicule, FSO, grade 3 diffuse external injury, and was given conservative treatment. He further deposed that on examination he found that the petitioner complained him intermittent headache and giddiness, sleep disturbances, loss of concentration, and irritable behavior, difficulty in doing laborious work, right hemiparesis, ataxia. On clinical examination, PW2 opined that patient is suffering from intermittent headache, giddiness, sleep disturbances, loss of concentration, irritable behavior, difficulty in daily labor work, right hemiparesis, ataxia, and his physical intellectual function are impaired and amounting to 50 to 55% disability as per Dr. Wilkins and Dr. Shetty.
Any amount on this, the matter has to be remanded to the court. What is this evidence? He takes conservative treatment. Nothing. How the disability will be assessed? What are the documents? What are the basing on what he has come to this? Nothing.
Your lordship may kindly say that diffuse external injury is a traumatic brain injury, which is a very serious injury, my lord. In the in this injury, the brain of the person will be rotated in the skull, your lordship. As per the medical.
He says that while giving the certificate, he has not verified any of the documents.
My lord, he is a treated doctor, one thing, and he was taken the certificate.
I'm reading at page 27 from the order.
Your lordship may kindly be see, he never stated that in the cross-exam, the suggestion to the cross-examination in the, to PW2, your lordship, by the council itself, that he was treated by the patient. Your lordship may kindly be see.
This is evidence of PW2, and in his cross-examination, PW2 admitted that.
No, it is not admitted, your lordship.
Getting treatment from the KLE hospital, the petitioner was admitted to their hospital.
Your lordship may kindly
stated that he has given only conservative treatment to the petitioner, and at the time of issuing disability certificate, he has not verified the medical documents.
Your lordship may kindly see that the accident was on 9/6/2015, and on 9/6/2015 he was admitted in the BHS Lakeview Hospital, and PW2 is the neurosurgeon in the said hospital, your lordship. And 9/6/2015 to 23/6/2015 he was admitted in the BHS Lakeview Hospital, your lordship. I will read the cross-examination of PW2, your lordship.
PW2.
Pardon, PW2. I will read the cross-exam.
PW2 is saying that he has not verified the medical documents of the petitioner.
My lord,
say that this observation of the court is wrong.
Please, your lordship. That's why I am submitting before this honorable court.
Read.
Please.
Cross-examination ಇಲ್ಲ ನಿಮ್ದ್ರಾಗ ನೋಡಿ ನೀವು ಫೋಟೋ ಹೊಡ್ಕೊಂಡಿದ್ದು ಅದಾವ ನಿಮ್ದ್ರಾಗ ನೋಡ್ರಿ
ಕೊಡಂಗಿಲ್ಲ.
ನಾನು ನೋಡ್ತೀನಿ ತಡ್ರಿ ಒಂದು ನಿಮಿಷ.
ಇಲ್ಲ. PW2.
Where will you find the PW2 there?
Pardon, my.
Where from you will have that evidence there unless and until the.
He has given yesterday, but now he is not ready.
It's your duty, madam. You have to bring. I have
One
given
submission, Your
yesterday
Honor.
only.
Your Lordship may kindly be see that in the chief examination para number 2, I am a consulting neurosurgeon at BHS Lakeview Hospital, Belgavi.
Please pass on.
Please.
Where did he say? Why did the court had wrongly recorded that?
It is.
They have stated in the last third para, my lord, he has not gone through the documents of the KLA and other.
It cannot.
Why, that is not.
In the
no, no.
cross-examination, my lord.
Yes, I've seen it. He says.
He never stated so, my
Issuing
lord.
the certificate,
The
my
observation is not correct. That is my submission.
Please wait. I have referred the medical records, wound certificate, discharge summary, past and present MRI scan reports before issuing the.
Subsequently, in the cross-examination, my lord,
It is in the cross-examination.
I will read that para, my lord. Basing on that, court can pass any order. I have no objection regarding that one. Whatever observed by the court below regarding the.
He says it is true to say that the petitioner was not given any
Follow-up
treatment regarding the so and so. So at some hospital at Belgavi. True to say that I have given conservative treatment.
Yes,
to
my
the
lord, that is
petitioner.
the observation made by the court.
It is conservative.
No, it is about, he says that the other reports are all looked into and then only he has given the.
Just pass. I will read that para, my lord.
And he is a treated doctor, your lordship.
Both of you read it tomorrow. No time, I have other matters. Yes, next. Yes, Monday. Yes, next.
Bill number 87. Patel Teli.
Request it on Monday. I could not bring a file on Monday, my lord. On Monday, I requested, my lord.
This is matter in the month of March.
No, my lord, it is already parted matter. So it can be taken on Monday.
You don't have, but then you should be ready when
No,
the
sir.
matters are listed.
Today I could not
How
bring
many
file.
times the matters will be listed? Like delete from parted?
No, sir, interim order may be extended.
One submission, my lord.
Entire order may be extended.
May I make the date, my lord? May I request for date,
Matter on 9th of March.
please? My lord.
Yes,
Interim order may be extended.
yes.
Final matter 88
All those matters adjourned.
for dismissal. 89.
So where is 89?
89.
One submission.
18. Last date, the last date, my lord, I was. Serial number 89. The last date, I was a little late to the court, my lord, on that time.
Yes, yes. What about this?
This is, my lord, the order passed by the labor court, wherein the disciplinary,
Switch on the mic.
please, ma'am. Disciplinary authority has imposed punishment, reducing the basic pay for 3 incremental stages, my lord. Wherein the, my lord, labor court,
So this has to be heard finally.
date, my lord, date, maybe.
This is matter, month of April. Delete from the capital for dismissal. Yes, next. Please call the matter. There is no 230 matter. Where is it? Oh, call that.
230 matter. Preliminary matter, serial number 1. Vidyashankar Ji Dharwad.
Please. Milords, challenging the extrement order, Milords, only on a ground that my marriage was fixed early only, Milords. Tomorrow is the marriage, Milords. Kindly more for a short time, Milords. Milords, annexure, Milords.
Not show that kind of interference at all.
Please.
You have marriage somewhere where we're outside the place.
Milords, already cards were printed, Milords. That's why I filed, Milords. Another 2 were my brothers, but that I have almost withdrawn, Milords. But regarding this one, Milords, with the humble request, Milords.
Against the order passed by respondent number 2, you can go to respondent
Yes,
number 1.
yes, Milords, I agree, Milords. But for tomorrow, Milords,
You should have asked respondent number 1 the same thing, what you're asking this court.
please. But their marriage was not there, Milords. Because of this, I had come before the court, Milords.
That's what I'm saying.
Yes.
When an order is passed by respondent number 2,
Yes, Milords.
you could have gone to respondent number 1 and asked the same thing,
Please.
saying that my marriage is there. I will go out of Bangalore, out of this place after that.
But Milords, what happened? Earlier, Milords, this court had granted some relief, Milords. So they thought my counterpart forwarded me, Milords. So on that basis, Milords, I filed, Milords.
Rule 190.
At least for 10 days, Milords, if is some, at least for 10 or at least for the sake of marriage, Milords, I will leave to your lordship, Milords. Otherwise, the marriage will cause some hurdles, Milords. At page number 20 is the marriage card, Milords.
We should also know not to do these kind of things.
But there are no,
Settlement orders to be passed.
please. But Milords, there are only one case is there against me, Milords. Only one case. That too a new one, Milords. Hardly 2 months back, Milords, it was filed. There are no other cases, Milords.
This order is passed when?
End of January, Milords.
What is this, page number 12?
Please.
Page number 12.
Yes, Milords. Those are the new cases, Milords. One is connected with that only, Milords. The another case is connected with that one case.
Where is the impugned order?
Milords, at page number 18, Milords.
Page number?
18.
What are you doing from the last 1 month?
But Milords,
More than 1.5 months now.
but I had filed it, Milords, in first week of February, Milords.
Whose problem is that? Court's problem
No,
or
no,
your
I
problem?
am not telling, Milords. I am not telling that.
This is nothing but excuse. You know that court is not entertaining the petitions. I have dismissed so many petitions.
Yes.
One of your petitions also you appeared the other
Yes,
day.
yes.
You know.
Yes,
You stay till, you wait till today.
No, Milords.
You will come in the
No,
morning and
for-
say tomorrow is the marriage, so that court will pass. I will not pass it.
But Milords, that was not my intention. From 3 days, Milords, I had complied it. The matter was listed before ARG, my lords, so it got delayed. This was not my intention, my lords. I'm absolutely sorry if I am making it feel that way, my lords.
So from now onwards, this kind of application should be allowed.
This is my last matter, my lords. After that, I have not filed any extrement orders.
Are you giving any undertaking to the court that it is your last matter?
No, regarding this one, my lords.
The petitioner, I'll dispose of this matter.
Please.
I'll dispose of this matter, directing him to have an appropriate remedy till 10 days from today, not to give effect to this. The present writ petition is filed, seeking the following prayer. The second respondent has passed the order dated 12/1/2026 under section 56 of the Karnataka Police Act at the petition and directed the petitioner for externment from Haveri district to Kalburgi district for a period of 6 months. Further directed the police officials to ensure strict enforcement of the externment and authorizes arrest under section 61 of the Act if the petitioner re-enters Haveri district during the externment period, and limited permission is granted only for the petitioner to enter the district for attending pending court cases and only for the duration of the hearing date. It is submitted with the land counsel to the petitioner that the petitioner's marriage is scheduled tomorrow, that is on 20/2/2026. Hence, it is submitted that there may be stay of all further proceedings pursuant to the order passed by the second respondent. Land counsel appearing for the respondent, the learned AGA submits that the petition is not maintainable in view of section 459 59 of the Karnataka Police
Act.
Which wherein the petitioner has an alternative remedy of approaching the government.
Yes.
Government. Next part. This court, having heard so and so, this court had disposed of several writ petitions, directing them to avail the alternative remedy under section 59 of the Karnataka Police Code. However, considering the fact that the petitioner's marriage is scheduled tomorrow, this court is passing the following order. The writ petition is disposed of, directing the petitioner to avail the appropriate remedy available to him under section 59 of the Karnataka Police Act. Number 2, the respondents are directed not to give effect to this order for a period of 10 days, that is from today, that is 19th to 28th of February.
Please. Seek hand delivery. Hand delivery of the interim.
Hand delivery of.
Please.
Yes, Nick.
Orders seal number 2 by Lakshmikant Reddy, Sharana Basava, by Lakshmikant Reddy. Settle.
This matter has been settled, my lords, between the parties. Parties are present before this court.
The RFA. This petition is arising out of?
My lords, I have challenged the Annexure C, my lords. Annexure C,
Where is that?
page number 13, my lords,
Page number?
wherein we have challenged the joint memo, my lords. 13.
Both of you have filed a joint memo.
Yes,
Can
my
he
lords.
Come before this court by?
My lords, he is working as a peon, my lords, as of now, petitioner. And deduction of 10,000 is causing his service benefits, my lords, his retirement benefits. So I am seeking for the quashing of the joint memo, my lords, wherein both the parties have agreed to set aside the joint memo.
So did anybody compel you people to file this joint memo before the court?
No, my lords. But
Then
it's,
why did you file the joint memo? Why do you come before the court saying that again this joint memo?
my lords,
has been-
earlier there was a dispute between both the parties, my lords, husband and the wife.
Correct. How can that be questioned before this court? That I'm not able to understand. If both of you filed a joint memo, court has recorded it. Then why should that? You can ask the same court. Why did you come to the High Court? Every day I come across the writ petitions unknown to law. Anything, everything can be filed. Why parties to a memo, the both of you file a memo, court will record that. It's a joint memo recorded. You don't even question an order that is passed. Just a joint memo you will question before the court. Where is the order? Where is the order?
Order is not there, my lords.
Then what is to be interfered by this court?
My lords, there was the order by the family court, my lords, for the deduction of 10,000 rupees.
Where is that order? We have to set aside that order.
Yes, my lords.
Without setting aside that order, what is the benefit you will get?
My lords, it may be taken tomorrow, my lords. I will,
Get that order.
please, I will get that order, my lords.
I will take it up on Tuesday. On that day, you file that, that order of attachment.
Please,
And so that we'll set aside that order.
Please, my
And then
lords.
we'll record this.
please, please, my lords.
This is matter on Wednesday.
And 20.
Yes.
Password matters? For one?
Serial number?
This one serial number 2? Password matters serial number 2?
The addressing council is virtually present. The addressing council virtually present.
Yes.
Yes. Yeah.
Shivash.
Shuru?
My lord, so far as respondent number 1 is concerned, my lord, I was directed to take notice for the respondent number 1, Union of India. My lord, matter is allotted to another, my lord, standing council, MB Kanvi. My name may kindly be deleted and their name may kindly.
Delete the name of
Mrityunjay.
J.S. Alikari.
And respondent number 2 name, my lord, sir.
One second. And Mr. MB Kanvi's name may kindly be
So
shown.
and so is appearing for respondent
Number 1. I'm grateful, my lord.
Insofar as respondent number 2 is concerned, my lords, name of Gayatri SR may kindly be deleted and the name of Vijay Mali. I have
So even for R2 also delete the name of so and so and print the name of so and so. Yes.
may request 2 weeks time, my lords, to file a statement because they are claiming, my lords, the amount, my lords, which required to be scrutinized. 2 days after, before 2 days, my lords, some of the amount is released. For the instruction, my lords, I need 1 week or 2 weeks time, my lords. Matter may be listed in the first week of March.
9.
What is this? What is the lead in this? To release an amount of rupees
98 lakh
9,000 due to petition in terms of the tri-party agreement dated
Yes.
30/11. The respondent, which respondent you are? 2.
2.
Respondent 2 shall file his objection within 2 weeks or else the right to file the objection shall be forfeited.
Yes, wait.
Yes, post after 2 weeks. Yes, yes.
13 password matter? 13 Vinesham Kulkarni, SCGP.
That's, this is the order challenging selection of the committee members, my lords, under the category 2, my lords.
So yesterday one batch matter was, yesterday 230 matters, my lords, similar to this matter.
No, that is not similar to this. I said I will pass an order in this.
Please, my
FLI
lords.
matters are listed.
Yes.
Now, as per this notification, what he was questioning is
Please.
that the person is not competent to be appointed as a trustee.
Please, my lords.
He doesn't fall in that category. He has not enrolled. Who has to get instructions in this?
In fact, AAG want to appear in this case. AAG want to appear in this case, my lords.
Okay.
Yes, I'll call.
This is matter on Monday. By the time the instruction shall be on record.
Please, my lords.
Whether the respondent, an official respondent is eligible to be appointed as trustee in the light of the fact that he has not donated, he has not endowed anything in favor of the temple. Yes.
Please.
Pastor Matter serial number 33 is one. A. Shetty.
3, my lord, I am appearing for the petitioner.
Where is the response?
But in fact,
Kapil Ahmad.
Appear for respondent.
Where is that?
the dependents, my lord, the writ petition. Suit filed by the respondents, my lord, is for declaration that he is the owner of the property.
You are the defendant or the plaintiff?
Dependents.
Defendant.
Dependents.
Plaintiff has filed the suit for?
Suit for, my lord, declaration that, my lord, he is the owner of the property bearing number 399/7.
Declaration, what is IA?
My lord, the IA is, my lord, for injunction against the dependent, my lord, for not to interfere in his possession.
Not to?
Interfere in his alleged possession.
Granted.
My lord, it was not granted by the trial court. But the first appellate court, my lord, reversed it, my lord, on the ground that,
Come to that order of the first appellate.
or the, in fact, the lordship may kindly see the order. Before that, my lord, shall I, my lord, the trial court judgment order also, my lord, trial court, my lord, by considering all the aspects, my lord, English translation is also been produced. My lord, the several documents have been produced. So far as the suit is up, my lord, the
24.
24, 23, 50/2020, 24. Trial court judgment may kindly be seen, my lord. English translation, my lord, I have given. The trial court relied on, my lord, the fact that the dependents who are, my lord, claiming their rights, my lord, by virtue of a registered sale deed. My lord, in fact, the plaintiff, my lord,
Let us read the order of the trial court.
trial court, my lord. In fact. Page number. Para, my lord, and the reasons, my lord, it starts from 3. And in fact, what he is saying that, my lord, the description of the scheduled property mentioned as, my lord, the suit scheduled property is situated at Kallahalli Revenue Village, Harapanalli Taluk, Vijayanagara district, and is described as follows. 399/7, 25 total extent, my lord, is claiming is 25 acres. My lord, the certain land, my lord, it is shown that south by lands in survey number 186 and 389. My lord, it is shown that, my lord, the survey south is by lands in survey number 386 and 389. My lord, in fact, so far as the plaintiff is, the dependents are concerned, they are also, my lord, relying on, my lord, the sale deeds, my lord, which has been, my lord, considered by the first appellate court, my lord, in fact, page number 13. By the trial court at page number 13. The documents in support of the defense have produced by the dependents have produced the following documents in support of their documents. One is, my lord, the original sale deed dated 12/3/1996 Then my lord, the another sale deed is my lord 12/3/1993, and my lord, the third sale deed is my lord the 12/3/1993, and my lord, in fact, the on perusal of the above said document produced by the para 23, dependent, it's seen that the first dependent Lalya Naik has purchased the property bearing 399/1, measuring 2 acres, YN Mantesh, son from one YN Mantesh, son of Lingappa, to a registered sale deed. On perusal of the handwritten Pahani produced by the dependent, it is seen that said Pahani relates to the survey number 399/1, measuring 2 acres, and the name of the first dependent, Sri Lalya Naik, is entered therein. On perusal of another handwritten Pahani produced by the dependent, it is seen that the said Pahani relates to the survey number 399/1, measuring 5 acres, and the name of the fourth dependent, L. Shekhra Naik, is entered therein. On perusal of the another handwritten Pahani produced by the dependent, it is seen that said Pahani relates to the survey number so and so, 399/1, measuring 2 acres, and the name of the seventh dependent is read. Then Malad, pay para 24. As per the settled principle of law, any person, these are the documents Malad, which I want to rely upon. Malad, in fact, the copies Malad, it is there. Malad, it is there.
Where are you reading?
Malad, page number, Malad, it is para 22. Malad.
Yes.
Page number 20, page number 13. The documents which we have produced, Malad, it is Malad referred to by the
Come to paragraph 23.
23, Malad, 20.
23 is the documents of the.
Yes, 23 on perusal of the above document, Malad, document has been appreciated. Then 24, Malad, as per the settled principles of law, any person who approaches the court seeking the relief of injunction against another person must prove that he has a prima facie case, that balance of convenience lies in his favor, and if the injunction is not granted in his favor, he will suffer irreparable loss and injury which cannot be compensated. For the purpose of deciding the above said IA number 2 filed by the plaintiff in the present suit, I am placed reliance on the following decided judgment. So, Malad, then.
Last para.
Yes. Considering the principles laid down in the decided cases, and upon examining the documents produced by the plaintiff to establish that they have prima facie case in the suit, as well as the averments made by the plaintiff and written statement, it appears prima facie that both the plaintiff and defendants have purchased these lands in this suit survey number 399. Though both the plaintiffs and the defendant have produced the original sale deed relating to their respective lands, since prima facie, if it appears that the lands of both the parties fall within the same survey number, as at this stage, in order to determine whether the defendants are interfering with the plaintiff's possession and enjoyment or not, it is necessary to conduct a full trial of both the parties. Therefore, at this stage, although the plaintiffs have produced the original sale deed and Pahani records to show that they are in possession of the suit scheduled property, they have not produced any document to establish that the defendants are interfering with the said property. On the other hand, it is seen that the defendants have lodged a complaint alleging that the plaintiff number 1 and others are interfering with their property and causing obstruction. Malad, the appellate court order. Malad, in fact, Malad, your lordship may kindly see the even Malad, the recital in the sale deed. Clear, Malad.
Finding of the trial court is both of you have purchased.
Purchased Malad out of Malad the same property. 399, it is Malad larger extent, Malad 397. Total Malad 397 acres. Out of that, Malad. Yes, Malad. In fact. Malad, page number 19, it starts Malad the judgment. Malad, then Malad the reasons Malad, it starts at page number 28. And point number 1, Malad, framed by the court, whether the appellant's original plaintiff show that the order passed by the learned senior civil judge and JMF on IA number 2 dated 8/2/2024, rejecting the grant of temporary injunction against the defendant is either incorrect or illegal or perverse to law, and thereby calls the interference of this court as required under 43 Rule 1R of CPC. Then Malad is held that affirmative. The suit.
Where is the reasoning by the court?
The reasoning, Malad, at page number
18, page 18,
14.1
onwards. Reasoning starts from 14.1.
14A, Malad, in fact. As per this sale deed, it can be seen that land of the dependent is located towards the eastern side of the land of the dependent number 4. Land of dependent number 7 is located towards the northern side of the dependent number 4. And the lands purchased by the dependent number 1 and 47 is located in the center of the main land, bearing survey number 399, totally measuring 397 acres 52 cents. Thus, as per the sale deed of the plaintiff and the dependent, it can be said that land of the plaintiff is distinct than the lands of the dependent number 1, 4, and 7, and the lands of the plaintiff is located towards the southern side of the main land, bearing survey number 399, totally measuring 397 acres 57 cents, whereas the lands of the dependent number 1, 4, and 7 is located in the center of the mainland. Malad, in fact, this is exactly, Malad, the dispute between the parties. In order to, Malad, your lordship may kindly see, the respective sale deeds of the parties, Malad, which is not being correctly referred by the first appellate court. Malad, by holding that, by relying on, Malad, the recitals in the sale deed of the first dependent, the plaintiff, Malad, this is findings has been recorded. Malad, whether that findings is correct, Malad, in view of the fact that what has been purchased by the plaintiff, Malad, is altogether a different property. Malad, in fact, his vendor's sale deed refers to, Malad, others.
Yes. My lord, kindly see, my lord, statement of
And in
objections.
fact, Malad, this honorable court,
My-
Malad, at the time of Malad admitting the matter, directed, Malad, both the parties to maintain status.
Please.
Status quo order is in force, even till this story. What my respectful submission is that let that order be continued till the disposal of the suit, and Malad, matter may be directed to be disposed of at earliest. That was the first submission made by me on the other day.
May I take your lordships through the statement of objections, page 19, your lordship may kindly see. Page 19 is, my lord, the property, the entire survey number 399 is, my lord, 400 acres. The property purchased by plaintiff is in the southern side, towards the southern side. The property of the defendant is in the northern side. They are not adjoining. They are totally different survey number. There are several other properties coming in between the plaintiff's property and yes, page 19, your lordship. Page 19 of my statement of objections. That is precisely why, my lord, the boundaries are different, survey numbers are different, extent is different, totally unrelated. Page 19, your lordship may kindly see. This is a survey map. My lord, your lordship may kindly see this 399.5 one strip, my lord, it is there.
399/5.
Yes, this is my land.
Where is the petitioner's land?
This here, my lord. Here in the middle portion it is there. Survey number is different. 399/1, 2, 3, 4.
Well, they are adjacent to the other.
They are adjacent to the other, my lord. My property is 399/5. There is a sale deed. There is a separate RTC. There is.
That is a whole dispute.
Yes.
That is a whole dispute.
Yes.
You are all, both are adjacent lands.
No, no. Your lordship, 399/1, what they have purchased, it is joint. It is 399/1, 2, 3, 4. They have not subdivided the portions. Now what they are doing is, they are, my lord, trying to interfere with my possession in 399/5. I am only restricting my prayer only with respect to this portion of the property. What they have purchased is in the adjoining 399/1 in the northern portion. They are not adjoining to the each other. The boundaries are totally different. Boundaries of the plaintiff's schedule.
You are showing one property here, on
Yes.
the whole one. You say this property belongs to the plaintiff, and your 399/5 is next to that.
Yes.
And in
One
fact,
minute.
his vendor's sale deed is
Your lordship may kindly see.
different. His
Their sale
vendor's
deed, your
sale
lordship
deed.
may kindly see their sale deed. My sale deed is with respect to this portion. In the entire map, my lord, there is no demarcation as to where exactly is their property. It is entire 399 acres, 367 acres is the entire larger extent. Out of this, my lord, I have purchased only 25 acres of the land. My land is.
What is your extent of land?
Malad, it is, Malad,
I'm only
different
restricting
extent.
prayer to
Malad,
my
it
land.
has- I have purchased, my vendor has purchased in the year 1920.
Common vendor, my lord,
80.
common vendor.
1980.
What is your extent?
The different extent, 5 acres, 3 acres, and 2 acres.
So where is your 5 acres?
Malad, that's exactly, Malad, what I am saying that this land, Malad, is.
You are exactly here, but
Malad,
exactly not here.
Your lordship may kindly see. He is saying that the property which belongs to us, Malad, he is claiming that portion as his own land, which cannot be in view of the reasons that his vendor sale deed.
Page 19.
Yes.
Come to page 19 of the objections.
19 of objections.
The objections filed by him.
Yes. 19, my lord. This is exactly, my lord, the difference arose because, my lord, your lordship may kindly see, this has been prepared in the, my lord, in the year, my lord, 2024, my lord, at the time of execution of the sale deed. And based on this, my lord, this record, my lord, which is,
Tell the court where is your land.
my lord, my land is, my lord, in fact, it is, my lord, this property, my lord, it is not the, my lord, this is shown as wrong. This is shown as, in fact, these lands, my lord, is situated in the portion where my lands are, my lord, it is shown as his land. That is not correct. In fact, that's, I want to bring your lordship's kind attention. My lord, his vendor sale deed is also, my lord, I want to rely upon. His, my lord, southern portion of land, the southern boundary of his vendor's, my lord, property has been shown as 385 and 386, whereas my property has been shown as 386 and 385. My lord, now the, my lord, your lordship may kindly see the property which is now they are showing. He is showing altogether in the middle of the road, middle of, my lord, the property, which it could not be. That's why, my lord, the trial court, my lord, held that these matters are required to be, my lord, looked into only after the full-fledged trial. Whether the, my lord, the,
First of all, you are not able to say
yes,
where is, how the lands of the petitioner and the respondent.
my lord, it is, my lord, in fact, this property, my lord, is shown that, my lord, is, my lord, the property which is now, it is shown that 397/7. My lord, it shows that, my lord, it is the southern boundary is shown as, my lord, 852 or 490. Whereas his vendor's title deed, it is shown that 385 and 380, my lord, 389. And my sale deed as well as, my lord, the sale deed of the other side. My vendor's sale deed also I have produced. My lord, it tallies with the,
When did you purchase?
my lord, I have purchased in the year 1993. There was no dispute as such. He created a document in the year 2023, and thereafter, my lord, trying to encroach upon this land. At that time, we lodged a complaint.
Where is vendors?
My lord, his vendor's sale deed at page number 43. 3, my lord. But it starts from, my lord, 41.
What is the survey number?
Page number 45.
Yes.
Page number 45, my lord. It is shown that, my lord, lordship may kindly see the southern boundary has been shown as 385 and 386, his property. Now, my lord, what he is trying to establish is that our property.
Where is 385?
My lord, in fact,
Correct submission.
no. No, that's why his property is not here. He wants to make a claim in a property which is belonging to us by creating a document styled as, my lord, this is page number 19, which is, my lord, without.
Where is his sale deed?
My lord, his sale deed, my lord, his sale deed at page number, my lord, I have produced it. I have also produced it. Page number 29, my lord. His sale deed. Kindly see his, my lord, the sale deed of his vendor as well as his sale deed. There is variation. His, my lord, the boundary has been shown at page number 39. Altogether a different. My lord, he shows that, my lord, 389. His vendor's title deed, my lord, it shows that 385.
85 and 86.
Yes, 385 and 386. Now he shows that 386 and 389. 389, my lord, that's why, my lord, how he want to, my lord, take undue advantage of situation. And in the guise of, my lord, purchasing a larger extent, he want to, my lord, dispose
My
it.
learned friend shows, my lord, where exactly is his property. I will not interfere his property.
No, before he submitting
Yes.
something, why the boundaries of your vendor sale deed and your sale deed is all not one and the same?
My lord, my sale deed is at page 39, my lord, this,
Yes, I'm looking at it.
yes. My lord, this is correct in terms of the map, my lord. This matches with the map. Your lordship may kindly see it matches with the map.
Map,
Yes.
it should match with your vendor's sale deed.
Yes. My vendor sale deed is also, my lord, don't have me, he has produced my vendor sale deed.
45.
Yes. Page 45 will leave.
That is the boundaries of the property.
Southern side mechanism.
385 and 386.
My lord, 385 and 386, same is my sale deed also. My sale deed also is on the Dakshin
Where is
Kade 385.
385 in your sale deed?
Yes.
Where is 385?
My lord, 385 illa, 386 is there. 386 and 389 is there. My lord, your lordship may kindly appreciate the map that is produced along with the,
Forget about the map.
yes,
You purchase a property from so and so.
yes.
Your property will have the same boundaries or it will
Yes,
have
it has to
different
have same boundaries.
Then why it is not
Yes.
having?
Lord, this, my vendor sale deed I have to verify, my lord, because,
It is there?
yes, my lord. I will verify with my party tomorrow.
No tomorrow. This is matter in the month of March. Yes, next.
Number 38, for submit.
But the interim order may kindly be.
Intermodal granted is extended.
Lord Sadiq Kanvi,
The petitioners are the office bearers of work institution, my lords.
Dharwad,
And during their subsistence of a term, they have been removed, my lords. And in their place, the respondent number 4 to 7 have been appointed by the additional chief executive officer, my lords. He don't have a power to appoint or remove the office bearers as such as Mutwalli, my lords. That is barred under section 32, my lords. And he says that in his impugned order that the power was delegated to him. My lords, the power cannot be delegated. That is barred under section 27 of the
Yes,
CPC.
who appears for the respondent? 1 and 2.
My lord,
Dear Lord,
that, my lord, what their contention is that, my lord, that power under section 36(2) could not be, my lord, delegated to, my lord, in favor of, my lord, the additional chief executive officer. My lord, even if that on that count, my lord, it is, my lord, even if it is set aside, even if it is set aside on that count, but my respectful submission that the question of, my lord, he being acting as a Mutawalli would not arise. It is, my lord, it is a
He is questioning that order.
that order, my
That
lord.
order will go.
Yes,
Whatever
my lord, whatever, my lord, whatever permissible
consequences-
under the law, my lord, to the work board to take action, my lord, that may be reserved.
May I make a what action can be taken, my lords? Only 4 months term is over, my lords. I have tenure till only 8 months was subsisting. When it is going to end in the month, 6th July 2026, in the month of 6th July, my lords.
Whatever it is, now you say that the action of the respondent is not in consonance with the provisions of the work.
Yes, my lords.
Now this order we will set aside. Whatever is available to the work, they will take the action, the board.
Yes, after that, my lords, and I will be the acting chief.
That we don't have to say. You are only concerned with
Yes,
this order. We will
this
set
impugned
aside.
order, my lords.
After that, whatever should follow will follow.
Yes, yes, my lords.
I want to make a submission. In fact, that is incorrect, my lord. This is the copy of the resolution passed by the board. I secured it, my lords. The order states that the matter was placed before the board wide subject number 12(2). My lords may kindly take the.
So he is on the point about the authority who has.
Exactly, my lord. Now, my learned friend's argument is under section 32, the board only has authority to remove, my lord, or appoint.
It has passed.
No, I am placing on record the resolution passed by it. In fact, it was directed. No, but I am the present managing committee. I got, yes, yes.
For the work board to say whether they have followed the.
No, this is the order. I'll share it with him also. Let him take it. But the whole argument is that, my lord, it is only under delegated. My lords may kindly, only for a moment, impugned order may kindly be seen. Only
I
for,
can only hear this from him, not from you.
my lords, that because I am the, my lord, subsequent office bearers.
That's why I specifically said he should get instruction.
Since my lord,
Far as
my lords may
this
kindly
order
see.
passed
Only
by
my
the
lord,
board
for a
has not
moment,
been satisfied.
page 36.
This order passed by the board has not been sought for. He has not seeking for
Please
any.
don't make those kind of submissions, Mr. Counsel. You have to make some responsible submission before the court.
No, no,
When
only-
we have asked
No,
specifically,
no, whether
what is, his contention is very specific. You have to answer to that. So without even looking at, without even getting from instructions to the work board,
Resolution. For a moment, page number 36 may kindly be seen. My lord. Page number 36 may kindly be seen. I'll clarify the entire my lord, gamut of issues, my lord.
let him
Page,
clarify. I have to hear him.
what happened?
My lord, it is the subsequently resolution was passed on 16/9.
Don't read the papers in the court.
16/9/2000.
Is this matter? Next Thursday, by the time the learned counsel for the respondent shall get specific instructions before and place the material before the court to show whether the whether the orders passed by the chief executive.
Additional executive officer.
Chief executive officer are sustainable in the light of section 30,
27 and 32.
27 and 32 of the act. Yes.
Much obliged.
My lords may hear my senior only words on that. Before passing of this order, the resolution was passed.
You
That
should
has
say
been
that.
cited.
That's not the you. You're just a respondent.
No, but
He
true,
is
true,
the
my lords.
authority
I
who
fully
has done
agree.
it.
Only thing is, my lord, if the submission that is accepted by setting aside the impugned order, then my lord, it will cause my lord injury to me. That's why my lord, I was making that submission.
Yes.
Please.
Number 42. Sponsor matter 42.
Is 42.
Tunjay Salikeri.
Petitioners have called in question a compromise decree in a Lok Adalat, my lords. These petitioners filed a suit for partition and separate possession. Maligwad appears.
My senior's name may kindly be deleted. The Santosh Maligwad
Santosh Maligwad.
has entered appearance, Mulots.
Delete the name of Mr. Mallikarjun Swami Nirima for R2. Where is the other counsel?
He was here in the previous matters.
You have an interim order in your favor?
I have an interim order in my favor.
This is matter in the month of March. Interim order earlier granted is extended till then. Yes, next.
Grateful, my lord.
Number 43. 43. Tunjay Tata Bangi. PM Shilwan.
Judgment debtors writ petition. Lord, suit for specific performance was instituted, Lord, in the year 1998. It was,
When was the stay granted?
there is no interim order.
No interim order.
Lord, in the present writ petition, there is an interim order.
That's what I'm saying.
Yes, Lord, there is an interim order.
When was it granted?
Lord, at the initial stage itself, Lord, in
That was right
2020.
from 22 is pending.
Yes, Lord.
This is a matter on Monday. Yes, next.
My Lord, may I request interim order may kindly be extended.
Interim order earlier granted is extended. Next. Next.
Seal number 44. Password matter. Liability.
This 44. How many other passwords are there after this? 44.
Appearing for respondent number 4 in serial number 44, my lord.
Apart from the password. Except this, all other passwords will come on Monday.
My lord. Serial number 65. Serial number 65. Password matter. We sought stay in this matter, my lord. It's a company appeal challenging liability
Which
on
one?
the ground of no DL, my lord.
60?
65, my lord.
When was the accident?
My lord, year of accident is 15/2/2024, my lord.
When was the amendment?
2020, my lord.
2020.
20. 1/4/2020.
1/4?
2020.
It is submitted that there is no driving license. In spite of the same, the liability is fastened on the insurance company. Considering the same, they shall be stay of all further proceedings on the condition that the insurance company shall deposit 50% of the amount Yes, next.
Here or before the tribunal?
But he is pressing for it. List on Monday 15. You can't, stress on that saying that the matter has to be taken some other time. They have their own agency. You have the interim order stay in your favor, isn't it? So they have every right to say that the matter has to be heard.
I request your lordship, the lord, please have the friendly who
This is the matter on 3rd March. Yes, next.
My lord, serial number 48.
Yes,
Serial number 48.
yes.
Serial number 48, we have filed an application for vacating of stay. The election was conducted last year. Their right to franchise has been upheld.
Yes, next.
48, 48.
Monday.
Lord, 69, my lord.
My lord, it's 48.
It's
Interim
past
order may
before.
be extended.
All the password matters, number.
May I request for 54, Lordship?
Seal number 44. Password matter seal number 44.
Please, appearing for petitioner.
44, you will hear it. Apart from 44, I am saying the other passed overs you call.
Serial number 40. 44.
I appear for petitioner in serial number 45, Your Ladyship. Ladyship, I have it on Monday. The matter pertains to refund of EMD.
Yes.
Seal number 46.
Please temper tomorrow.
For the implementing applicant minutes in this matter, will be taken up on Tuesday minutes.
Yes, Tuesday.
Please, great.
54. 46.
Yes.
Seal number 53. 53.
Either Monday or Wednesday, Your Ladyship.
Yes, Monday.
Please.
54 either on Saturday or Wednesday, Lordship. 54, I am for petitioner. Saturday or Wednesday, Lordship.
Tuesday, 24th, 54.
My lord, serial number 40.
54.
Interim order may be extended.
Saturday.
24.
Please.
24.
Serial number 54 on
24.
24th minutes.
20.
24th, Tuesday.
54.
Kindly have it on 25th, Lordship. I may not be available on that day, Lordship. On 25th.
24.
Yes, next.
54. 24 2. Seal number 55.
Lords, I have instructions to file objections to the vacating application filed by the respondents. Weeks
Filed
accommodation
application
to
for
file.
vacating
Lords.
interim order. The recovery due to the bank order has been stalled in your,
No, I'm not hearing.
That's next week.
any date in the next week if it can be.
Tuesday.
Interim order may kindly be extended.
Order only granted is extended.
Obliged.
Okay, Tuesday.
Seal number 56.
I am for the petitioner.
Monday.
Have it on Monday.
Monday.
Yes, Monday.
Interim order to vacate.
Yes.
Seal number 58.
My lord, 58, my lord.
58. Senior.
Mr. Jay Kumar Patil sir is in online. my lord.
58.
No time to hear now. Monday.
Please, my lord.
58.
Monday. 58.
Monday, my lords, please.
23. 59.
My lords, may I request for Monday, my lords? Monday, my lords. It's a case of death, my lord.
Yes, next.
59
Please,
Monday. 23 2. 63. Password matter 63.
Please, Lords.
Owner's appeal, my lord, seeking stay, my lord. I've probably wrongly been implicated to this case. There is no FIR being named in my name. My vehicle is not. Please, my lord.
50%.
It's a poor family, my lord. 30% may be gone.
Submitted an appeal filed by the owner of the vehicle. Why have you not contested before the court?
Please, ma'am.
Why you have not contested before the court?
No, contested, ma'am. I have denied the averments, my lords.
Huh?
I have denied the averments. I have contested in the tribunal. The
On
police.
what ground the owner is before the court? Before this court, on what ground you are?
I've wrongly been implicated. My name, neither my name is taken in the FIR or charge sheet, nor my vehicle is named.
It is submitted that the vehicle of the petition is not, appellant is not involved. And in spite of this, bringing the same to the notice of the court, court has passed the order Consider the same, 30%, 4 weeks.
30%.
Yes.
Please,
Stay.
much obliged. Much obliged.
Please call that 40.
Serial number 64, password matter, Kulkarni.
My lords, appeal against rejecting the TI, my lords.
Tomorrow.
Please, my lords.
Serial number 69, please.
For respondents, my apology, I was not there. That's the reason why. Leonard Friend said he has no objection to allow the petition. That's the reason why it was
I
passed.
filed
Tomorrow.
tomorrow.
Please.
Yes.
Tomorrow.
My lords, serial number 48, my lords. Interim order may kindly be
In
extended.
all the matters, wherever there are interim orders,
And
they
it is-
will extend it.
It is covered by, it is covered by, my lords, by Sham Prasad judgment. 48, serial number 48.
Interim order extension.
Yes.
44.
Serial number 44 bar 44.1, my lord.
I have a
The-
submission in 44, my lord. Appearing for respondent number 4, in the morning they have filed a withdrawal memo, and all the connected matters are for the same tender. And they had submitted that it is infructuous because the tender period is over, my lord. All the
That is,
connected matters
in
is
the
for the
morning-
same tender and the
morning
tender
session,
period
that
is
was-
over.
Order being passed.
My
is-
lord, we have filed it in the registry itself. It was not filed today, my lord. Since the tender period is already completed, the writ petition, we have withdrawn it as infructuous. my-
What about 44.1? That
No,
is.
I-
Please,
in one.
please,
I'm submitting.
we are submitting regarding.
Give 44.1.
44.1, my lord. They have challenged, your lordship may kindly peruse the order passed by the honorable court dated 12/6/2024.
Yes.
12/6/2024.
44.
Please. 44 point WP 1023.
What is the relief sought?
It is dated 12/6/2024. 12/6. May I read it?
Impugned order is at Annexure J.
Quashing the impugned order dated, issued
Yes.
by respondent number 3. What is that?
Order dated 12/6/2024.
10/4/2024.
Please,
12/6, please, madam.
Where is 10/4/2024?
page 30 to Annexure J, my lord.
Page 35.
No, no,
32.
order of this honorable court. I am
Huh?
submitting order sheet, order of this honorable court, madam. Order of this honorable court
I'm
dated,
looking at what is the prayer he is seeking.
prayer is to quash annexure J. So this honorable court has considered that annexure J is only a show cause notice.
1 minute time to understand, I'll be able to understand.
Yes. The respondent number 2,
Where is the writ petition? All or attached
connected
to
matters.
this? Where is the writ petition? Is this a writ petition?
writ petition number
102.
102312 of 2024.
Please.
How can the memo of citations be on the top?
Order sheet, court office.
I don't think this is a writ petition. And there are no material. Sure. Which page is into impugned order?
Page 32, my lord.
30?
2.
Dated 10/4/2024.
Please, my lord.
What is this order?
My lord, respondent number 2 has passed an order directing the petitioner to pay 1,07,26,000 dues, my lord.
How can it become infectious?
No, no, this is, my respect, this is not an order. It is only a notice. It is only a show cause notice. In the order, it is very specifically stated that final order will be passed with due consultation with the
Whatsoever reason this writ petition is pending from 2024. So we have to pass some order.
Yes, yes, my submission is that, my lord, this is a notice, it is not a final order. Let them file the objections.
That is on Monday.
No, I consider that, my lord, let them file the objection and we will pass appropriate orders. That is my submission.
If that
Only a
case,
show
my
cause
lord, if
notice.
they are saying that that is only the notice, we may be provided opportunity of hearing
Definitely.
and.
That is my submission.
Please,
We'll give all the,
please.
let him file the objections. We will give all the opportunities.
This matter 44.1 disposed of, and I'll pass orders.
Even next matter also same, my lord.
Observing that only it may.
Yes, yes, that is
You
considered
appear
by
for
this.
which respondent?
Sorry, my lord.
Respondent number?
Respondent number 2. I am for wakalat for respondent number 1.
Yes, 44.1. And what about 44.2?
Same, that is also infractious. It is in respect of a notice demanding some amount and raising.
Like in the other one.
Yes, raising the objection.
Yes,
He has
both-
not some
both
security.
disposed of.
That is also over. It
Yes,
has become
yes.
infraction.
Next. Done?
Much obliged. Because
Please.
when we have this, we could not call the tender. That was our difficulty.
What about this 53? Fifty-three is there.
53 is Monday.
Monday. Yes.
Infractious ಅಂತ ಕೇಳಿದಾರಲ್ಲ.
ಡಿಸ್ಪೋಸ್ಡ್ ಅದು ಒಂದೇದು ಎರಡನೇದಲ್ಲ ಇದು
ಆರ್ಡರ್ದೊಳಗೆ ಇದೆ ರೀ. ಕೊಟ್ಟಿಲ್ಲ.